All right, so we have now completed the entire Casey Anthony trial. We watched every single day of witness testimony. We had to speed it up a little bit because, we gotta get through the trial. It's a long trial, and a lot of parts you can just speed up a little bit. So we did that, and now we have reached the top. We've reached the point where we're going to play for you the closing arguments in Casey Anthony's trial. And I got to say that this has been a very eye-opening experience, going through this old trial that happened in 2011. And I think a lot of people were relying on a lot of news reports from the time and the media. And seeing it actually play out in front of our own eyes gives you a little bit of a different perspective on the trial. So let's see how both sides summarize the case and make their final plea to the jury. And then most likely what I'm going to be doing is having a separate video where I react to and analyze kind of the entire trial and give you my thoughts about whether the jury got it right, and talk about the prosecution, how they presented their case and how the defense presented their case, and ultimately why we got the verdict that we did, that we already know about. So without any further ado, let's pull up the closing arguments. Here we go.
I want to be the first, and I know I will not be the last, to thank you for the time that you've given us in this case. We've taken you away from your families, from your lives for the last 6 weeks, and all of us appreciate the sacrifice that you've made.
I'm going to slow it down.
I am happy to say that we came in on the low end of our estimate. We said 6 to 8, and it's been 6. And our job here is virtually done, and your work is about to start. The video, the CD. It's easy to be a parent sometimes. It's easy to be a parent when you're playing with your children. It's easy to be a parent when children are a joy and when children are fun. But we all know that being a parent is so much more than just playing with your children. Being a parent is about sacrifice. Being a parent is about sacrificing your time, about sacrificing your love, and about sacrificing your dreams and sacrificing your life. When you have a child, that child becomes your life. This case is about the clash between that responsibility and the expectations that go with it and the life that Casey Anthony wanted to have. When Kaylee was born, Casey was saddled with expectations and responsibilities. Those expectations came not only from society, but from her parents. The expectation is that she would care for her daughter with the support of her parents, that she would work hard and help support her daughter. Her response to those new responsibilities, as the evidence has shown in this case, was to lie. The first expectation of her parents, shortly after Kaylee's birth, was that she would work, that she would help support her daughter, along with the generous contributions of her parents. For whatever reason, her solution was to lie. She told her parents initially that she went back to the same job that she'd had before Kaylee was born, working at Universal Studios for a subsidiary company, taking photographs, a daytime job. And her parents accepted that. They believed that. They both worked during the day, and it appeared that that's what she was doing. The significance of what I'm about to tell you isn't simply that Casey Anthony lies. It's the pattern and the reason that she lies that is important in this case. Because what you'll see and what I'm going to tell you and what you've heard in this case is that when Casey is faced with a problem, her solution is to change her lie, to modify it. Casey is very bright. You can't take any of that away from her. She's very smart, and her lies are very detailed. But what you find throughout this case is this persistent pattern. When Casey wants to do what Casey wants to do, Casey finds a way. So first she tells her parents, I'm working during the day at Universal Studios. That sounds fine. It sounds very plausible. But the problem is that when you're working and you have a child, you have someone has to take care of the child. So the obvious question is, who's taking care of Kaylee? The solution? Make up a lie. So Casey makes up Zanny. So for almost 2 years, Casey Anthony pretends to have a job and pretends to have a nanny to take care of Kaylee while she's at work. And everything seems fine. But that creates a problem. The problem is that Casey's with Kaylee 24/7. She's with Kaylee every day and every night. Because when her parents think she's at work, she's not. She's with Kaylee. And what kind of life is that? So Casey solves the problem. The solution is a new job. A job as an event coordinator. A job with flexible hours. A job where sometimes she has to work at night. Perfect solution. If she wants to go out at night, if she wants to hang out with her friends, if she wants to see her boyfriend, she simply says, I have to work, and drops Kaylee off with her mother. And her mother is happy to help, happy to watch Kaylee. And that works for a while. Works well for a while. Everything's good. Casey can do what she wants, have the life that she wants, have the support of her parents, have Kaylee when it's fun, and when it's not, she can leave Kaylee with her mom. Everything works great. But then she meets Ricardo Morales, somebody that she feels she may actually have a relationship with, who accepts Kaylee as part of that relationship. But that creates a problem. How do you include Kaylee in the relationship without letting mom know that the whole thing is a lie? So you create a new solution. Oh, Zanny will take her overnight. We spend the night there. So in the spring of 2008, 3 or 4 nights a week, Casey and Kaylee stay at Zanny's. Another creation in this case. When in fact they're staying at Ricardo's house. And it works perfectly. It's great. Mom and dad think that I'm working late, and so Kaylee is with Zanny, and it makes perfect sense for me to spend the night, and I can spend the night instead with my boyfriend. It works perfectly. It's great. But Ricardo decides that he really doesn't want a serious relationship. So this playing house isn't working anymore. Then we get into April and May of 2008, and this is where the problem starts, because the solutions of the lies are no longer giving Casey what she wants. It's not giving her the freedom that she wants. Remember from the testimony of Amy Huizenga, her friend, the friend of Ricardo and friend of hers, that friend through that period of April, May, and June of 2008, that Cindy is resisting. The excuse isn't working anymore. Cindy isn't allowing Casey to go out and do what she wants and babysit Kaylee. There's a tension there. The freedom that Casey wants just isn't there anymore, and she can't come up with a story to make it happen. But that's what she wants. Her parents are getting suspicious. Remember the story from Mr. Anthony about the Sports Authority job? That's in early 2008. George is getting suspicious. And George is trying to find out what's really going on. But George is being told to stay out of it. If you'll read George's suicide letter, it actually says in there, at one point I think on the 3rd page, he says, I've tried for months, in fact over a year, and I was told to stop being negative. George is trying to get beneath the layer of lies. At least this is the Sports Authority issue, but he's being told to stay out of it. Stop being negative. And Casey's lies continue. But there's a problem. The only way Casey's lies work is if Kaylee isn't talking. Kaylee's 2.5, almost 3. She's starting to become verbal. She's starting to talk. Kaylee is not going to cooperate. She can't. She doesn't know enough to lie. At some point, Kaylee is going to say something. Someone's going to ask her about Zanny, and she's going to say, who? Someone's going to ask her, did you have a good time at Zanny's? And she's going to say, no, Tony. It just can't keep going. Casey meets Tony. Tony has this life. He's free. He's a club promoter. He's out there at night with the loud music and dancing, and it's a great free life. With Tony, she can do whatever she wants. I believe the testimony was on June the 6th, and on June the 13th, they have the nightclub fusion, and it's fantastic. Shot girls, music, dancing, young people doing what young people are supposed to do. And I want to say that clearly. There's nothing wrong with young people being young people. There's nothing with young people drinking and dancing and having fun. There's nothing wrong with that. But that's not the life that Casey has, because Casey is a mom. And that gives her responsibility, whether she likes it or not. But that life is so much what she wants. During the week of June 2nd through June 9th, in fact, Casey has a chance to truly embrace that life because Cindy was on vacation that whole week. and spent most of it with Kaylee. Remember, she talked about how wonderful it was spending that week with her granddaughter. So that whole week, Casey is essentially free. She has a taste of that freedom. She doesn't have to lie to get around it. She's free. And it is fantastic. So she has a choice. A life tethered to a child, or a life free to be 22. You might ask yourselves, well, why not just leave Kaylee with Cindy? Why not just give Cindy custody and walk away? Because based on the evidence you've heard in this case, Cindy would never permit Casey to walk away from Kaylee. Cindy wanted her daughter to be a mom and to act like a mom. And there is no way that Cindy Anthony would have ever permitted Casey to walk away. So those were Casey's choices. The life that she wanted or the life that she had. And as hard as it is for anyone to imagine, she had to choose between sacrificing two things. The first was her dreams and the life she wanted. And the second was her child. And we submit to you the evidence in this case that shows that the choice she made was her child. On June the 16th of 2008, Casey left the house, pretended to leave the house, with Kaylee, and used the tried and true Ricardo excuse. I got to work late. We're both going to spend the night at Sandy's. An excuse she hadn't used based on the evidence since she was with Ricardo. Sounded plausible. It's something they've done before. Didn't seem strange. She used that excuse both to her father when she left and also to her mother, I believe, in a phone call later that day, or perhaps even the night before. What this tells us about her plan is this. She wasn't going to stay at Tony's with Kaylee because that was not their relationship. So on that morning, Casey knew she would not be staying at that house, and that neither would Kaylee, because she knew that that night she would be in the arms of her boyfriend and that Kaylee would be dead. So for June 16th, it was the same old excuse, the tried and true. I'm staying at Zanny's. I got to work late. Made perfect sense. She actually spent the night at Tony's. June 17th, well, they'd done it a couple days before, so she knew her mom would accept one more day of this spending the night at Zanny's problem. So she said, 17th, we're spending the night at Zanny's again. And Cindy accepted that. But by June 18th, Casey knew that Cindy would no longer accept that excuse. It didn't make sense that they would be staying at Zanny's 3 nights in a row. They never had done it before. It wouldn't make any sense. So Casey had to change the lie, had to add an element to explain the continued absence. So on June 18th, Casey adds the conference in Tampa wrinkle. Says, well, I've got this conference at this hotel in Tampa, so I'm going to take Kaylee with me, along with Zanny, the babysitter, to this conference in Tampa. But it's not just that. She adds another element, an element that would appeal to Cindy, which is, oh, by the way, there's going to be another mother there with a child the same age. What a great time Kaylee will have. You see, every time you add to the lie, you add to the lie for a reason. Casey's very smart. Casey knows how her mother thinks. She knows she needs to add. So she adds the element of an out-of-town trip to a fun place and another child to play with. A great story. Mom will absolutely buy it. It'll keep Mom off my back for at least a couple more days. While in fact, Casey is staying with her boyfriend, Tony. And sadly, Kaylee is in all likelihood in the trunk, dead and decomposed. Put out of Casey's mind as easily as she puts out the truth. Remember, on the 17th, the 18th is the day. On the 17th, Casey's car is seen backed in to the driveway of the Anthony home when no one is home. I believe it's that day or the next day, the evidence showed, Casey goes to the next door neighbor and borrows a shovel. And I would submit to you that the reason to borrow a shovel under those circumstances is because she thought briefly about burying Kaylee in the backyard, just like they buried their pets. Apparently that was too much work for her, so she decided instead to just throw in a swamp. Anyway, so the story on the 18th is pretty good. It buys her a couple more days. So through the 18th and the 19th, she continues to tell her mother, we're having a wonderful time. We're at this conference over in Tampa. She, on the 20th, actually extends it to add Busch Gardens. It's going to be great. Going to have fun. Kaylee's going to go to Busch Gardens with these other children. They're going to have a wonderful time, and Zanny's going to watch them while at my conference. So it satisfies everything. Cindy's sad that her grandchild is not with her, but she's happy that this that Kaylee's having such a wonderful time at the theme parks. Tells Cindy that they'll be back on Saturday the 21st. 21st, she tells Cindy again that the conference is still going on, that they're still at Busch Gardens in Tampa with Annie, Juliette Lewis, and Annabelle, the fictional people. Now, counsel in questioning has suggested that these people are somehow imaginary in the sense of being not a deliberate fabrication. I would submit to you that the fact that they are deliberate fabrication is established by the fact that while Casey is telling Cindy that she and Kaylee and everybody else are at Busch Gardens, she tells another witness, Maria Kish, who you heard from, that Kaylee is with the nanny at the beach. Because obviously the friend doesn't need to have the story, and she can't very well tell the friend, by the way, I'm in Tampa, because she's standing in front of her. Again, Casey's lies fit the audience and the necessities of that audience. By Sunday the 22nd, clearly they should be back from this conference by now. But on the 22nd, Cindy is told, oh, well, the conference ran late the day before. They were going to plan on coming back, but they figured they would just stay and go to the park at Busch Gardens on Sunday and have fun. And Cindy is placated by that. But they're supposed to be back on the 23rd. Casey, of course, is still at Tony's. And by this point, ladies and gentlemen, in all, based upon the evidence you've heard, Kaylee was already in her resting place off Suburban Drive in the process of decomposition. On the 23rd, when they're supposed to be home, Casey needs to come up with some other reason for them not to be there. At this point, Casey comes up with the story of the accident. Zanny, this imaginary person, has been involved in an imaginary automobile accident in an imaginary place and is now in an imaginary hospital. And of course, they couldn't possibly leave without her. And since Juliette Lewis is there and Annabelle is there and Kaylee is having such a wonderful time, we're going to stay a few more days. So that excuse extends the stay a little bit longer. Casey continues to update her mother about the progress of Zanny's imaginary injury and extends the stay even longer. On the 24th, however, she has a problem. 24th is when she comes home and runs into her father. This is the gas can incident. So on the 24th, she's got to come up with something for why Kaylee isn't with her. So she tells her mother that she came home to Orlando to get insurance papers for Zanny for the accident. Casey is smart. Casey is quick. It is absolutely amazing how nimble Casey Anthony's mind is in the ability to come up with an appropriate and believable lie in an instant. She's impressive. But again, it allows her to extend this absence. Well, she is, in fact, again, hanging out with Tony. June 25th, still in the hospital, staying there to be supportive of Zanny. June 26th, Zanny is finally released late. It's amazing how that's its theme. Everything seems to be late. Zanny's released late. So they decided to stay at the hotel, not try to come back that night. They're going to spend one more night at the hotel. So finally, Cindy thinks Kaylee's going to be home. Finally, it's been more than a week, longer, 10 days, longer than she's ever been away from her precious granddaughter. But finally, they're going to be home. The next day. The next day comes, Friday, June 27th. Well, we're back in town, but we met up with Jeff Hopkins. Jeff Hopkins is the imaginary connection to Zanny that she came up with years before. She's actually got an amazing memory. I mean, imagine being able to remember the lies you told a year ago and incorporate that into a new lie. It's really quite impressive. So now, Jeff Hopkins is in town, and they're staying at the Hard Rock Hotel with him, a fun place. Again, Mom will be placated by that. But of course, she tells Amy that Kaylee is at the beach with a nanny. So again, we're getting contradictory lies, depending on the audience. June 28th, having a great time, still at the hotel, Jeff Hopkins, Zanny, the other children, everybody's really just having a wonderful time. Mom, so we can't come home. June 29th, gee, Mom, we're just having so much fun, we can't come home at the Hard Rock Hotel with Jeff Hopkins. So Jeff Hopkins becomes an interesting part of Casey's long-term strategy in this case. June 30th, she tells Cindy that Jennifer and Kaylee are going to Universal Studios. They're going to have a wonderful time at Universal Studios. On July 1st, she makes a mistake. July 1st, Cindy is actually on vacation. She makes the mistake of telling Cindy that Casey and someone named Jennifer Rosa are at Universal. Cindy actually goes to Universal, calls Casey on the phone because she wants to see her granddaughter. I'm sorry, that's July 3rd. July 3rd, we're at a character breakfast. Great thing for Kaylee, she's having a wonderful time. Cindy actually tries to go and see her She arrives at Universal Studios, calls Casey and says, I'm here. I'm ready to see my granddaughter. Oh, no, we're in Jacksonville. We're with Jeff Hopkins in Jacksonville. Now remember, Jeff Hopkins, the backstory of Jeff Hopkins is that he's a wealthy friend of hers that she has some romantic interest in, who conveniently lives out of town. Oh, we were going to be the character breakfast, but now we are in Jacksonville with Jeff Hopkins. This is the beginning, I would submit to you, of Casey's long-term strategy for how to deal with Cindy, because you have to have one. Remember Timer 55? Timer 55 is the password that Casey created for her MySpace and Facebook accounts. And there were two references by Casey to Timer 55. The first was in one of the tape-recorded conversations with Lee Anthony you saw in jail, where she says that Timer 55 is related to Kaylee. And then later, Lee testified his recollection had to be refreshed, as he frequently did, but admitted that Casey had told him that Timer 55 reflected the 55 days between June 16th and Kaylee's birthday. Now, she told him the story that was some reflection of when she thought that Zanny would bring Kaylee back. But we know now that's not true. We know now Zanny is a fiction. So what did it mean? What did Timer 55 actually mean? Timer 55 meant that she knew that she could only stall her mother to Kaylee's birthday. Timer, 55 days. The most she could do was 55 days. And then her mother would insist on seeing Kaylee. What I submit to you, the Jeff Hopkins Jacksonville story is a long-term strategy. Remember, on July 3rd and 4th is when there was the big blow-up. Cindy created a MySpace page, and she and Casey finally had a heart-to-heart. And what does Casey tell her? Casey tells her, I'm in Jacksonville with Jeff Hopkins, this man with whom I think I could have an actual relationship, a wealthy boyfriend who has a child the same age as Kaylee, with whom I think I can have a long-term relationship. Mom, you've got to get used to the fact that I won't always be with you. Now, this is all made up. So she's now got herself, mother convinced, that she's in a potentially long-term relationship with a wealthy man who lives out of town. Timer 55. She's coming up with a long-term strategy. Because maybe she'll marry Jeff Hopkins. Maybe they'll elope to Europe. She could extend that 55 days for months. She never had the chance. July 5th, she tells Cindy that her car is being fixed in Jacksonville, that she'll return on the 12th, that she's staying with Jeff Hopkins and his mother. July 13th, she tells Cindy that Jeff Hopkins' mother is getting married, a miraculous and fictional marriage, and they're going to stay to finish that. Well, in fact, she's just hanging out with her friends. Now, the July 3rd conversation did back Cindy off. Cindy was largely leaving her alone after that, until July 15th. On July 15th, all hell breaks loose because they got the car. I would submit to you, had they not gotten this car, I would submit to you, based on the evidence, that Casey would have continued this story at least to Kaylee's birthday and probably beyond, for as long as she could. But the car made that impossible. July 15th, the car is discovered. Cindy is on a mission. Cindy is on a mission. Cindy is going to find and see her granddaughter, and she will not be denied, and that's it. Tracks down Amy Huizenga, tracks down Casey, grabs Casey, says, you will take me to my granddaughter now. She tries to rely on the old saw. She's at Zanny's. I don't want to wake her up. She's at Zanny's, she's at Zanny's, she's at Zanny's. Despite everything that Cindy says, despite the threat of Cindy Anthony to call the police, sticks to the story. Same old saw. Zanny, 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 Zanny. Until finally, her brother, Lee Anthony, says to her, okay, let's play this out. I'm the police officer and you're you. Ms. Anthony, take me to your granddaughter. No, she's sleeping. Take me to your granddaughter, your daughter. And convinces her of the reality that this story simply will not stand. Cannot survive. Your lie will not succeed. And in a pattern which you will see repeated in the face of a lie that simply cannot stand, she comes up with a new lie. Yes, there's a Zanny, but Zanny kidnapped Kaylee. Kidnapped Kaylee 31 days ago. It's interesting that though Casey got the date wrong, in other words, remember she told the police it was June 9th, it was actually the 16th. She got the number of days right. 31 days. 31 of the 55 were gone. I haven't seen my daughter in 31 days. I've been looking for her. I've been doing my own investigation, and tells this elaborate story of how she knows Zanny because she works at Universal, and Jeff Hopkins and his son Zach and Zanny and all the other children, and tells the police this elaborate, consistent lie. And initially the police treat her as if, in fact, she's a victim of a child kidnapping. But the more they investigate her story, the more it seems to fall apart. In what can only be described as, if it weren't true, you couldn't write it this good, is the incident at Universal Studios. But it's indicative of Casey Anthony and who she is and what she does. She maintains this story about the kidnapping, about working at Universal. She takes them to Universal. She walks with great confidence from the security gate to a building, enters the building with absolute confidence, walks to the end of a hallway, turns around, puts her hands in her pockets, and says, okay, I don't work here. Casey Anthony maintains her lies until they absolutely cannot be maintained anymore. When she gets to the end of that hallway, or when she gets to the end of that conversation with her brother and realizes this lie has failed me, so I must abandon it and replace it with a new one. So, in that amazing conversation with Yuri Melich and with John Allen, she admits to lying about working at Universal for reasons which are not clear, but maintains the Zanny story. I'm lying to you about working here, but everything else I told you is true. And she maintains that lie through conversation with law enforcement. She maintains that lie through conversations with her parents and her family, which you saw through all of July and into August. But during that period of time, a problem comes up, and that is that her claim of where she dropped Kaylee off has been conclusively disproven. There's just no way that's true. Her claim that she was looking for Kaylee has also been conclusively disproven. There's no way it's true. Realizing that, when she is briefly released from jail on bond and stays with her family, she comes up with the new story. The kidnapping story, the forceful kidnapping story, the Blanchard Park story. Remember the testimony she told her brother Lee when she was out in that later part of August, that in fact, yes, Zanny did kidnap Kaylee, but it was by force. We met at Blanchard Park on the 16th, that they held my arms, they held me down, they took Kaylee away from me because I was a bad mother. Again, faced with overwhelming evidence that the story is a lie, Casey comes up with a new one. Call it Casey 3.0, a new version. The problem with that version comes up on December the 11th of 2008. Can I have State's Exhibit 208, please? Kaylee's remains are found. Kaylee's remains are found within a quarter mile of the Anthony home. With her remains are found a number of items, a number of very important items. Could I have 222, please? Could I have State's Exhibits 302 and 284? The first, that should be the gas can and the first problem is tape. The tape that is found on Kaylee Anthony's remains, which is contained in this box, in this bag, and you can look at. 3 pieces of duct tape, photograph we see here with a distinctive brand on it. Hinkle brand duct tape, found on Kaylee's body. The difficulty for Kaylee 3.0 is that the same tape that was found on Kaylee's body is also found on a gas can taken from her home. And you'll see from the sales exhibit you have that was put in by the defense that this tape is a fairly rare kind of tape. Hasn't been sold since 2007. And even then, it was only like 100,000 rolls of it sold. It's a very unusual tape. And it's on Kaylee's body, and it's on that exhibit. And in fact, in what has got to be the most bizarre part of this case, that very tape was used unknowingly by her own father to display a photograph of Kaylee, that missing person poster. The tape that was used to kill Kaylee Anthony was used to implore people to look for her. Could I have photograph in evidence 224? This is the bag that Kaylee was found in. This is what, I guess you could say this was her coffin. This bag, could I have photograph 227? This is the tag from that very same bag. 293. This is the laundry bag taken from the Anthony house during a search warrant on, I believe, December the 11th of 2008. This is the make of the bag that served as Kaylee's coffin. Remember, we saw a photograph of an ad. They're sold in sets. There's a square one. There's a cylindrical one. This is the square one. The cylindrical one is in this bag. State's Exhibit 264. I'd rather not take it out. It's not very good condition. Because that bag is Kaylee's coffin. Could I have State's Exhibit photo, State's Exhibit 233? This is the photograph of the shorts that were found with the remains of Kaylee Anthony. You'll recall that from the medical examiner's testimony, it's very, very tattered from decomposition. State's Exhibit 314. This is a photograph of Kaylee Anthony wearing those very same shorts. Could I have State's Exhibit 237? This is a photograph of the lettering that was found in the bag with the remains of Kaylee Anthony. The last remnant of a shirt. Remember, the testimony was all that was left of the shirt was the stitching around the collar and these letters. Could I have State's Exhibit 13, please? And there's a photograph. Kaylee Marie Anthony wearing the shirt in which she died. With not a stranger, Casey Anthony. Could I have 255, please, photo and evidence? And I'll need Exhibit 288. This is a photograph of the blanket that was with the remains of Kaylee that was found on December the 11th of 2008. You'll notice in the middle of the photograph you see a particular character, Winnie the Pooh with Piglet on his shoulders. Exhibit 288 is the bedding that was on Kaylee's bed, maintained by the grandparents for all those months. He was supposed to visit. You'll see the Winnie the Pooh theme, but also you'll see the exact same figure on the bumper from Kaylee Anthony's bed. This blanket was not taken from the home of some stranger, but was taken from the home of George and Cindy Anthony. Cindy and Kaylee lived. The claim that some stranger abducted Kaylee Anthony was no longer tenable. Just as the claim that Kaylee was at Zanny sleeping, just like the claim that she worked at Universal Studios, just like the claim that she left Kaylee at Zanny's house. One by one, those claims died. And by the time Kaylee's body was found, any suggestion that Kaylee was kidnapped and murdered by a stranger was gone. There's no question left that Kaylee Anthony died at the hands of someone in that house. When we started this trial, the defense in opening statement made some statements. I want to first, of course, remind you that what the attorneys say, what I say, the defense counsel says is not evidence in this case. The evidence that you must decide this case on is what comes from the witness stand or from these exhibits and evidence. In opening statement, defense counsel gave you a very, very detailed explanation, story of how Kaylee Anthony died. With dramatic flair, he told you about Casey Anthony being awakened in the morning by her father, screaming at her, "Where's Kaylee? Where's Kaylee?" About a frantic search for the child, about the grandfather bringing her up, wet from having pulled her from the pool, and laying her at Casey's feet and screaming, "This is your fault, this is your fault." The judge will instruct you on the definition of reasonable doubt. He will tell you that a reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. The defense's opening statement has not been established by any evidence in this case.
Burden shifting. Move to strike.
Overruled.
In fact, the only evidence presented in this case is that it did not happen. George Anthony, the first witness you heard in this case, told you that it did not happen. You may not speculate, you may not imagine, and there is simply no evidence in this case to support that contention. And you must reject it. The defense's opening was not simply to create one villain. The defense was not satisfied with one. They suggested a second. They suggested someone that counsel referred to as morally bankrupt, Roy Kron. The defense in opening suggested to you somehow, and perhaps counsel will clarify this in his closing argument, that somehow George Anthony disposed of Kaylee's body, and that George Anthony was somehow, actually we'll concede, George Anthony is connected to the tape, tapes from the house, that George Anthony's connection to the tape somehow connects him to placing the tape on Kaylee's body. Remember, the defense counsel said, follow the tape. But then in the same opening statement, he suggested to you that Roy Kron somehow took the body, kept it in another location, and then returned it. And in fact, one of their witnesses, Dr. Spitz, suggested what I would submit to you is, based upon the evidence, the nonsensical proposition that someone came along, took the skull, took it home, and put tape on it. Well, ladies and gentlemen, you can't have it both ways. Either George Anthony is a person that put the tape on, which we know is not true, or Roy Kron is the one who put the tape on. You can't do both. It's one or the other. Either somebody put the tape on that child before the child decomposed, or they didn't. The arguments made by the defense in this case, I would submit, require you to suspend your common sense, to leave in Pinellas County everything you know about how people think and act and why they do what they do. It is a trip down the rabbit hole into a bizarre world where men who love their granddaughters find them drowned and do nothing. Where men who love their granddaughters take an accident, a completely innocent act, and make it look like a murder for no reason. A world where a man who buries his pets will take the granddaughter who was the love of his life and throw her in a swamp. This is the world that the defense invites you to occupy. And a world where a guy who runs across a skull and reports it 3 times to the police and is blown off by them, takes the skull and the mandible, which is worth a lot of reward money, takes it home for 4 months, puts tape on it somehow, and then brings it back and sets it back where it was and calls the police. In any world, even the most morally bankrupt, greedy, reprehensible reprobate, if they're motivated by money and they want to report finding a child's skull that everybody in the country is looking for, and if all they're motivated by is money and the police are not listening, you walk down the street, you turn the corner, you find any one of dozens of reporters and say, come with me, I got a story for you. And every single one of those reporters would be in that scene right then and there, if that's what Roy Kron had wanted. Roy Kron, that's all he saw. It's on tape. Nobody wanted to listen to it, so he gave up. 4 months later, he came back and still he reported it. It's there. You can look at the photographs of that body, and without any assistance from expert testimony, can tell that that body has been there for a very, very long time. It didn't just get set there. And that tape didn't just get put on that skull. And you know how you know that? Because the tape is decomposed just like everything else is. You've seen photographs of the tape. You've got it in evidence. That tape has been out there for a very long time. You heard testimony from the Ms. Lowe, the fiber analyst, who told you that that tape didn't even have any cotton in it. And we know it's the same tape as the tape in the garbage. But that tape had been out there for so long, it didn't even have cotton in it anymore. So she couldn't even tell scientifically they were the same. Everyone can see they are the same, but that's how long it had been there. The tape did not just get out there a few days before. All the evidence says that that's impossible. Look at the facts of this case, and you will see that there is absolutely no possibility, reasonable or otherwise, that George Anthony had anything to do with disposing of his body. He is a doting grandfather who loved that child literally more than life itself. You watched him on those hours and hours of videotapes and conversations with Casey Anthony. You saw the pain. You saw the anguish. You saw the questions that he wanted answers to because he didn't know. And you have his suicide note. January 22nd, 2009. George Anthony was ready to end his life, to be with Kaylee. And that note, when you read that note, it's going to go back, you can read it as many times as you want. There is absolutely no way that the man that wrote that note knew anything about what really happened to his granddaughter, and that's what was killing him. He didn't know. He had nothing to do with this crime. But the evidence that Casey did is overwhelming. Casey's car, when it was retrieved from the tow yard on July 15th of 2008, reeked of death. The first witness you heard talk about it, Simon Birch, gentleman with the English accent, manager of a tow yard, not a police officer, but a guy who for 30 years has been involved in towing cars. He also spent a year in waste management, which is 2 years in waste management, which is also, I think, important. He told you, he said, I have smelled everything that a human being can leave in a car when it gets towed. People leave their groceries in the car, park in towaway zone, the car gets towed. The groceries rot in the back. Dead bodies, 5 or 6 of them. I've had cars that had dead bodies in them. I've smelled it all. And yes, I would submit to you, he smelled rotten milk too. And he told you that when he approached that car the first time and leaned down to get the VIN number, he smelled something. And he knew what it was. And he told you that when he went back there with George Anthony and he smelled that car when the trunk was open, he said to himself, whoa, I know what that is. And Mr. Birch has no reason to lie about any of that. Could have stopped there. He was very, very persuasive, I submit to you. But we didn't. We went further. You heard from professional witnesses, crime scene technicians, who smelled it, unfortunately, on many occasions. Unforgettable, unforgettable. Exactly what it smelled. The defendant's own father, even at the time, said, I smelled that before, and I know what it smells like. But we didn't stop there. We got help from the one person who has studied the odor of human decomposition more extensively than anyone else, Dr. Arpad Voss. 20 years he's spent studying the biochemistry of human decomposition. The last 10 specifically studying the odor of human decomposition. And he told you that when he opened that can, he jumped back and said, I know exactly what it is. But we're not just relying on his nose, we're relying on science too. He examined the evidence. Examined the odor. Now, what's important about what he did with the odor is that he actually took a piece of the carpet, separated it from the trunk, so that the odor that he was getting had to come from the carpet itself. In other words, not some ambient odor from something that had been in the car before, but from the carpet itself. And in fact, the defense's own expert, Dr. Furton, agreed that that process would render an odor from the carpet itself. Submitted to instrumental examination. Now, both Dr. Voss and Dr. Furton agree that at this stage in the science, there is no signature set of chemicals that is indicative of only human decomposition. They both agree on that. All they can say, either one, is that it's consistent. And Dr. Voss, who has researched this more than anyone else, says to you, it's consistent. Could it be from other sources, other things that were not found in the trunk? Of course. But those things wouldn't smell like human decomposition. And you could put together a coincidental group of chemicals to account for everything. You could throw in some gasoline, maybe throw in some chloroform bleach, throw in some carbon. You could throw the chemicals together, but it wouldn't smell like human decomposition because the smell is unique. He tested the odor. He tested the carpet through 2 different instrumental examinations, one for inorganic, one for organic, and he tested the paper towels. And everything he tested came back to one specific cause, that there was a dead body in the back of Casey Anthony's car. Now, the defense presented you Dr. Furton, who is also experienced in this area, though I would submit to you not as experienced as Dr. Voss, because Dr. Furton's main area of interest is in individual human scent. In other words, the sense that you and I give off in life as individuals. Some of his students at the corollary do study human decomposition, but the thing was interesting is he agreed that the odor coming from the car is, in his opinion, from decomposition. He tried to propose some alternative sources of the decomposition, such as milk or cheese, but ultimately he had to admit that the items that were in the car, that is the garbage, wasn't sufficient. I mean, I guess it was Dr. Huntington, the bug guy, who tried to talk about, that there was maybe some salami in the salami package, and remember I showed it to him, and it wasn't salami, it was a piece of paper. And then Dr. Furton tried to talk about the cheese and the Velveeta packages, and I showed him the Velveeta packages, and there was a tiny little bit of residue in it. And ultimately, even he agreed that what was in that garbage was not sufficient. We have exploded the myth of the garbage as the source of this odor. Even Dr. Furton admitted that no, this garbage just wasn't sufficient to give the odor that was found on these items, and in fact, the odor that was still present by the testimony of their own expert, Dr. Huntington, that he still smelled 2 years later. You all, in your common life and experience, have smelled common household garbage. Y'all have walked past, I'm sure y'all have walked past dumpsters. You've got your husbands or wives, somebody taking out the garbage, it took a little too long. What garbage smells like is not beyond your experience. And ladies and gentlemen, when you remove a bag of garbage from a trunk, the smell goes with it. It doesn't stay in the trunk. It was there because Kaylee's body had been there. But that's not the only evidence you have. You have the hair. A single hair was found in the trunk of Casey Anthony's car with an artifact that you heard, I'm sure more than you ever wanted to, about. But an artifact which is only found in hairs attached to decomposing human bodies. And that particular expert testimony has not been rebutted by any other testimony you've heard in this case. You heard a lengthy testimony from Stephen Shaw. You heard lengthy testimony from Stephen Shaw about a test that he did, where he literally told you, I was trying to create this artifact in a hair taken from a living person. I tried to find every method I could think of, every decomposition situation I could think of, to try and recreate this particular artifact. And he couldn't do it. No matter how hard he tried, he could not replicate it. Now, defense counsel debated with him some photographs where there was some darkening and debated whether that was banding or wasn't banding. The important thing about all of that is that when you look at the hairs that actually came from a car, from the trunk of a car or from the inside of a car, the same circumstance as this particular hair, they didn't have any markings on it at all. Nothing. No decomposition of any kind. So regardless of whether you debate whether having a hair buried in the dirt for a month can create something that looks like, so what? This hair wasn't in dirt for a month. It was in the back of the car. The point is that that hair was from a dead body. Now, how do we know that that was Kaylee's body? 2 ways. The first is by mitochondrial DNA. Mitochondrial DNA testing was done on the hair and also on Casey Anthony. That mitochondrial comparison proves that that hair came from some maternal relative of Casey Anthony, which means it had to be either from Kaylee, Casey, Cindy, Lee, or Cindy's mother. Okay? Well, we know it's not Casey's because it's too long and Casey's hair is treated. So we know it's not Casey's. We know it's not Cindy's because it's the wrong color, it's not treated, and it's too long. We know it's not Lee's because it's too long. Lee's hair is short. This hair is 9 inches long. And we know it's not Cindy's mother because Cindy's mother had been in the car once, but Cindy's mother's hair is treated, and this hair is not. This hair could only come from Kaylee Marie Anthony. And remember, the testimony is that the hairs actually taken from Kaylee's body also had the band, just like the hair from the trunk. The only difference was the hairs from the body, the roots had actually completely decomposed, where the one in the trunk had not. As hard as it is to accept, when Casey Anthony was at Blockbuster on June 16th, walking arm in arm with her boyfriend, Tony, Kaylee was in the trunk of her car in the early stages of decomposition. When Casey returned to the house on the 17th or 18th, she backed her car into the garage with the intention of burying Kaylee in the backyard. She went to Brian Berner and borrowed a shovel. Based upon the dog alerts in the backyard, she in all likelihood actually took Kaylee's body back to the backyard and set it down for a period of time. Was digging too much work? Perhaps. And she decided instead to toss Kaylee's body in a swamp. The evidence in this case proves beyond any reasonable doubt that Casey Anthony decided on June 16th that something had to be sacrificed, that the conflict between the life that she wanted and the life that was thrust upon her was simply irreconcilable, and something had to give. She chose to sacrifice her child to live the life that she wanted. She took her child, she took her life, and she put her in the trunk and forgot about it. After a couple of days, she couldn't forget it anymore. And she disposed of her body in a swamp. These are the facts that you have heard, and these are the facts that prove, beyond a reasonable doubt, that Casey Anthony is guilty of murder in the first degree, and that murder is premeditated. The defense says and will say that we can't prove how Kaylee Anthony died. Let me echo the words of Dr. Jan Garavaglia, the medical examiner in this case, when she said, there is no good reason to put duct tape over the face of a child. Why would you put duct tape over the face of a child? Well, there's two reasons. One is perhaps to silence them. But then why do you need three? Remember, in this case, there wasn't one piece of duct tape placed over Kaylee's face. There were three, overlapping at angles, placed over her face. Why do you need three? What does three do that one does not? One would certainly silence her, if for some reason that's what you wanted to do, as brutal as that would be. Why do you need three? You need three because your purpose is not to simply silence the child. Your purpose is to make sure the child cannot breathe. The first piece goes over the mouth, but that doesn't secure the nose. The second piece goes over the nose, but you could still have some gaps, so you have to be thorough. You have to have three. 1, 2, 3. And then the child dies. There is simply no other reason. There is no other justification. There is no common sense. There's just no reason to put duct tape over the face of a child, living or dead. And that, ladies and gentlemen, is proof beyond a reasonable doubt of how Kaylee died. Because there simply is no other explanation for why you put duct tape over the nose and mouth of a child. And based upon the photographs you have seen, it is crystal clear that that's where the tape was. That the medical examiner told you, the forensic anthropologist told you, that there's no question that that tape was on Kaylee's face before her body decomposed, because otherwise the mandible wouldn't have been in place, and it was. You can see the photographs of the tape. I don't want to show them to you again. You can look at them in deliberation, but you can see the photographs. The duct tape is curved slightly under the jaw. There are even strands of the duct tape that go under the jaw. That tape was placed there with one singular purpose. Now, we can only hope that the chloroform was used before the tape was applied, so that Kaylee went peacefully, without fear. But go she did. And she died because she could not breathe. She died because she had 3 pieces of duct tape over her nose and mouth, and she died because her mother decided that the life that she wanted was more important. This murder was premeditated, and the defendant is guilty. Thank you.
All right, well, that's the prosecution's case. Closing argument. Pretty solid, I think. And now let's move on to the closing argument for the defense, and there's a few different parts. So we'll start off with the first part.
Prosecution. Good morning, ladies and gentlemen. I, too, would like to thank you on behalf of the defense for the sacrifices you've made as citizens of the state of Florida. We know that it came at a great sacrifice, and both sides saw how much attention you paid to the presentation of evidence in this case. And it hasn't gone lost on us. We all have recognized that. And I want to thank you both individually and collectively for that great sacrifice that you've all made. Thank you. Here we are at the end of our journey. And I have to tell you that I probably think you have more questions than you have answers. And if you recall at opening statements, the final thing that I told you, at the end of the day, when everything is said and done, the one question will never be answered. The key question in this case will never be answered. It can never be proven. And that is, how did Kaylee die? That's why we're all here. Really. There's no dispute that Kaylee is passed on. There's no dispute whatsoever about that. So really, the key question, as it relates to all manslaughter, child abuse, and murder charges that you're going to be presented with, is how did she die? What happened to her? What is proven beyond and to the exclusion of every reasonable doubt? Not just some, but every single one. And those questions were never answered. That evidence was never presented to you. In fact, there was a great deal of things that you were probably looking for and never received. Now, I'd like to explain to you that this is my last opportunity to speak with you individually. After I am done, Mr. Mason will then stand up and cover the jury instructions and the law, and then I will have one last opportunity to speak with you. But generally, this is our moment. This is our opportunity to show you and explain to you what we think the evidence showed in this case. The state, after we're done, will then be able to get up and have what's called a rebuttal argument. This is the hardest point for a defense lawyer because I can never come back up and respond. And the reason it's done that way is because the state has the burden of proof here. So they get that last opportunity. They have the burden of beyond and to the exclusion of every reasonable doubt, which is the highest standard in American jurisprudence. It is the highest standard that must be met. So that is why they're afforded that opportunity to have the last word. It wasn't because we tossed a coin and they won. It's because it is their burden. And you'll recall when I told you in the very beginning, when we did the jury selection, I had the unique opportunity to speak to each and every one of you individually. I told you, it's not a two-sided affair. The state has the only burden here. And while the defense did put on a case and did put on evidence and testimony, it was never required to do so. We could have sat back, not questioned not one single witness, and did absolutely nothing throughout the course of this trial. And it still would have been the burden of the state of Florida to prove every element in every charge. And you'll recall when we talked the jury selection, we talked about elements and what they mean. And Mr. Mason is going to come up and give you a little more detail as to that. But that's the same burden, beyond and to the exclusion of every reasonable doubt. And it's done that for obvious reasons. We're here for a serious matter. You all left your homes to come and resolve a serious question of fact. And if you were not given the facts you need, your guidance will be the law. The law will guide you as to what your decision and what is a legal and just decision. Judge Perry will tell you that what is important is that you follow the law. We all have laws. We all have lived by these laws for many years, and no one has the right when deliberating to base their decision on emotion. Now, what I'd like to talk to you about and how I've broken down my final remarks to you are, I'm going to start with my biggest fear. I'm going to tell you right up front what I fear may happen in this case. And I want to talk to you about it and explain why I feel that way. I want to then outline the state's case. I want to talk about it piece by piece. And my presentation will be a little bit longer than Mr. Ashton's because I want to actually show you what I think the evidence showed. Now, you're going to have to rely on your recollection of how the evidence was presented. It's true. What we say is not evidence, but it's a guide for you to look at the evidence from a certain angle and a certain perspective. There were lots of delays in this trial. There were times we went at sidebar. There were times objections were raised. What you have to look at the evidence by is by what actually was testified to. And sometimes it came out a little odd. Sometimes it didn't come out with as much cohesiveness, and the presentation wasn't as fine as both sides would have liked it to be. I certainly know that was the case with us. But the problem is this is the purpose of us coming up here and talking to you, to show you we think this has a connection to this. We want you to pay attention to this fact because of this and what came on later on, and try and tie it and piece it together for you so you can look back and say, yes, I remember that happening, but when it happened, I wasn't so sure what it meant. But now that you explain it, I understand what you're trying to say and what your point is. So that's the purpose of what I'm going to do when I talk about the state's case. And then I want to talk about the defense's case, the presentation that we put on, even though we weren't required to do anything, even though the law says that the defense has no burden and does not have to prove anything. Then after that, as I mentioned, Mr. Mason will get up and explain what the charges are, and explain what must be proven, and also explain the judge's instructions to you and how they apply to the defense's case, and how they apply to the state's case, to try and give you an understanding. We realize while you're all very educated people, you're not skilled in the area of the law. So this is something that we're going to use to assist you in that regard. And then finally, I will have my last remarks that I think are points that I think you should also consider before we sit down. And as I mentioned, it is going to be the toughest time when Mr. Verdict goes up, but you have to understand the reason why. Now, let me start with my biggest fear. And that is that this case deals with so much emotion. I know that there were times where every single person in here felt something deep down inside. The law gives us a guidance as to what we should do when it comes to emotion. And that is your rules of deliberation. What the law is that this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. And that's because, obviously, we want you to base your verdict on the evidence, not on emotion. And while there were times where emotion was directly pointed at you, where things were done to draw into your emotion, to get you angry at someone, to get you to discriminate against someone because they didn't act the way they should have acted. They should have acted. They didn't conform with what we think is right or normal. They're different. And that is not what the law is. The law says you must base your verdict on the evidence, not on emotion. And it's my biggest fear because it's such a difficult thing for you to push aside. Kaylee Anthony was a beautiful, sweet, innocent child who died far too soon. There's no doubt about it, and that is not disputed by anyone. But to parade her up here, to invoke your emotion, would be improper. It's improper under the law, and it's improper as to the rules of your deliberation. And I submit to you that that is the strategy and the way the state presented this case. They started with, well, let me just start with Mr. Ashton's remarks to you today because they're the most recent in your mind. Mr. Ashton started out showing you a video of little Kaylee, started talking to you about parenting, started talking to you about what a mother should and should not do. He went on for a great length of time talking about this beautiful child, not on his evidence, not on the evidence that was presented before you. It was to set up the emotion for what was to come. And that is exactly how this case was presented. They didn't come right out the gate and show you the evidence. They gave you 2 weeks of testimony that was completely irrelevant and served only one purpose. And that was to paint Casey Anthony as a slut, as a party girl, as a girl who lies, and has absolutely nothing to do with how Kaylee died. And you would dishonor the law and even Kaylee's memory if you were to base your decision on anything but the evidence. And to use emotion to get you angry is improper. And here's the proof. And Judge Perry will read that to you. It is rule number 3, but I ask that you make this rule number 1. The state came out and paraded all of these people. But what was unique is throughout that process, everyone kept coming back with the same thing. Casey was a good mother. Kaylee loved Casey. And what was funny is I wanted you all to see something, and you may have wondered why I asked certain questions. I asked many of the questions as to how did Kaylee react to Casey, because I thought it was important that you understand that, of course, a child cannot fake this. A child cannot fake love. A child knows when it loves someone, it behaves a certain way. And I brought those questions out, and I asked them from both angles. How did Casey treat Kaylee, and vice versa? And what this did was, it wasn't to appeal to your emotion. It was specifically directed at the child abuse charges. We were here for a couple of months, at least 6 weeks, as Mr. Ashton pointed out. But you didn't hear one single instance having anything to do with child abuse. Not one. And this prosecution was geared in such a manner that it was deliberate, it was methodical, it was thorough, and it was detailed. You saw during those 30 days every movement of where Casey went and every single thing she did. And if there was one instance of child abuse, you would have heard it. You would have seen it. You would have been able to, it would have become clear. So if you look at these child abuse charges, ask yourself, when did someone get on this stand and tell me or demonstrate in any way that Kaylee was abused? Child abuse cases are sad, and they're one of the most horrible crimes imaginable. But one thing's for certain, if there's an abused child, people know it. People see bruises, people see different things about that child. They will see, there will be broken bones at times, there will be different instances, but there was nothing other than the fact that this child was loved and well taken care of. And from one moment to the next, something happened. Something changed. Something changed that will forever change the life of Casey Anthony, and something forever changed that ended the life of Kaylee Anthony. It was sudden and immediate, not deliberate, not repeated, not premeditated, but something from one moment to the next. You have to rely on the evidence. What came forward? What was put before you? I agree with one statement that Mr. Ashton said, is you can't speculate. Don't speculate. Don't guess. It has to be proven to you beyond and to the exclusion of every reasonable doubt. If you don't know what happened, it wasn't proven. We don't want you to tell us what you think happened. We want you to tell us what was proven happened. And that's the difference here. Because you know what? We can go on and speculate all day long as to the different theories that were posed before you, as to the different possibilities. But the truth of the matter is it must be what was proven. There are no mysteries to solve here. There should be no mystery before you right now. If you have questions, then it was not proven. And that's as simple as it goes. It's as simple as it gets, because that is exactly what is done. Now you have seen this checkbook prosecution, where they spared no expense, utilized the finest crime labs in the country, the FBI laboratory, but yet with all of the resources, and used not only established areas of forensic science, but created new ones that were never testified before in front of a jury. You are the first jury to ever hear some of the evidence in this case, this type of evidence, air evidence, the very first. You're the first ones in the state of Florida to ever hear hair banding evidence. You're the first ones in the state of Florida to ever hear a trainer testify about his dog. You're the first one to ever hear any of these types of evidence. And that's what I told you from the very beginning, that this prosecution would raise to the level of desperation to make up for their lack of evidence. Now, back to what I was saying with their initial setup. the way the case was presented the first couple of weeks. You see, the strategy behind that is if you hate her, if you think she's a lying, no good slut, then you'll start to look at this evidence in a different light. You'll start to, oh, wait a minute. Maybe I'm seeing something that's not there. And start to actually discriminate against her rather than give her the standard that is afforded to each and every citizen in our country. And that is that the state, that the government come in here and prove their case beyond and to the exclusion of every reasonable doubt. But you can get away with that if we can get a jury to hate her. We can get away with that if we paint her in a certain light that has nothing to do with what the is. I told you at the very beginning of this case that this was an accident that snowballed out of control. And while it was a very common accident, what made it unique, what made it different, is not what happened, but who it happened to. And you all sat here and saw some bizarre things throughout the course of this trial. Bizarre things that have been going on long before Kaylee was ever born and throughout her early life. You saw all of these things. This is not stuff that is new. There's something wrong here, something not right. And that's what makes this post-death behavior relevant. It explains it. But at the end of the day, it is irrelevant to the number one question that you all came here to answer. How did she die? And I will jump and piggyback off of what Mr. Ashton said and ask you not to speculate as to that fact. Now, I want to start with the car, okay? And what's unique about the car is, again, what I told you at the very beginning. The car does not shed any light on how Kaylee died, period. And I told you all, it will double the length of this trial, if not triple. And I think I showed you that that ended up being true. All of the discussion that came around with being irrelevant evidence ended up being posed as the now, and I say that for this, because what the car does is it tells you how Kaylee may or may not have been transported. It doesn't explain how she died in any way, shape, or form. And you may be asking, well, why did you spend so much time fighting it? Well, we weren't about to allow the state to put a square peg through a round hole, and that's that. Because there are just as many questions as there are answers relating to the car. Who had possession of it all the time? Did George Anthony have access to it? And there was testimony that came out. And was there, in fact, actually a body in the back of the car? But at the end of the day, we come back to, does it tell us how she died? No. We all know Casey acted inappropriately and did it and made some mistakes and bad decisions. She should have called the police. She should have not attempted to block this out. She should have reported her death. There's no doubt about that. And that question was never contested. That issue was never debated. But if there are crimes associated with those acts, the state of Florida has the ability to charge her with whatever crimes they feel those acts warrant. They don't have the right to overcharge or inflate the case, to make it something that it's not, just because it's entertainment, just because everybody wants to know, just because there's some mystery. You heard tons and tons of evidence of how this case, the media, and the way it was portrayed, and the way it all came about, how it influenced people's actions, decisions, for both sides. But we can't lose focus of what actually occurred, and that's the answers that you're supposed to answer here for us during your deliberations. I want to start off with the issue of the car. Now, you'll recall I used these boards during my opening statement when I explained certain things, and I think going back to them will kind of help you with the timeline of things. You'll recall that on the 27th, actually, you'll recall that Kaylee was last seen on June 16th, according to George Anthony, the testimony of George Anthony. Now, I will remind you that the indictment reads from June 15th, not June 16th. And that is very important for you to consider. And that raises the question is, does even the state of Florida believe that she was last seen?
The indictment itself is not evidence. It is charged in a way that says between.
Sustain, let's move on.
Look at the indictment. Look at all of the instructions. So, you'll recall Tony Lazzaro testified that, and he was the young man that was dating Casey. And you'll recall that on the 20th of June, Casey ran out of gas. And Tony went to the apartment Tony went to help her get gas. They went to the Anthony home, and in the back of in the backyard, there is the shed where they got the gas cans from. You'll recall his testimony, and his testimony was clear. that when they went to pour the gas, Casey did not try to block him away. Casey did not say, "Hey, don't get near my trunk." In fact, they poured the gas in the car. They opened the trunk, and they put the gas, and she put the gas cans in the trunk of the car. She could have easily put them in the front seat. She could have done whatever she wanted. She could have told him, "Go away, I've got this." She could have never gotten assistance from Tony Lazzaro at all. If she had a body, as suggested by the state, in the trunk of the car, or if the smell had been there, this young man would have smelled it. Remember, he put up with his hand and he went like that and he said, "It's right here." You've seen pictures of the car. The gas gauge, the place where you put gas in the gas tank, excuse me, is right next to the back of the car. Why didn't he smell it? What happened there? Well, there's a reason for that, and that's because the car didn't smell at that time. That's the only logical conclusion. You'll also remember a young lady by the name of Maria Kish. She was a very attractive girl with glasses, one of Tony Lazzaro's roommate's girlfriend. You may not have noticed the bombshell that hit when Mr. George asked her about ever getting in that car. He got an answer he didn't expect. And that was, "Yeah, I was in Casey's car." And was it during the time that she was living with Tony? And she answered yes. Remember, they all went to McDonald's. All four of them got in that car, and Maria and her boyfriend sat in the back seat, and they didn't smell anything. But yet, 2 years later, it still smells, and all of these people are smelling the smell. Why wouldn't it smell that bad when it was most recent? Why is it not smelling to these people? We're going to get into who smelled what, but take that into consideration when you look at this. Then you'll recall the incident with the gas cans. That was reported missing to the police on June 24th. I labored over these gas cans throughout this trial because I think the issue is obvious. Who in the world reports gas cans missing? Who, not even in the state of Florida, how many times in the United States has someone called the police and said, "Someone stole my gas cans"? And why is that duct tape on there? And why are there so many lies surrounding that gas can and that duct tape? It's not a coincidence. If so, it would be an incredible coincidence. You couldn't have odds worse than the lottery. That's how bad it is. Then the car is towed on the 30th. You recall Mr. Simon Birch testifying that after 4 days, they sent out their notice. So what happened this entire week? Why did Mr. Anthony wait until the 15th to pick up the car? Why? Remember this fact. Mr. Birch said when George Anthony went to pick up the car, he showed up with a gas can. He knew the car was out of gas. And an even more important fact that you should remember is not only did he know it was out of gas, he knew that the car had been at the AMSCOT for 3 days. Remember that? He said, "Mr. Anthony told me that it had been there for 3 days. And I asked him, would you have known it was there for 3 days? No, as tow people, we just go pick up the tow yard. We would have no idea how long a car's been at a certain place. But he told us it was there for 3 days. Well, even though Mr. Anthony heard that testimony, he got up here on the stand and he said, "I called when I got to work. I found out that it was there 3 days when I got to work." And I asked him, "Did you call Mr. Birch to let him know that it had been there for 3 days?" He said, "No." So how in the world did Mr. Birch know that the car was at the AMSCOT for 3 days? He knew because George Anthony told him. George Anthony knew that that car was at the AMSCOT. He knew that that car was out of gas. And he showed up to pick up the car with his key. And when he got there, you all remember, he smelled the smell of death. He smelled the smell that you never forget. And of course, he did what every responsible parent would do, and that is nothing. Just go home and go to work. Nothing. Don't call to find out if my daughter is alive, who I have not seen since the 24th of June. I don't call to find out if my granddaughter's alive, since I haven't seen her since the 16th. He didn't do any of those things. And that's because he wanted to distance himself from this situation, and he knew. There's evidence of that. That was all presented to you. He knew something. He knew she was dead. This evidence doesn't make sense. And if the state of Florida had done as much work trying to track the comings and goings of George Anthony as they did Casey, you probably would have seen more. You probably have more answers, but you don't. Now, July 15th comes around. Now, July 15th comes around, And as Mr. Ashton points out, all hell breaks loose. Now we take a look at who actually smelled what in the car. You have CSI Bloisey, who testified, depending on who was asking the questions, you may recall. If Mr. Burdick was asking him, oh, it was human decomposition. When I was questioning him, oh, it was decomposition. So he went back and forth. You may recall that time. You have Deputy Forgy and his dog, who was advised that this is the suspect's vehicle. And you may recall we did this small thing where I had each and every person who witnessed this dog inspection, and they all said there was only one car. But yet Deputy Forgy lied to you, and he told you there were two cars. If you believe him, you have to believe that Yuri Melich, Michael Vincent, and Gerardo Bloisey were lying to you. Michael Vincent, the other CSI person who says he smelled a dead body. Mr. Arpad Bas, and we'll get into him a little later. Cindy Anthony, who said that during her 911 call, but yet said so because this was her third call and she wanted the police to get there quicker. Simon Birch, who runs the police tow yard. Now, you may recall that Mr. Birch didn't make his statement until 9 days later after it was broadcasted all over the news and in fact referenced news reports during his statements to the police. You have George Anthony, who did an incredible job of pointing out to Yuri Melich the first night upon arriving, as soon as he arrived. And of course you have Dr. Neil Haskell, the $40,000 man, the entomologist, who explained several theories. Now let's take a look at who didn't smell what. Karen Sanchez, the manager at the Amscott tow yard, the Amscott check cashing place where the car was. You may recall she said she smelled garbage. Tony Lazaro, who went and got Casey, got the gas cans for Casey, and was actually right near the trunk on the 20th. Charity Beasley, the police officer who picked up the car and took it to the tow yard. Maria Kish, the girl I spoke about earlier, who sat in the back seat with her boyfriend, Clint House. He didn't smell it either. Sergeant Hosey. Now, he said he smelled something. He's a sergeant. There's a missing child. He's at the home. He's hearing lies. Yet, he didn't think it was sufficient to call the crime scene investigators. Why? Because the trash seemed like a plausible alternative. It was understandable, if trash is in the trunk of the car for 3 weeks, that is probably the source of the odor. Deputy Ryan Eberlin, this was the young man who handcuffed Casey. He said he didn't smell a thing. Yuri Melich, the lead detective, who, again, like Hosey, was advised by George Anthony and still did nothing. His name is escaped me. Fletcher, yes. Brendan Fletcher, a corporal who said he did not smell anything and came in and out of that garage and that the trunk was open. Adriana Acevedo, another police officer who was there, that said she did not smell anything. Now, I know you heard a lot of evidence about the smell of this car. And if you look at, once Casey is arrested, how many people you have to eliminate. You didn't do anything. Cindy's explanation of the reason why she said that, at least one person. And even if you look at all of these people and give them the credibility that they deserve, you still have an abundance of people who did not smell something. This is a reasonable doubt. When you have this many people who are telling you a certain thing, you have to have some doubt. This is not one individual, like her boyfriend, who's trying to protect her. These are a significant amount of people from various backgrounds who have no interest in helping Casey Anthony. And that's why you need to consider this. And that's why you may have a reasonable doubt as to who smelled what. Now, the state of Florida talked to you and presented to you a neighbor by the name of Brian Berner. You may recall, this is the individual. He was a heavyset guy. He came up here and he testified about Casey borrowing a shovel. Now, if you think about Mr. Berner's testimony, you may recall that the police told him to close his eyes and try and remember the day that this all occurred. You'll recall that Mr. Berner didn't see what was done with the shovel. You'll recall that the shovel was borrowed for 45 minutes. And you'll also recall that Casey came back and she wasn't sweaty. And what the state wants you to believe is that Casey Anthony, in broad daylight, was going to go borrow a neighbor's shovel. even though you all saw that they have 4 or 5 of them in their shed, and bury her child in the backyard? Is that reasonable? How does that even pass muster at all? Now, I think what maybe my colleague's response was, well, look at all of her actions. They're not rational. Okay? And I would agree with that. And Mr. Ashton said something very interesting. Bury her like she buried their pets. Okay. Well, I will get back to that in a minute, but I'd like you to remember that. But okay, let's speculate now. That's what they're doing. They're saying, come, let's go speculate as to what happened with this shovel. You can easily speculate that Casey took that shovel and tried to open up the shed lock to get the gas cans. You can easily speculate that she was doing whatever with that shovel. But that shovel was tested. That shovel was inspected by the FBI, and we brought you the evidence forward. Not the state of Florida. We had the people from the FBI who inspected the shovel, and there's absolutely no evidence, no DNA, no hairs, no soils that match the actual scene. There's no evidence of that. So let's just speculate, shall we? That's not the law, and that's not your job. But yet that's what they want you to do. That's what they're asking you to do. Now, you saw tons of testimony about the trash and the garbage. And I can't count how many times I brought this up to you and showed it to you and said, take a look at this. And I brought it to you because I think what's important here for you to remember is that this evidence was changed. This evidence was altered. Whatever evidence could be used to exculpate Casey was destroyed, put intentionally into a dry room. You don't know what food is in there. All you know is they want to dry it out. They want to, and you were passed a Velveeta cheese with fingerprint dust on it. You remember that black powder? Fingerprint dust. They want you to know who cut the cheese. But they don't want any other evidence to come out as to what was actually in the trash of that car. And Mr. Ashton can do his little show all he wants and show them the garbage and say, where's the spit in here? Well, we could see there was spit there. Where's this? Could this create any smell? Well, of course you can't find anything because it was altered. It was destroyed. And that's not what a police officer's job is to do. That's not what crime scene investigator Vincent and Bloisy should be doing. They should be preserving evidence, photographing evidence, documenting evidence, so that you can make an intelligent and just decision, so that you can have the evidence you need to carry out and answer any question as to what was in this garbage, what chemical compounds could come out of it. And they went out and did the air test 6 weeks later from this. How absurd, how outrageous, how unjust could that be? Now, one of the things that I will point out to you in much more detail is the issue with the computers. And I will get into the detail of the state's, the very heart of their premeditation, as they like to call it, having to do with what you heard and how you were misled in a certain direction. I'm going to get back to this when we cover that evidence, but this evidence will so infect the quality of their case, like a cancer, that you will have no alternative than to render a verdict of not guilty. Actually, Judge, I think this would be a good starting point.
All right, moving right on to part 2, except we're going to take a very, very brief break, and then we'll get back to part 2. Okay, just a very brief break. All right, we're back. Here we go. Part 2, closing arguments.
Both sides are ready to proceed.
Yes, Your Honor.
We miss you, Mr. Baez.
I wish I could say the same. I do have one issue that I'd like to bring up.
Yes, sir.
I apologize, but I continue to see Mr. Ashton's facial expressions as I'm doing my closing arguments, and I would ask that he refrain from showing gestures or something, whether he approves or disapproves of what I'm saying. I think the court's been clear about its order, and I would just ask that.
With the signages, I can't see Mr. Ashton, but as I made it quite plain and clear, we don't need any facial expressions of approving, disapproving. Okay, for those of you who may wonder why we took so long, remember we had to, while we're in her state.
Yes, sir.
And you've only used 38 minutes and 20.4 seconds of your 4 hours. So you have a long time to go, Mr. Baez. All right, let's return to jury. Stay recognized, present jury.
Yes, Your Honor.
Defense?
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during your lengthy lunch hour? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court, my colleagues in the prosecution. Good afternoon, ladies and gentlemen. I'd like to pick up where we left off, and we were talking about the actual physical evidence, whether it is or whether it isn't. I'd like to call this next phase the state's fantasy of forensics. And I want to begin with the trunk of the car and this phantom stain that the state has alleged is on or in the trunk of that car. I'm looking. We've all seen the photograph, and I don't see anything that would remotely resemble a stain of human decomposition in the trunk of this car. Now again, this goes back to grabbing your emotions early on and hoping you'll see something that's not there. We heard evidence that there's no blood in the trunk of that car. We heard numerous tests. We heard Gerardo Beloisi talk about how thorough he was in examining the trunk of this car. You may recall he said he hasn't had a car in his entire 30 years of experience where he has processed it more than he did this car. And you heard Heather Siebert from the FBI talk about when tissue decomposes, it still has cell material. And they could have gotten DNA if there was DNA in the trunk of this car. And they certainly took swabs. They certainly tried. They certainly did everything they possibly could to generate something to let you know and to prove to you that there was a body in the trunk of this car. The state wants to have it both ways. They want to say there's a stain when there is. Maggots, when all the maggots were in the trunk of, were in the actual trash bag. They want to give you all of this evidence to try and say and try and hope that if you stare hard enough, you'll either see human decomposition, a human decomposition stain, or some other figment of your imagination. Of course, by this point, you're already angry. Your emotions are riled up, and you just might see, if you stare hard enough, if you stare long enough, you just might see a stain in the back of that car. Well, that's not true. That's not evidence. Evidence would have been a DNA report. Evidence would have been something similar to what we showed you. Something, as you may recall Dr. Huntington saying, not even professional cleaners could get that stain out of the trunk. This car was 10 years old, had a previous owner, went through 3 owners in this family, had numerous stains that were there long before June 16, 2008, long before. And you heard testimony about that. You heard actual evidence about those stains. And all they want to give you is stare a little harder and you just might see it. It's a phantom stain. It's there, you just can't see it. And this is the stuff you must look at. Remember when I told you, this investigation reached the level of desperation. And that's what this is. This is a clear sign of nothing but desperation. Nothing but desperation. Now I want to remind all of you that some of these boards have writing on it. And the law basically says that you must rely on your memory of what was actually said. So I may repeat certain things on this, but I want to be clear. Rely on what you heard in the courtroom, not about what I'm reading to you. Okay? Now, you may recall we had Dr. Neil Haskell come up and testify. Dr. Haskell and Dr. Huntington are both forensic entomologists, and they both talked about the bugs in the trunk of this car. Or should I say the bugs in the trash bag? Because that's what they both basically testified to. They both testified that the Magnocelia scalarius is a insect that is just like a gnat, kind of like a fruit fly. What you see when you leave your doggy bag in your car for too long. What you see when you normally find trash. They are not exclusive to human decomposition. There were 0 early colonizers except that one blowfly leg. And you may recall even Dr. Huntington said, just last week I found a blowfly in my house, so it doesn't mean anything. And they are commonly found in garbage. And then there's this testimony about towels, the paper towels. Well, Dr. Huntington say, you can't clean this up with paper towels. And you know, and you didn't hear any evidence of DNA or any blood found on those paper towels, because I guarantee you that would have been the first thing the state led with if they had. But they didn't give you any of that. Instead, they gave you more speculation upon speculation, guess upon guess. They want you to fill in the gaps with your anger and your emotion. That's what they want. And they're hoping that if you talk about maggots, you'll think dead body. Well, you heard Dr. Huntington and Dr. Haskell talk about these insect activity. It's amazing how much information you can get, right down to the time of death in some cases. Well, they had that opportunity on July 16th and would have answered all questions if they had taken DNA from those maggots. DNA feed, if a maggot is feeding on human tissue, it digests it. It can be extracted. And of course, none of that ever occurred in this case. No answers, no answers. Just more speculation and more speculation. Hardest thing in the world is to stand up here and talk about maggots in a case like this. Hardest thing to do is to question about maggots in a case like this. But it's necessary. It's a necessary fact that we have to confront to be able to expose and tell you what the actual evidence is, where the truth lies. And the truth lies that there is absolutely nothing in the trunk of that car that has anything to do with human decomposition fluid. So why? Why are these allegations being made? It's to make up for the lack of evidence, to have you guessing, to have you take that leap of faith into a place where you should not, and you cannot under the law. Now, the next thing the state did is they talked to you about hair. And they had Stephen Shaw, a young man, and Karen Lowe, both from the FBI. I think it's fair to say, by looking at a lot of the testimony that came across in this case, that the FBI laboratory is probably the most advanced crime lab in the country, and that their employees are trained extremely well. That is why they are scientists as opposed to advocates. That is why you saw more FBI people testifying for the defense than you did for the state of Florida. Why is that? Why did we have to call 10 FBI lab personnel for you to hear evidence? Why? If this is a search for the truth, why is important information being withheld from you? And that's because this is about winning and nothing else. Winning a high-profile case and nothing else. It's not about a search for the truth. And that's what you should consider when you look at how some of this evidence was presented to you. Both Stephen Shaw and Karen Lowe would only go so far. They told you that the banding that's found in the hairs that looks similar to this, they cannot say it came from a dead body. And the reason for this is quite simple. The reason is the science is just not far enough for them to know. And something very interesting and unique happened in this case. They conducted a study right after we took their deposition, when we went to Washington, D.C. to take their deposition. Stephen Shaw did his study on environmental effects on hair. Now, you may remember, this is only the second study that was ever done on environmental effects. The first one was done by a grad student out of John Jay College. The second one was done by Mr. Shaw after I took his deposition. Trying to validate their science is not the same as science. This is not DNA. And that's why they wouldn't get on the stand and say it came from a dead body, for no other reason. Because they know it, they know that the science is still in its ongoing phase, and they had similar effects that mimic post-mortem root banding. And what was interesting about this is, even the FBI analyst at the lab got these two wrong. So I guess it all depends on who's testifying in your case as to whether it's post-mortem root banding or not. Well, that's not science. That's not something you can rely on. And what's more important is neither one could ever testify as to how long that hair was in the trunk of that car. Could have been there for years. Could have been there for months. We don't know, and you don't know the conditions. But one thing you do know is that you're only talking about one hair. One hair. And how many times did we have to get Karen Lowe back? We had to bring her back to show you all of the examinations that she did. They took hair from the trunk. They took hair from the trash bag. They took hair from Casey's clothes. They took hair from her home. They vacuumed the trunk of the car. They went crazy trying to find more hairs so they could say, this came from a dead body. And they did find more hairs. You heard her say she tested hundreds of hairs, and only one hair showed something there that could have easily been from environmental effects. Easily. Now here's the thing. There are several things, but if neither one of them individually can actually stand on its own, you shouldn't consider it. They're hoping they throw enough against the wall and see what sticks. That's what they're doing here. Let's throw it all against the wall and see what sticks. Right down to their cause of death. 1 week it was chloroform. Today it's duct tape. Let's make up our minds and say we prove to you that this case was proven beyond and to the exclusion of every reasonable doubt. How can you say that? How? It makes no sense. Then we get to chloroform. I have to tell you, when I first heard chloroform being mentioned in this case, I thought to myself, this has to be a joke.
Sustained.
Chloroform began in this case by Dr. Arpad Blas. And that's how it all started. That's how this issue came up. And what happened was he testified that the reason they progressed was that the chloroform levels were shockingly high, unusually high. You all remember that. That was quite a moment in the courtroom where this forensic anthropologist, not a chemist, no matter how much his buddy Marcus Weiss wants him to be a chemist, he's not a chemist. I'd like to be a race car driver sometimes, and sometimes I drive pretty fast, but that doesn't make me a race car driver. Dr. Voss is not a chemist, but all the other chemists have different conclusions. We had to call the actual person who did the tests. The state didn't call Marcus Weiss because he would have come up here and he would have told you that all they did was a qualitative analysis, not a quantitative analysis. That's huge. That's huge. But what they want to do is have him testify about the levels when there are no levels. You can't determine how much is there because they didn't do that kind of test. So let's just guess. Let's rely on this guy who's selling a sniffer machine. Let's rely on him. But the very next witness from the FBI, a chemist, someone who is educated and experienced in that specific kind of test, came back and said, no, they were low levels, very low levels, consistent with cleaning products. Now you have to remember, these instruments are so sensitive, they can take a drop of water and tell you all the chemicals that are in there, fluoride, chloroform, any other type of chemicals that would be in a drop of water. They can certainly do it from any of these air tests, and that's exactly what they did. If you believe Arpad Blas, you have to believe Dr. Rickenbach was not telling the truth. They're completely different. Their testimony was completely opposites. They were polar opposites, both on the way they practice their science. One is a crime lab, a forensic crime lab that has strict standards, and a research lab that does research. They're explorers. They push the boundaries of science. And that's what Arpad Blas was doing here. Marcus Weiss wouldn't go so far. Although he wanted to talk about how great his buddy was, and I knew he was not going to be a friend of the defense. You saw his testimony. He wanted to be evasive. He didn't want to be straightforward. He didn't want to answer my questions so you could get the answers you need. No. All he wanted to do was talk about how great his buddy was, but one thing he wouldn't do is tell you how much chloroform was in the trunk of that car. Dr. Michael Sigmund, another individual, another chemist from the National Center of Forensic Science, testified that the main compound was gasoline. And they want to say, oh, well, you know, the liner was removed. Well, the air is the air, especially if they're going to test something 6 weeks later. The person who conducted the air test and collected the samples in this case was Michael Sigmund, who is a state expert. He was hired by the state of Florida, not by the defense. He was hired by the state. He was hired by the state. The only defense expert you heard from was Dr. Furton. But we had to call them all. We had to bring them to you because the state didn't do so. They wouldn't. Why is that? Is this a straightforward, straight-up prosecution? Are they giving you everything you need when someone's life hangs in the balance?
Objection to the violation of paragraph 5 of the court's order.
Overrule at this point.
These are things you have to consider, the lack of evidence. You have to consider all of these things and take a look at it and wonder why some of these questions weren't answered. And why were these people hidden from you? Why? Is that justice? Is that a search for the truth? Is that what a citizen deserves in our country, in our state of Florida? Is that what someone deserves when facing trial for their life? I suggest to you that it isn't. And I suggest to you that this lack of straightforwardness is unacceptable. And when the truth surfaces, it hurts a lot more than the single lie. Now, dealing with Arpad Blas, you heard that he had a financial motive. You heard about his patent for his sniffer machine. This device that he's trying to create to sell to law enforcement agencies across the country and even across the world. He has done some research, but he's not the only one. He had a guy in Greece tell you that he agrees with him. Well, we didn't see anybody from Greece testify up here. The other individual who had done a lot of research in this area is Dr. Furton. You heard from him. And while I disagree with Mr. Ashton's characterizations of his testimony, he testified that there is no signature, there are no chemical aspects of decomposition yet. It's at its infancy stage. And this man will be much more willing to take the leap of faith because it hits his wallet. And his too. Some of his designs and some of the work he's doing is great. It's groundbreaking. It's excellent. But that doesn't make it science. That doesn't make it true. You also heard him talk about a thing called divining rods. I don't know if you remember that, but he said you can actually take a coat hanger and find a hidden grave with it. He said that. He said you can find a clandestine grave by going around with a coat hanger, and that it's actual science. Well, if that were the case, what does he need a sniffer machine for? But this is the kind of nonsense, the kind of stretching of the imagination that our pod boxing engages in. Maybe one day he'll be able to sell hangers and patent that idea. But this is the level of absurdity, the desperation that this case, that this prosecution will take it to. They'll take it to the next level. They'll ask you to see things that aren't there. And they'll ask you to imagine fictional science. It's a fantasy of forensics, is what it is. A forensic fantasy, and nothing more. We have the most advanced crime-fighting tools available to us anywhere in the world. And they couldn't find a single link from Casey to Kaylee's death. Not a single link. But yet they want to create things. For what? The cameras? Because it's a high-profile case? No, because it's about winning. Win at all costs, no matter how much it costs, no matter what it costs.
Counsel is violating paragraph 5 of the court's order regarding derogatory comments against counsel.
Sustained. Let's move on.
Now I want to take you to what I think the evidence showed in this case, where it reached its most outrageous level. And that is the computer searches. The state of Florida took this approach. This gentleman, Sergeant Stenger, a police officer, did in August of 2008 using a software called Net Analysis. He did a report, and his report came out. And this was on the main issue in this case, the chloroform. They were looking for chloroform, and they got it. Okay? They've got it. And this report comes out showing the size spot one time, one visit. But something really odd happened at trial. Sergeant Stenger didn't testify to his report. In fact, he goes to a seminar a year later and tries out this new software called Cashback. So what happens? He can't get Cashback to work. And he tells the owner of the company, a guy from Canada, hey, I can't get this thing to work. I've got this high-profile case, and I need this to work. So as you heard Mr. Bradley testify, that he stayed up 3 nights trying to get it to work. 3 nights, and finally he got it to work. And they come back with 84 searches for chloroform. Now what was odd, when I saw that, it was a jaw-dropping moment for me. And it was a jaw-dropping moment in this courtroom, because I know I couldn't have missed that. What? And I went back, and we looked back, and we finally realized the net analysis report. This man not only testified falsely about what was there, he testified about somebody else's report, Kevin Stenger. And you'll remember when I asked him about this report, he said, this is not my report. And I asked him, can you testify intelligently about anything in Sergeant Stenger's report? And he said no. He said no. This report that's in evidence, and you'll take it back with you, States Exhibit 166, was done Friday, June 3rd, 2011. You had already been jurors in this case, and he does this report. And the state of Florida calls this man to testify after this report had been done in August 2008 with an established piece of software saying something completely different. This is fraud. This is trying to pull a fast one.
Objection again to violation of paragraph 5 regarding
Sustained.
comments. Move to strike.
Motion to strike granted. Duly instructed to disregard last comment.
This is not true evidence. This is not true evidence. This is not the truth. A human life lies in the balance. You're being asked to make the biggest decision of your life. You're being asked to take someone's life if you feel the evidence deserves to be. And this is the type of evidence you're given. I suspect that when the prosecution gets back up, they'll ask you, or they'll tell you should rely on the lower number. Because this is the true number. And you know this is the true number because of the progression that we showed you. This was Facebook. 84 times was Facebook. I'm sorry, MySpace. MySpace was just 2 levels up. MySpace is not even on this report. How did that get missed? And I showed you, and when I called the man who wrote the report, we called him to expose it to you, to expose the truth. Why, when the defense has no burden under the law, does the defense have to call witnesses, police officers, to testify and to tell you the truth, to bring the truth to light, so you can see and you can render a just verdict? This is outrageous. And you will see in Defense Exhibit 45 the progression of when someone typed MySpace in 84 times, 83, 82, and you see the progression. You see no such thing on this report. You don't even see MySpace. This is their premeditation. This is their murder case. And Mr. Ashton gets up here and says, we can only hope that she issued the chloroform beforehand. Hope? They weren't asking you, they're hoping they're going to get a conviction now? They're hoping that you'll buy the chloroform? They're hoping? You're not supposed to hope. You're supposed to prove cases beyond and to the exclusion of every reasonable doubt. Where do they get this stuff from? How can they ask you this, to do this? How can they come forward with this evidence, this junk that doesn't even work? And why wouldn't they have him do a report? He's the creator of the software. Why didn't he issue a report? Why? He's in Canada now. Nobody's going to prosecute him for perjury. This is a police officer who works here, and he didn't say a word about this report until we called him and had to show you that there are no such searches of being 84 times for chloroform. The extent of the computer is this: 3 minutes worth of time, 3 months earlier, that have nothing to do with this case, and everything to do with the MySpace posting. The MySpace posting of Ricardo Morales. You heard evidence, ladies and gentlemen, that Ricardo Morales posted this on his MySpace at the same exact time that he was dating Casey Anthony. He also testified that he was dating her in March. March is the same exact month as these searches. If you don't know what chloroform is, and your boyfriend is posting things like this on his MySpace page, it beckons the curiosity of what exactly that is, especially to someone who's young. What is that? Is that true? Can that actually happen? It's not unreasonable for a young woman to decide to research something like this based on what her boyfriend is posting. And wouldn't you know, what is the first search before the very first chloroform search is? MySpace. Exactly where he posted it. MySpace. Now, then there comes the issue of Cindy Anthony. Well, we all knew Cindy Anthony in 2009 testified to doing these searches. We all knew that, both the state of Florida and the defense. That was something you needed to hear. And what the state of Florida decided to do is then go out and spend their entire rebuttal case to prove she's a liar. Well, I told you she was a liar the first day. I told you how this family lies. That has been clear throughout this case. Throughout this case. But there's one thing you can't deny, and that is MySpace goes right before the next Google search, how to make chloroform. This is not true. This is misleading. And Ms. Jane Burdick, when she questioned Cindy Anthony on the stand, she said 84 5 times. She kept questioning her. 84 times you searched for chlorophyll? 84 times? When this report was in existence. Why? How could she do that? How can that evidence come before you? How is that truth? That's why you have more questions than answers. That's why situations like fantasy searches, fantasy forensics, phantom stickers, phantom stains, all of this nonsense. And no real hard evidence, no DNA, no fingerprints, nothing. But she's a liar and a slut. Convict her on that. And she lied. And she didn't act the way she needs to. She made some stupid decisions, but let's make her pay with her life. That's what this case is about. An accident that snowballed out of control. And it's out of control. It's out of control right now. And it has been out of control since the moment this trial began, since the moment this case began. It's out of control. And it's true. Casey made some bad decisions and started this. But it doesn't have to be continued. It doesn't have to be presented this way. This case does not have to come out this way. The truth stops here. The truth starts here. The nonsense stops right now. It should have stopped the moment you all raised your hands and chose to be jurors in this case and took that oath. Every single thing, all of that nonsense should have stopped, but it didn't. And this is what they want you to render a verdict. This is sufficient reasonable doubt, ladies and gentlemen, for you to say, you know what? I don't trust this evidence. This is proof, conclusive proof that I don't trust this evidence. And on something so serious, when the law says I can reject part of it or I can reject the whole thing. It's just like there's an old legal adage that says if you go to a restaurant and you buy a meal and you find a bug in your meal, you don't take the bug out and continue eating. You send it back. to send it back. Something as so serious as your health, you would never risk that with. Now those are types of situations. That's in the situation you're right here in now. A situation so serious that when you make that decision in the jury deliberation room, it is irrevocable. You can never take it back. You can never say, oh my God, I made a mistake. You can never say, can I change my mind? Can I take that back? No, it's done. It's done. These types of decisions of reasonable doubt, that's why we have that standard. If this were a financial sheet and you had your entire life savings and you're about to retire and you say to yourself, I'm going to invest with this man because he's giving me great numbers.
Sustain. Motion to strike granted.
These types of decisions are life-changing, unchangeable decisions. And this type of evidence is reasonable doubt. That stain that never was is reasonable doubt. All of these aspects, the way this was presented to you, is all reasonable doubt. And here's the thing. If you don't know what happened, that's it. If it wasn't proven to you that it happened, that's it. It's over. It's not guilty on every count. Only the ones that were proven to you beyond and to the exclusion of every reasonable doubt come back. That's it. That's what our law is. And all the emotion and all the anger can never change that, because it works the same for John as it does for Jane, as it does for Casey. That's how we have our society. Those are the laws we have chosen, to make the law equal for everyone, equal justice under the law. That's what we have. And you've got to follow it. The law is your guide here. Not myself, not Mr. Ashton, not Mr. Rain Burdick, the law. And the law will guide you, and it already has been, and will in the deliberation room, that this is what they must prove. Not anything less, because we will not accept anything less. The fantasies continue with the Phantom Heart sticker. Where in the world did this come from? This is outrageous. A young, very eager FBI analyst, Elizabeth Fontaine, sees something on the duct tape as she's examining it. Something in the outline of a heart appeared on the corner. Okay? That certainly deserves looking into a bit further. Well, they then recover 30 feet away. You recall Murdoch, Mr. Murdoch, who processed the scene, had his computer with a computer program, and we called him to show you how far away this was found. And this looks nothing like the stickers were found at the home. Nothing. And this child had all kinds of stickers in her house. You're not going to find a small child like that without heart-shaped stickers in their home. There were also Mickey Mouse stickers. There were also Goofy stickers, all kinds of other stickers, a scrapbook that was used by Casey to document her child's life. And they tried to sell you that this thing found in an area where trash is dumped, okay? Trash is dumped there, 30 feet away, across the street from an elementary school. How unusual, how crazy is it going to be that you're going to find a sticker attached to a cardboard, not attached to duct tape, 30 feet away? But that doesn't matter, because if you remember, the prosecutor, when they got up, their next question was, wouldn't you agree that this area was a trash dump? Playing on that anger again, playing on your emotions, trying to get you angry and say, yeah, that heart sticker was there. Well, why did they hide her from you? Why did the defense have to call Lori Gottesman? You remember, she used the VSC machine. She's a document examiner for the FBI that showed us all the different things that they do to find and uncover things with documents and things like that. And she saw no sticker or sticker fragments observed on any of the items. None. It didn't exist. It has nothing to do with this case. This has nothing to do with this case. But if you lie on your anger, if you rely on your frustration, your desire for blood, then yeah, maybe you can make this square peg fit through the round hole. Maybe if you squint your eyes hard enough, that sticker looks a little bit like one of these. This is outrageous. This is the quality of their case. This is the quality of the evidence put before you. But that's all that, these are some of the things that we were only be able to uncover. If this investigation was focused, open-minded, not just arrest her within 24 hours, we'll get the evidence later. That's what happened here. She was arrested within several hours, arrested for child neglect. And they went out and got the evidence later. Okay, bring that car over here now. Forget all 7, 8 cops who were there that night. Today it smells like a dead body. Forget everybody who saw it and smelled it, but today it smells like a dead body. Let's get rid of the trash, because we don't want anybody thinking this was trash, this smell. They're going to be this sneaky with this type of evidence. How much can you trust the rest of them?
Objection, violation of paragraph 5.
It's not a violation of paragraph 5.
Sustain.
Let's stretch the truth here a bit further. How is this even presented to you? How does this even What about all the beer bottles found next to the sticker? Why weren't they presented? What about, well, maybe we could dust those bottles for fingerprints and see who the killer was. Why not? It's just as reasonable. It's far away, but it doesn't matter. It was out there. That's the kind of evidence that you have to render your verdict on. And then we come to Dr. Jan Garavaglia, the medical examiner. She told you that she did an autopsy on the remains. This child had no broken bones, no evidence of prior trauma, no evidence of trauma at all. And she did it, and she sent out all of the toxicological exams that she could to try and make this case fit. They all came back negative. You heard the test for chloroform, negative. The test for Xanax, negative. All of these other drugs, negative, 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 negative. Cause of death, unknown. And that's where the science ends. That's it. And that's where we are here today. How did Kaylee die? You would think that you can get a medical examiner to come and talk to you about medicine, about science. She has a little leeway with the manner of death. They want to tell you it's a homicide without telling you how. Why is it a homicide? Well, because I said so. Well, these are her 3 reasons. The injury was not reported to the authorities immediately. You don't need to be a doctor to know that. The body was hidden in a wooded area. Well, you don't need to be a medical examiner to do that either. Duct tape appeared to be applied to the lower face. Appeared. You don't need to be a doctor to know that, to render that opinion either. These are all opinions that have nothing to do with what this woman was trained to do. Nothing. Absolutely nothing. A person on the street riding a bicycle could give you these same facts and say the same thing. This is not science. The science she used was straight up, they can't establish the cause of death. And everything else came back negative. Everything they suspected, and as Mr. Ashton said, everything they hoped for was not there. And you remember, Fury Melich got up here, and he testified to you, we did 3 search warrants on that house. We found no printing paper. We have found no paperwork having anything to do with chloroform. We found no receipts for purchases of chloroform. There were no purchases for chloroform found on this computer. They didn't find any chemistry kits. They didn't find any containers containing chloroform. They didn't find any ingredients making chloroform. They didn't find anything whatsoever having to do with chloroform. Nothing. But they're hoping. Let's hope. And Dr. Garavaglia gives you this. Well, if that wasn't enough, of course, you had Dr. Schultz, whose real purpose was to tell you and to get you more angry about how her remains were treated afterwards. But he did say no trauma to the bones. Mr. Fantasy Man, Dr. Warren, who for some reason showed you a video of a smiling Casey and a smiling Casey with some duct tape that he got off the internet. He Googled it, got that photo, stuck some duct tape on it on Photoshop, and there you go. There's your new murder weapon of the week. That's how she died. Well, that's not evidence. And he himself said, the only reason I suggested is that to show it could have happened. Well, she could have been shot, but they don't have a video of her getting shot, even though they could have done one. She could have died any number of ways, and they didn't show you videos of that. He was up there being an advocate, not a scientist, and showed you that video for one reason and one reason only, and you know what it is. Dr. Schultz testified to the same thing. But Dr. Schultz didn't have the same opinion as Dr. Garavaglia. Dr. Garavaglia said it was homicide. He had no opinion on either one. She jumped in because this was a high-profile case. He was the first medical examiner, board certified, fully capable of handling this case, but yet she's the big shot, and she comes back into town and takes over. And because of her relationship with the media and law enforcement. That's it. The politics at the medical examiner's office played out in this case, and you got to see it with these two. We presented to you, and we were fortunate enough to have one of the most experienced medical examiners in the country, Dr. Werner Spitz. And Dr. Spitz did a full autopsy. They can say all they want. And if Dr. Spitz had not found anything, that would have been a different story. But he did. He found actual physical evidence, physical proof that Kaylee's remains were not found and did not decompose in the manner in which the state or Mr. Kronk tried to tell you that they were. Those photographs are not indicative of how Kaylee decomposed and where she was and what position she was in. This is the physical proof. The semantics of was it dirt, was it brain matter? I think a man who has 60,000 autopsies under his belt, the man that our country turned to for the commission for President Kennedy and the Reverend Dr. Martin Luther King, that man, I would tend to believe over an anthropologist. I think that that's his qualifications.
Counsel expressing his personal opinion.
Rephrase it,
Sustained.
Judge. You can look at his qualifications and decide for yourself. You can look at whether he's more qualified than Dr. Garavaglia. And it's quite obvious, he is. What Mr. Ashton tried to do when cross-examining him was not question him on his science. No, he wanted to question him on the facts. He wanted to question him on how much of the police reports he had read. Well, the police reports didn't do the police didn't do the autopsy in this case. They might have for Dr. Garavaglia. They might have influenced Dr. Garavaglia. But this is a man of science who actually did a complete autopsy to check, to see what exactly could have happened to Kaylee. And he did say one other thing. He did have one very important finding. He told you that when you open up a skull, and if a person has died of suffocation, there is a discoloration in the back of the ears. That was not in this case. He testified to that. And he told you that it doesn't always happen, but it certainly wasn't in this case. Well, that also eliminates one of the state's theories. It's actual physical evidence. It's not hoping. It's not guessing. And it's certainly not something Dr. Garavaglia did when she botched this autopsy. Why not open up the skull if you're trying to get to the truth? Why just look through a little hole and think that you can be able to determine what's there, when obviously there was something there that was relevant, something there that could help you, that could explain to you, this isn't the way they're saying it is. You have to ignore this completely if you buy their duct tape theory. He tried to Mr. Ashton tried to get him to talk about things outside of science. Well, explain to me how someone could put the duct tape on there. There's a million ways. It doesn't necessarily mean a person did it. You've heard people referring to this area as a swamp. You've heard the state say it was underwater. Well, water is going to move around the duct tape. You also have the issue with Mr. Kronk. Rolling skulls dropping out of bags, they're outside of bags, inside of bags. What's going on here? You have all kinds of different things, and you also got to see the photographs of the duct tape lying flat on the ground, and then at the medical examiner's all the way there. Now, initially you might say, well, that's a leap. I can't believe that evidence would be manipulated that way. But I think we've seen through the course of this evidence that that's not so far-fetched. Is there evidence of it? No, I won't go that far. But it's certainly a possibility. And if you're going to entertain fantasy forensics and other possibilities of the state of Florida, you can certainly entertain that. But we will not ask you to do so. We think you need to rely on actual physical evidence, actual true evidence, not nonsense. Something you can see, something you can look at and know exactly what is true and what's not. Not some fantasy. Now I'd like to talk about the defense case a bit. And the judge is going to instruct you that this is the law. I've told you, I've repeated it many times, but he will tell you that the defendant is not required to present evidence or prove anything. And that's simple. It's a constitutional guarantee afforded to every citizen, every single one of us, no matter who we are, no matter how much money we have, no matter what position we hold. We all share this inalienable right. This is a right of ours. And despite any overtures that we must do so is completely untrue. And you will have the opportunity of the law to guide you in that area. And that's what Judge Perry is going to tell you. Now, I told you in the beginning of this case that Casey reacts the way she does and lies because of the environment she was brought up in. The dysfunctional family, the secrets and the lies. And I told you about this photo. I showed it to you in opening. And you heard it testified to numerous times in this case. George says she looked this way because she was working out a lot. Cindy said the complete opposite. She was sedentary. She had even stood here and looked over at Casey, could clearly see she didn't look like this, and asked her to turn to the side. Turn to the side, I can't see. I don't think you can believe that they didn't know she was pregnant. And I don't think you can deny Lee Anthony's powerful testimony. The only member of the Anthony family that didn't get impeached in this case was Lee Anthony. And Lee Anthony said it straight. I confronted my mother about it, and she told me to let it go. Forget about it. You saw how hurt he was. The bizarreness of that entire situation you heard about. The lies that were testified to up on this witness stand by both George and Cindy Anthony are clear. They took an oath. Everyone in this courtroom, in this process, has taken an oath. My colleagues, myself, the judge, you guys, and every witness who took the stand. And any witness who gets up there and tells a lie does not have the right to violate that oath. Does not have that right. And you can reject their testimony. You can reject it all. It's like that plate of food. The state wants you and talk to you during a closing argument about the 30 days and all of the things that George and Cindy did. Well, mainly Cindy. In fact, George didn't do anything. You heard about that. But you heard of all these stories about what Cindy said. But by the end of this case, they're impeaching her. They want you to know she's a liar. But please believe what she said for us. That's what they're trying to, those are the goods that were being sold here in this trial. Believe her when it's convenient for us, but don't believe her in others. That's unacceptable. That's not truth. And that's not what you render a just verdict on.
All right, everybody, we are going to take a brief, I guess you can call it a lunch break. And we'll try to be back by 1:45. All right. So right in the middle of closing arguments, I'm sorry to do this, but it's going to keep going for a couple hours. But so far, I mean, Baez is really, really good, as you can all see for yourself. He's really good to see how the prosecution deals with all this closing argument. But anyway, all right. So we'll see you soon. All right, everybody, we are ready to continue. I know it's a little bit before 1:45, but got a lot to get to, so let's get it rolling.
Casey has issues, and these issues were there long before Kaylee was ever born and long before June 16, 2008. I want to show you the world that Casey Anthony lived in, that you heard testimony in this case. You remember her imaginary friends. We had Zanny the nanny from 2006. She's a perfect 10. She used to date Jeffrey Hopkins. Remember how much amazement Mr. Ashton found and how she could remember these things? She has long black hair, but got it cut several times over 2 years. She has a beautiful smile, straight white teeth. She drives a Ford Focus, and her family is wealthy, and they come from New York, and the Carolinas, and Miami. Jeffrey Hopkins, the trust fund baby. He also appeared in 2006. He's a couple years older than Casey. He worked at Nickelodeon, and he had a child named Zach. You may recall the Anthonys invited him over for barbecues numerous times, and he never showed up. You had Zachary Hopkins, his son, who used to play with Kaylee. You had Samantha Fernandez, Zanny's sister, and Gloria Fernandez, her mother. You may recall I asked how Cindy talked about her having heart issues. And then, of course, you have Juliette Lewis, who was Zanny's roommate. Now, you may recall Cindy testifying that her and Casey sat in the parking lot of Universal Studios for an hour and a half, waiting for Juliette Lewis to appear. Can you imagine an hour and a half sitting in a parking lot talking about this girl that's going to appear who never shows up? Not 10 minutes, not 20 minutes, an hour and a half. It's like going to the movies and sitting there and waiting. And she never appeared. And this has nothing to do with Kaylee's death. This is something that just doesn't add up. This is something that's just not right. This is the world that Casey lived in. Juliet had a daughter named Annabelle. Cindy knew all about Annabelle, Kaylee's playmate. You heard about Raquel Farrell, another roommate of Zanny's. She worked at Universal too. Eric Baker, who could have been Kaylee's father, but he died in a car accident, in a motorcycle accident. And Kaylee has a stepbrother somewhere in Kentucky. Her fictional bosses, Tom Manley and Thomas Frank, event coordinators at Universal Studios at Extension 104, which does not exist. Her office at Universal Studios that does not exist. Her office that she took police officers down the hallway, to the left, across the street, and got there, and she couldn't go any further. It's at that point, at that moment, that the police should have seen and realized there's something wrong with this girl. This is not just someone lying to cover up a crime. We need to handle this investigation in a different manner. If you found a drunk guy on the street who just lost his job and he's staggering all over the place, you don't treat him the same way you would someone who's completely sober. You realize as a police officer, you have to take a step back and you have to be a professional police officer and deal with individuals who have issues as well as individuals that do not. This is what they do on a daily basis. And all the signs were there. Everything was there. Everything she was saying just didn't add up. And Mr. Ashton says, well, she didn't get a chance to carry this on or take off. Casey had plenty of opportunity to hop on a plane and go. She could have told George and Cindy Anthony, you will never see your granddaughter again, end of story, and been done with it. That's a lie. Those are actions consistent with guilt. Those are somebody fleeing the jurisdiction, not someone with an alibi that has an expiration date on it. People weren't going to just stop asking for Kaylee. That wasn't going to happen. This world here, you wonder why this case got so crazy. And you look at the situation here, you look at the facts here, and the world that Casey lives in, and you realize that if a person lives in this kind of world, these facts make more sense. This cover-up makes more sense. These unhealthy coping skills make more sense. That's what Dr. Karyoff was telling you. If you're a healthy person and you've got a sound environment, you will be able to grieve. Although everybody does it differently, you will be able to grieve and get some semblance of life. But if you have issues, if you don't have a healthy environment that you live in, it can go to all types of extremes, which would include going out dancing, which would include lying, which would include this fantasy. All Casey was doing, if you look at the situation, is continuing what she knew best, where she felt safe. Remember what Yuri Mellet said and put in his police report? She went somewhere where she felt safe. That speaks volumes. It speaks volumes in this case. I'm not proud of the way Casey behaved. I don't think anybody here can justify her actions, but they do not constitute murder. And you can take a look at this world and understand a little bit better. Understand where it all comes from. You understand the why, as opposed to the state's theory, where she's a loving, wonderful mother one day, and then I'm going to go party on a Monday afternoon, even though there's no party or no club to go to. Even though Tony Lazzaro said he liked Kaylee, he enjoyed being around her, that this was her motive, that's nonsense. That's absolute nonsense. Yes, at first glance, you would say Casey's lies are nonsense. But when you look at it in this perspective, you look at it through the whole picture, you understand that it's not nonsense. It's not right. It's certainly not right by any standards, but it makes sense. It makes a lot more sense. She now wants her freedom? Is that what you do to get freedom? You kill somebody? That's outrageous. That's nonsense. Nobody's going to come looking for little Kaylee? She's going to get to party every day and every night? That's nonsense. That's complete and total nonsense. She had no motive. Casey treated Kaylee well. She loved that child. And not a single person, despite the thoroughness, despite using every law enforcement agency available to them, they couldn't find a single person to come in here, take that stand and say, you know what? Casey was a horrible mother. I saw Casey strike Kaylee. I saw Casey do this. I saw Kaylee do that. Casey do that. I said, you heard Tony, the guy who enjoyed her being around, and you heard him say something else. Remember the time where he said Kaylee was running to the pool and how Casey had to run and stop her? Everywhere you look at, there are signs of what actually happened to Kaylee. And that was a perfect example that Kaylee loved the pool. Casey was as protective as she could be. And on that occasion, Casey stopped her from drowning on that day and running into the pool. Obviously, she would have been there and could have saved her. But that's all you heard. That's all the evidence that was presented to you. That Casey was nothing but a good mother, despite their best efforts to parade as many of her friends up here and shot girls and everybody said the same thing about Casey. She was a considerate person. She was a kind person. She treated me with respect. She cared for others. This is not consistent with a person who's a murderer. This is not consistent with a person who engages in child abuse, aggravated manslaughter. None of that makes sense. And the reason it doesn't make sense is because it's not true. The reason you don't have that evidence that they're desperately trying to find is because it's an unprovable case, because it's not true. That's why, despite all the efforts they tried, they couldn't give you the answers because they're not true. Now, I used an example during my opening statements of what I told you was going to come out in this trial, dealing with Kaylee in the swimming pool. You heard, as the evidence was presented in this case, that Cindy and Kaylee went swimming on June 15th, the day before, the night before, June 16th. And I told you, I don't know if Cindy's going to admit to leaving the ladder up. Well, she didn't do that. She says she took it down. But thanks to the state of Florida, they got to show us how truthful Cindy Anthony really is. How much guilt would she have knowing that it was her that left the ladder up that day? The denial that she must be in, the denial that she displayed when she testified in this case 6 months earlier, that she thought Kaylee was still alive. Remember that. They had a memorial, they televised it, they held it in front of the world, and then they cremated her. And then she comes in here 2 years later and says, I think Kaylee's still alive. Well, I understand why she said she took the ladder down that day. But what's important too is you remember that door. You remember this house had no safety locks, had no child safety locks, and Kaylee could easily open the door. So if she can do that, if they were that neglectful in that sense, you can understand how the ladder would probably be brought down. Sometimes, sometimes not. Now, you heard Cindy say that on the 17th, on the 17th of June, that she goes to work and actually tells people, someone's swimming in my pool. Why would she do that? That's an odd thing to tell your coworkers, isn't it? Someone's swimming in my pool. I saw the ladder up. We're always very sure. What are the coincidences that she would go in on the 17th and talk about the day Kaylee dies and says, someone was in my pool yesterday? And this happened long before the police were called. This is not a fact that you can ignore. You heard both George and Cindy talk about how she could get out of the house very easily. In fact, we ended up showing you proof of it, which is in evidence. And you heard George testify that Kaylee would wake her up in the morning and say, "Jojo, swim, Jojo, swim." This is a child who loved the swimming pool. That door had no safety locks on it. She could get out quickly. She could get out easily. And if for some reason she wasn't being watched that day, that morning, when both Casey and George were home, something happened. Kaylee's reported missing on July 15th. The very next day, actually within 24 hours, Cindy tells Detective Melich about the swimming pool. You remember that when I questioned Detective Melich, he said that he was getting calls during the Universal Inquisition when they were in the Universal Studios conference room with Casey. You heard the tape. And he left the room because Cindy was calling him left and right, desperately. And he spoke to Cindy, and Cindy told him about the ladder and the swimming pool. And he didn't, and the shocking thing that you may all remember is he had the opportunity to go back in there and ask Casey, "We know what happened. Tell us about the swimming pool." And he never did. He never investigated this case as an accident. Never. He never pursued that. And that's why this case turned out the way it did, partially. Because law enforcement didn't want to keep their eyes open, didn't want to look at every possible alternative, didn't want to consider that there was something wrong with this girl. Instead, they had a murder case, and that was it. That was all they were interested in, was evidence of murder. There's nothing sexy about a drowning. There's nothing interesting about a drowning, and they didn't care. Now, we were able to uncover something that was highly unusual, and that was finding an actual photograph of Kaylee opening that sliding glass door. Everyone has hundreds of, most parents have hundreds of pictures of their kids. But how rare is it that you would have one of her actually opening the door? But we found one. This child was heavily photographed. She was loved. Casey took hundreds and hundreds and hundreds of pictures of Kaylee, even in mundane little moments like this. This was her precious child. There's the proof that she could easily get outside. There's the proof that she was big enough and strong enough to open the door. You can't get anything better than that, short of a video of what happened. And if that wasn't enough, we were able to find photographs of a year earlier of how easily Kaylee could get up the ladder. And what's so odd about this is you can see how often she was photographed. Every little moment, captured. And look at how soft Cindy is holding her or touching her. She's on her own. And look at what Kaylee's doing. Kaylee's diving into that water. This is what she loved to do. This is what she wanted to do all the time. And you can discount Cindy Anthony's testimony, but these photographs tell the truth. There are documented moments in time that do not lie and clearly show that there is a reasonable hypothesis of innocence. It is reasonable that if there are no child safety locks and she could get out, and you had the incident with the ladder the day before, and Cindy was swimming the night before, it is extremely reasonable that she could have drowned in the pool. And that's where the state fails. They must rebut each and every reasonable hypothesis of innocence. They cannot rebut this. They can't do it. It's impossible. They can say all they want about chloroform and duct tape and where the duct tape was or where it wasn't, whatever they want. The issue here is, how did she die? That's why, again, we're back to that one question. How did she die? Where did she die? Did they present one single piece of evidence as to where Kaylee was when she passed away? Zero. When did she die? Why? Because she want to go party? They want to give you the who without the where, the how, or the why. It's impossible. This case, if you look at the law and you look at the facts, is relatively easy for you to decide. It's a tough decision to make because of the seriousness of it all. But factually, it all makes sense. And this is the only explanation that makes sense. And it makes sense because, as I said from the very beginning, it's not the commonality of the tragedy here. It's the uniqueness of who it happened to. And that's why we're here. Because these people are different. This girl is different. And this is why she behaved in this way. And this is really the only rational explanation of all of this madness, of all of it. And that's because this is what happened to Kaylee. And the moment that the state failed to rebut this, and they did because they didn't present any evidence to rebut it, it was an impossible task. As you know, Dr. Garavaglia said, cause of death, unknown. That's it. They have the right and the ability to charge her with whatever inappropriate acts she may be guilty of, but they do not have the right to overcharge her of murder or manslaughter or aggravated child abuse when there is no such evidence of it. Improper disposal of a body, whatever they want, none of these crimes are before you. None of them, except the most serious, the ultimate penalty, all of these things. And I think you all know the reasons why. We've lost our senses here. Now, I want to talk about the duct tape now. And it's strange how you would have one piece of evidence that can tell you so much. Actually, two pieces of evidence that say so much about what may have happened here, and so many lies that surround it. Did you get a clear answer from George Anthony as to the gas cans and the duct tape? You can ask yourselves that. You can ask why he made certain statements. You recall Linda Tonelli, the woman who worked at the command center and said George used duct tape. He brought duct tape to the command center. And I'd like to re-show you this video if I can before we go any further. Gas cans and duct tape. Look at that duct tape. It's right there, almost the whole roll. And Mr. Ashton was correct when he said this is rare duct tape. This hasn't been sold since 2007 and was in very little quantities. You probably have never seen duct tape with a logo on it. It's always gray and silver. But you may recall when shortly 10 seconds after playing this video, George Anthony took the stand. And I asked him, where'd that duct tape come from? And his answer was, I don't know. There were a lot of people at the command center. Could have been anyone. He wouldn't even admit that that was his roll of duct tape. Completely denied it. Even denied the location of where this video was taken. You heard the judge enter in a stipulation into this case by both the prosecution and the defense. We all agreed it was at that location, at that time, manned by this person, and he got up there and said, nope, it wasn't there. It was at another place. He can't lie at all. He can't tell the truth at all. And he's confronted right there and then with this duct tape. But he wants to pass it off on somebody else. Then we have this issue with this photograph. Now, I'll bet you remember the first time I cross-examined him on this, I had some issues because it was the state's case and the photograph was not entered into evidence. The state did not use George Anthony to introduce this photograph. So when I cross-examined him, I was shut down.
Objection, Your Honor.
Sustained.
Strike fine.
Motion to strike granted. Disregard the last comment.
He was not cross-examined on this topic. But he said something very interesting. He said, sir, that photograph you're showing me, I was shown other photographs during my deposition. That was not this gas can. You remember we got into the whole debate about the different, is it the round cylinder one? Is it the old one, the one you've had for 20 years? And then when it was our case, and the photograph was now in evidence, and I showed him his deposition transcripts, he went and looked at all the exhibits, and then said, yeah, that's the one they showed me during my deposition. But he told you under oath that he was shown some other photograph, not this one, and played all kinds of games with this gas can. This is not a game. This is not a game at all. But yet he lied to you about this gas can. George Anthony lies when it's convenient for him. He lied to Mr. Ashton when he was taking his deposition. You may recall, during Mr. Ashton's testimony, during Mr. Ashton's cross-examination, he said, you remember we sparred during the deposition? And I impeached him on this actual testimony, where Mr. Ashton said, but it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent. And George said, didn't have any duct tape over the vent. And when it came back to me, or at least the last time I saw it, now it had duct tape on it. And I didn't put it on there. But is it your testimony here? Under oath, Mr. Ashton has to remind George Anthony, he's under oath, that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on the can. Please answer out loud, yes or no. It was not on the can. It was not on. Lying. Here's the photograph. August 1st, 2008. The duct tape's on there. But when he's sparring with Mr. Ashton, it's not on there. Cops must have planted it. Why is he lying about that duct tape? Why? He knows that he's the only one connected to the duct tape. He knows that he's caught on video by the media, hidden behind the donation jar, that duct tape was his. And you heard Cindy Anthony testify that George was the only one that had a roll of duct tape. And we get back to June 24th. Why is he reporting this gas can missing? Why is this gas can so important to him? The only connection, the only direct link to Kaylee, to her remains, is this duct tape. Yes, you have other items, but the only one that it ultimately connects to is George. If this is their murder weapon, as they claim, they can't hide behind the duct tape. It only connects to him. Casey's in jail she's been in jail for 2 to 3 weeks before that entire roll of duct tape is photographed by the media. Look at these facts, look at these events. The 24th, he issues a police report and reports him missing. The 15th, she's reported missing. He doesn't say a word about this alleged argument. Remember the argument over the gas cans in the trunk of the car? Here's your fucking gas cans. Well, on the 17th, a detective goes and inspects the shed. It doesn't say anything about that. Hey, you know, by the way, I had this fight with my daughter. She wouldn't let me near the trunk of the car that smells like death. And here are the gas cans. Why don't you take them and fingerprint them? He doesn't say a word about it. It's not until near August 1st that he tells them about it, and they collect it. And they take this photograph. Then the first week of August, he's photographed by the media inadvertently, and all of the duct tape's the same. We're not talking about fantasy forensics anymore. We're talking about cold, hard evidence. Evidence that points to one person, and one person only. And he can get up here and lie all he wants, and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here, or whether it's myself. Objection.
Approach the bench. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. During this recess, I took an opportunity to go and view the video of the segment that Mr. Baez was talking and Mr. Ashton's reaction and Mr. Baez's corresponding response. Needless to say, that response on behalf of Mr. Ashton and Mr. Baez violates this court's order. Now, if both sides would like to take the time to go look at it,
let's just get on with the
and you can look at it. And then I will proceed to do what I'm going to do. Because I, with the state order of defense, wish to have an opportunity to view the video clip.
So apparently the prosecutor, Mr. Ashton, was smiling and laughing at Jose Baez's closing argument. So he made that comment about this laughing man's thing, and he pointed to the prosecution. So that's where everything kind of went off the wire. So apparently they both violated the court order, because the court order was, you can't have those type of reactions to the other side when they're doing a closing argument. You're supposed to sit there like a poker face.
Okay, court will come to order. Both sides had an opportunity to view the video clip.
I'm just going to go ahead to the closing.
Thank you, Your Honor. As laid out throughout the course of this trial, this duct tape only points to one person. There's some doubt here. There's some issues here. There's some things that just do not add up. There's also something that you learned towards the end of the defense case, and that is the way the Anthony family had buried their pets. It's odd. It's different. There is a pattern there that each member of the family testified to, except George, again, had a little amnesia. George, the person who actually does the burying, who does all the work, seemed to forget, but yet Cindy and Lee clearly remembered. Why, instead of rebuttal of impeaching Cindy, did we not dig up that backyard? Why did George Anthony never tell police about the way they buried their pets? 3 years go by, and there's no mention of it. There's a chance to save his daughter's life. Mr. Ashton said, why would someone use 3 pieces of duct tape? Well, you recall Mr. Murdoch testifying that one was found 6.5 feet away. You recall seeing it attached to the hair of Kaylee, which would be the top portion near the top of the bag. There's any number of scenarios of what could have happened in 6 months. There's significant movement of bones where the state clearly brought out one was found under 4 inches of muck, as they described it. That can move, but a piece of duct tape can't. I submit to you, ladies and gentlemen, that that's not reasonable. And it's also not reasonable to accept the constant lies and unique circumstances surrounding George Anthony and this duct tape. Now, I told you from the very beginning, I am in no way, nor are we in any way suggesting that George Anthony killed Kaylee. There's no evidence of that. There's no evidence of any murder in this case. And that has been our position from the very beginning. We would never point the finger at someone that doesn't support any evidence. This was an accident that snowballed out of control. Whatever happened afterwards has nothing to do with the crimes charged. They have absolutely nothing to do with that. Mr. Anthony has, on numerous occasions, had the opportunity to come up here and tell the truth about these items. But given every single opportunity, he lied. He was impeached by the prosecution during the deposition. He was impeached here. He played games with the photograph. He danced around the truth and just refused to be upfront and honest. There's one thing you can see in George Anthony, and that is that this man doesn't have an ounce of paternal instinct in him. Not an ounce. Where he got up here on numerous occasions and almost with a bit of joy testified against his very own daughter. I don't know a father in the world who wouldn't fall on the sword for his child, who wouldn't attempt to try and protect her from the jaws of death. But not George Anthony. Even Cindy Anthony tried, and you saw that. Lee Anthony, at times, was resistant. But you didn't see an ounce of that from George. George cares about George and no one else. Those were not the actions of a father. Throughout the course of this trial, as he testified, he didn't act like a father once. There were times where he actually smiled. There were times where he thought it was funny to spar with me. And there were times where he broke down and did displays of affection. But I submit to you, his displays of affection are not exactly very genuine. We had this young lady come and tell you about his displays of affection. He told you that she had a brain tumor, and he was going there to console her. There's not a tumor. There's nothing involved. She didn't have a tumor. It's 3 years later, and she's still alive. She came here and testified. She doesn't have a tumor. And he went there to her apartment at night and during the day when he was claiming to be working to console her. He's got a woman at home that needed consoling. Cindy Anthony needed consoling. He wasn't home consoling her. He was consoling her. The state tried to impeach her about, oh, well, you sold your story. Yes, she did. And we brought that out from the very beginning. But there's one thing that's certain, is that she kept their relationship private until the police came knocking on her door, until it was already out there and made public. That's when she ended up selling her story, not before. She didn't expose George Anthony and say, I had a relationship with him. And by his own admission, he knew there was a guard at that gate that saw his coming and goings. He was a high-profile person, couldn't get around, couldn't deny ever being in her apartment, because she would have been the next person on that stand. He was going to her apartment to console her for some fantasy brain tumor that didn't exist. He came up here and he lied to you. Oh, I'm just being a nice guy. George cares about George, not about his wife, not about his daughter, not about his family, about himself. And that's what this is all about. When you read it, it's all about himself. It's a self-serving, self-preservation document. Now remember, this is January. His relationship with his mistress is now over. Cops are coming around a little too often with search warrants, and they collect that gas can again after returning it. The gas can with the duct tape, which he can't seem to tell the truth about. And they're coming around, and they're asking questions, and they're getting his fingerprints. The walls are getting closer and closer to George Anthony. So what does he do? He gets a 6-pack of beer with some blood pressure medications and claims to commit suicide. This whole thing is about, oh, I'm sorry, I'm this, I'm that, you were the best. That's all George is about, himself. He had a gun. The only reason he got a gun was to get Casey back in jail, knowing full well that there could not be any firearms in the house. This is an ex-police officer. This is someone who knows better, who the person from home confinement said, listen, these are the rules. The second they're broken, she goes back to jail. He didn't care. It's because George cares about George. If he really wanted to kill himself, he certainly could have. And it would have taken a lot more than a 6-pack of beer and some blood pressure medication. This is a self-serving document. It's more of George Anthony's lies, and it's more of George protecting George. Calling the police on these gas cans on June 24th is George protecting George and George throwing Casey under the bus. You saw the text message that he sent. He sent Miss Holloway, I need you in my life. Him and Cindy, he doesn't write Cindy and I need you in our life. Cindy's not going to her apartment at night. Cindy never went to her apartment. Cindy wasn't consoling her for her brain tumor, but he was. And before any of this, then he goes up there and denies ever saying that this was an accident that snowballed out of control. He's telling her she's dead. And still showing another face to the media and the public. And he's going around doing all kinds of media appearances. Within 48 hours of his so-called suicide, he's in front of the cameras again. If there's one thing you've learned about this family and its dysfunction, is that they don't mind putting on another face. Lies are what pumps and what lives within this family. And I told you that in the very beginning. She was raised that way, raised to lie. Is it a surprise that she has this fantasy world? Is it a surprise that she has all of these imaginary friends? Is it a surprise that she turned out this way, knowing the lies and actually seeing them firsthand? And mind you, fortunately, they kept coming up on the stand again and again and again. So you got to see them on different days, and you got to hear them change their stories and do different things. But the fact of the matter is, they raised their hand, swore to you, I will tell the truth, the whole truth, and nothing but the truth. And they lied. So now, as their own daughter stands trial for her life, you're supposed to rely on that. You're supposed to believe in that. And these are only the lies that were uncovered. What about all of the other things that could have been investigated and never were? How is it that they didn't get his cell phone activity during that time? How is it that they can't tell us the comings and goings of that? We have the most advanced technology available to us. You don't use it, and you don't go digging up things you don't want to find. You're not going to find them. And you're not going to have the information you need to render a just verdict. That's not justice. It's not justice, especially when you're pouring everything you can directed at only one person, and you're not looking at the entire situation. No, it shouldn't have turned out this way. Absolutely. But they should have done more. They should have looked elsewhere. They should have opened that net. They shouldn't have been walking around with blinders. They shouldn't have been trying to put square pegs in round holes. And if they had just kept an open mind, they would have seen the rest of what was going on here. They would have seen that the truth wasn't exactly the truth, and that there was more to the lies. You heard Dominic Casey and Jim Hoover take the stand. You may recall both of these were private investigators working for the Anthonys. And you heard something very interesting, and you saw a video of where they went out searching in November. You may recall Dominic Casey was the one that maybe provided us with a little comical relief throughout this trial. A strange man, to say the least. And his partner, Jim Hoover, when they went out and searched off of Suburban Drive. And not only searched, videotaped. For the very first time, they were looking for a dead Kaylee. And Mr. Casey says, well, it was a psychic that sent me out there. A psychic that was introduced to him by Cindy Anthony. And you heard Cindy Anthony get up there and deny ever sending him to the woods. And you heard George Anthony say that once I saw that video, he never went and asked Dominic Casey anything about it. He never said, hey, what were you doing out there where the remains were found? This is his private investigator who's working for him and his wife, and he never asks him. You may recall we showed you the email. It's Dominic Casey. And this is Jim Hoover. You may recall this is the location on Suburban Drive in the abandoned house where they were. And I asked him, you know Orlando's 101 square miles. Out of the 101 square miles of Orlando, This is the spot that they searched. And it's circled. You remember Yuri Melich came up here and circled this item right here as to where Kaylee was found. That's where they searched. And you heard Yuri Melich say that Cindy said she had her people walk that area. Remember, he took the stand, and then Cindy got up and denied it. Well, Cindy denied it first, and then Yuri Melich impeached her. Why is she lying? And then you heard Lee Anthony impeach his mother 30 seconds after she left the stand. In fact, it angered Lee so much that he stopped taking time off from work because they were looking for a live Kaylee originally, and now all of a sudden they're looking for a dead Kaylee. And you heard him. He said, I had enough. We got into an argument over it. I confronted her. This is a young man talking about his mother, impeaching her 30 seconds after she got off the stand. They knew where she was. Casey was in jail. They knew where she was, and they were out there searching. What do you think the odds are that they would search at the same exact spot where she would be found a month later? What are the odds in having that video? Can you even count that high? How odd is that? Is that a coincidence? Is this a coincidence too? Is this a coincidence too? Add them all together, and you've got something very suspicious going on. Very suspicious. And it has absolutely nothing to do with Casey. So where's the truth in all of this? Where? It's not in the forensics. Where? It's not on their testimony. And these are the state's star witnesses, which one of them they had to impeach at the end of the trial. And remember, Kaylee was found with no socks or shoes. It's one fact I forgot to bring up while I was talking about the pool. That's consistent with someone who was at home. She was at home when she died. She didn't have any socks or shoes on, and they didn't recover any shoes off Suburban Drive. You remember CSI Welch? I asked her 2 questions. Did you find any socks, and did you find any shoes? And she was wearing shorts that didn't fit her anymore. Hadn't been worn in over 6 months, and she had pull-ups on, and hadn't worn them clothes in a long time. Things are just not adding up here. Things just don't make sense. It is so difficult for you to find the truth. If it is difficult for you to find the truth, then this case is not proven. There's reasonable doubt. And remember what I told you about this case in the very beginning. Reasonable doubt lives here. It's throughout the case. It's right here. It's with these individuals. It's with those individuals. It's everywhere. You can't trust this evidence. You can't. When the state rested its case, we had no burden and could have closed up shop there, but you didn't have enough information. You didn't hear from Carrie Owen from the FBI, Madeline Montgomery from the FBI, who tested the hair and found absolutely no drugs, found all the club drugs and tested for all the club drugs they could find and found none. And she said it was very sensitive, that they had a very sensitive measuring tools. The state wants you to talk about it's meaningless. Wouldn't have been meaningless if they found drugs. It's only meaningless when they don't find it. Heather Suber, the DNA analyst, who tested all of those items, the trunk, the car, her other items throughout the case. Marcus Weiss, Stephen Shaw, Maureen Buttrell, the soil analyst, who went in of her shoes and didn't find any soil from the scene in her closet, and also those collected. Airbach and Lori Gottesman. 10 different people, 10 different state experts we had to call. So you can get all of the evidence. So you could see that evidence either inculpates someone or it exculpates someone. And the reason they couldn't prove this case is because it wasn't true. Look at all of these. Look at all of these tests that they ran. No fingerprints on the duct tape, either at the scene or even on the gas can. No fingerprints on the duct tape at the scene. No fingerprints on the laundry bag. No DNA on the duct tape. If it was wrapped around her face, suffocated her to death, as the state claims, why isn't there DNA? Degradation? That's not enough. You heard Dr. Eichenboom, Mr. Eichenboom testify about that. You heard Heather Subert also testify. They wouldn't have tested it if it couldn't have been on there. The FBI searched for this. It came back negative, but it had another partial profile on it. One that they contaminated and another one on the sticky side. That, remember, was the 17 marker that excludes Casey. More importantly, excludes Kaylee. If Kaylee had decomposed all over that duct tape, there would have been cell material on there. There would have been some DNA. We solve cold cases every day, 20, 30 years later, with DNA evidence. Oh, 6 months, we can't solve a case? We can't find DNA on some duct tape? Duct tape's it's one of the best ways of getting this type of evidence. Not only DNA, but also fingerprints. And you didn't have that. No DNA on the paper towels. No DNA in the trunk. No blood in the trunk. No sticker on the duct tape at the scene. No chloroform on the car seat. No chloroform on the steering wheel. No chloroform in the bones. Remember, they searched, they did all kinds of toxicological examinations from the saline wash, from the bone marrow, from also from her hair. Nothing to match their case. Nothing that adds to their theories, to their hopes. Remember what he called it? They only hope. Their air tests, their chloroform, no quantitative analysis, the toxicology exams, all of these drugs, negative, 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 negative. No prescription over-the-counter illicit drugs in the bones. No hairs exhibiting characters of decomposition out of the other hundreds of hairs that they checked. The soil examinations, all of this stuff, the shovel, everything came back negative. The greatest crime lab in our country, all of this came back negative. As I told you in the opening statements, she's dumb enough to leave her child off the side of the road, just 19 feet, but she's smart enough to outwit the greatest crime lab in the country. That doesn't sound right. It doesn't make sense. It goes on and on. No tissue on the duct tape. Nothing. No maggots in the trunk outside of the very few that fell out of the bag. Everything else was in the bag. No blowflies in the trunk except that one leg. But remember, there were 75 in the bag. Well, how'd they get in there? 75 early colonizers in the bag, but not one of them made it into the trunk, or at least only a leg got in the trunk, and it was in the trash bag. And remember that paper towel had marijuana. Remember? The fatty acids that Arpad Boss tried to say was adipocere, but yet had marijuana also. That doesn't make any sense. That's nonsense. How ridiculous can you get? No discoloration inside the skull. Remember Dr. Spitz. You'd be hard-pressed. We were very fortunate to have someone as qualified as he was to come here and testify before you, to be able to tell you about this issue and how if someone dies of suffocation, you would have that. No trauma, no fractures. The list just goes on and on and on. No prior injuries, nothing. No cause of death. It adds up to only one thing. If you look at all of the evidence here, it only adds up to one thing. And that is, she died by an accident. This was an accident that snowballed out of control. Now, again, the defense has no burden here. The defense didn't have to call these people. And the presentation of the evidence that you got from the prosecution included this person, this person, this person, this person, this person, and this person. And I would be willing to bet that most of you probably don't even remember any of them. But they failed to call this person. Do you even remember what these people talked about? The man who finds the body is never called by the prosecution.
Counsel's violation as to number
Sustain.
4 in the court's pretrial order.
Sustain. Continue.
Defense called Roy Kron to show you that there were some very suspicious circumstances surrounding his discovery. We never suggested to you in any way, shape, or form that he had anything to do with Kaylee's death. We never said he packed up her remains and took them home. But there's one thing we did say, and one thing that is uncontroverted, and that is he knew where she was and had control of that for at least 4 months. If you look at this is what I showed you at the beginning of this trial, and this is what actually came out. At approximately 1 p.m., he's there with his coworkers on August 11th. He tells his friends, hey, I think I see a skull here. A skull. But they get distracted by the snake. Forget the snake. They forget the skull and concentrate on the snake. And he never says a word about it to his coworkers ever again. He goes home that afternoon, and calls 911 at 4:28 in the afternoon. And he tells them, I see something round and white. He's describing a skull. They don't find anything. Nothing happens. So he calls again on 8/12. And he gives even a more comprehensive description. You have the 911 calls, so you will be able to hear them. Well, you heard them. He starts giving more of a description. And he says something very interesting. He says there was a tree there that had a fallen tree that looks like somebody had cut it. Now, if he's 30, 40 feet away, like he said, came here and testified to, how would he know so much details that someone tried to cut this tree? Then he says this, there was a white board hanging over it. There was no white board recovered. This, I suggest to you, was a marker where he may have hid her remains under the tree that took 2 people from CSI to move away. You may recall them testifying that. Well, how heavy is this tree? Is it too heavy for someone who weighs 100, 105 pounds soaking wet? Not so heavy for a man who weighs about 250, 300, well, 250, he's about 6'1", 6'2". These remains were hidden. We all saw how close, the 19 feet. From here to the witness stand, maybe a little further. From the side of the road for 6 months. But there's this white board there that no one finds, no one photographs on December 11th. What happened to the white board? Who moved it? Not Casey. She's been in jail. This is in August. She's already in jail. In the short time she was out on bond, she was under house arrest, and the media, 10 media trucks parked outside her house. So somebody moved that whiteboard. Somebody moved that tree. At the very least, you must reject whatever was found there, the conditions of which it was found. Because as all crime scene people testified, you never get a second chance at a crime scene. You never get a second chance. If you want to get reliable information from a scene, it cannot be contaminated. It cannot be staged. If it's staged, it's useless. It's pointless to review. Because whatever you see, you must reject. And that's what happened here. On the 13th, a police officer meets him there. Deputy Kane comes out and meets Roy Kron to show him, so he could show him where the bag of bones are. They didn't find it. She was not found on August 13th when the police officer went out there. And all Kron could say is, well, he wasn't very thorough. Well, it's 19 feet away from the street. And remember, there was about, as Mr. Murdoch pointed out, there was about 6.5 feet of grass. If you're this close, how can you not tell the officer, it's there, it's right there? No, the officer was rude to me. Okay, let him be rude. And just as the prosecution pointed out, why not grab the bag and go down the block and say, news media, here it is. I found her. Give me the reward. I've got a story for you. Why let the rude officer treat you that way? Why not point it out? Something is wrong here. Something very shady. And $255,000 is a motivation for someone. And he admitted it. I asked about the reward. I said I won the lottery. He said all of these things. And he also called his son in November. You heard his son say, my dad told me he found Kaylee. Brandon Sparks had no reason to come here and lie to you and testify against his father. He wanted to have a relationship with his father. They were estranged, and they were just starting to build that. He completely impeached his father's testimony. And not only did he impeach it, Mr. Kronk impeached himself. He admitted to you. On December 11th, when he happens to be urinating for the second time, 4 months later, he finds her remains. He tells the police in 2 different statements, I lifted the bag up about 4 feet off the ground, and the skull dropped out. Well, that's not consistent with what the police found. And they went back to him on the 17th, and that's where he changed his story. You heard him say it. I changed my story. 2 different statements. And what's glaring and what's missing here is on the 11th, when they ask him, so do you have anything else that's important that you want to add? He doesn't say, yes, I called you 4 times 4 months ago. He doesn't say anything. He keeps that quiet. It's not until they go back, and he knows they've got the 911 calls. They've got those previous crime line tips. My story's different. I better play ball. Yeah, the skull didn't drop out. It didn't roll out of the bag. It was there. It changes his complete story. Now, I submit to you, ladies and gentlemen, how can you trust it? How can you trust anything at that scene if it's staged? Any of it. We know by Dr. Spitz has proven that it was not as they found, her skull was not as they found it. We have Kronk lying about the skull rolling out. And remember, in August, He's doing all these 911 calls and talking about a skull. The skull is outside of the bag. But yet on December 11th, it drops out of the bag. Well, who put the skull back in the bag? Somebody had to. It's in his own sworn statements. And it's not until he changes it that he admits to that. But those statements are etched in time. There's nothing that can be done. And you know now that he changed his story. And you also know now that those remains were hidden. Those remains were in a bag. This man is lying. How can you rely on any of that evidence? In your deliberation, you cannot trust this evidence. You can't trust this scene with all of this going on. You just can't. There's something not right here. And again, reasonable doubt is breathing and living in this case. And it's living right down to the very end as to when they find her. And if it weren't for the defense finding Brandon Sparks, his own son, you wouldn't have had that information. If it weren't for the fact that we called Mr. Kron to testify, you wouldn't have had that information. You wouldn't have had any of this knowledge when making a decision that takes someone's life, when making a decision to convict someone of murder, aggravated manslaughter, aggravated child abuse. You wouldn't have had any of this information. None of it. Information that you can see is critical, clearly critical. We keep getting back to that one central question, and that is how she died. And right now, as you sit here, you must certainly have more answers, more questions than answers. And the judge will instruct you on what the law is and how it must be proven. And there's no way, in looking at all of these circumstances, that you can say that this case was proven beyond a reasonable doubt. There's just no way. And there's various reasons why this is such. It began with part of the cover-up. It also concluded with part of the information and the investigation as to where it was carried out. To find her guilty of any single charge, any single one of them, you have to have an abiding conviction of guilt. That's what you have to have inside of you. You have to know that this case was proven. You have to know that these facts were proven. And you don't have that. And however tragic this case is, you cannot continue it. You are the ultimate deciders of what the facts are. Mr. Mason is going to come up and show you the different charges and explain to you how the law will be applied in this case and how we suggest that you look at it and how the judge will instruct you on it. I thank you all collectively and individually for all of the attention that you have given us and the prosecution and how you've been able to keep an open mind despite every reason not to. I know that it has not been easy. This prosecution knows as well. And there have been times where emotions have gotten high. But you're here to fulfill an oath. You've labored tremendously over this journey. And we're going to ask you to render a verdict of not guilty on these charges because they simply were not proven. And they're simply not true. Just look at what they have and what they don't have. All the fantasy forensics in the world don't make it so. All of the lies that you've had to swim through don't get you any closer to the truth. You can't get any more serious than this. The stakes cannot be any higher. And we ask that you use the law as your guide. Thank you.
We'll take a 10-minute stretch break before Mr. Mason starts.
Listening to lawyers, I can see it in your face, but unfortunately, you're not going to get to do that, at least from me. But we'll spend a few minutes. And I begin thinking about where we are and where we've come from since May the 9th in Clearwater to now. And we're about to put on your shoulders the most solemn responsibility that you individually or all of you have ever had to face. And all I can say about that is you agreed to be able to do it, and I hope you all survive it with good senses and pride in what you do, just like we will, hopefully. Now, begin my comments. I want to devote just a little bit of some philosophy. A very dear friend of mine named Milton Hirsch, an author, and in fact a judge in South Florida, advised me of this parable, and it's always fun to go through. History records that on May the 19th of 1790, the skies over Hartford, Connecticut turned from blue and sunny to black and stormy with such speed and dramatic force that the people believed the end of the world was at hand. The Connecticut House of Representatives was in session at the time. Some of its members dropped to their knees in prayer as others clamored for adjournment. The Speaker of the House, Colonel Davenport, rose to his feet and restored order with these words: "The day of judgment is either approaching or it is not. If it is not, there is no cause for adjournment. If it is coming, I choose to be found doing my duty. I wish, therefore, that candles be brought. Today is Judgment Day in the United States, as for its Constitution. Tomorrow will be Judgment Day, as for the Constitution. Every day in which an American stands trial for his liberty before a jury. Every day in which an American is arrested or his home or property searched. Every day in which a voice is raised in speech or song. Every day in which a vote is cast or counted. Every day in which a newspaper is printed or read. Every day in which a lawyer is asked to defend an unpopular man or an unpopular cause is Judgment Day for the United States Constitution. We can cower before the storm, or we can light candles. Let us light some candles. On this eve of the 4th of July, anniversary of the freedom of our country and beginning of a constitutional government, there are some things that you're going to hear about that are extremely important. And that is the constitutional rights and constitutional protections that afford the freedom to each and every one of us in this room, and interpreted with some very special rules for Casey Anthony. Now, when I finish, my colleagues from the state attorney's office, for a long time, either together or divided up in some fashion, will stand and they will present arguments to you. And when they're done, I guess probably tomorrow morning, as I'm saying it, Judge Perry will then read to you the instructions of law that you are required by your oath and required by the law to follow. And I can tell you now that there are going to be some questions asked about those, because in truth and fairness, we haven't been able to get all together to finalize what it's going to be, but we're working all hard on it. You, at least, however, will not have to memorize it. You will be given 12 sets of these typewritten instructions so you can read them, and discuss them, argue about them, try to understand what they mean. And I know, actually, that you will be able to, because despite how long it's been, I remember all the process of the jury selection. And I believe that you all have the cumulative and individual abilities to analyze and to resolve your questions regarding those instructions. So I'm going to tell you what some of them are, and one of the ones that governs about everything that's going to happen in this case is an instruction that is entitled, when you get to them, plea of not guilty, reasonable doubt, and burden of proof. And I do not intend to belabor all that now, but there are some things that control the major lighting of candles that we're going to do in this case. And that is, Casey Anthony is not required to present evidence or prove anything. You may remember that that concept was discussed with you in Clearwater, not just by the lawyers asking questions, but Judge Perry looked to the side to each one of you and discussed that with you. And every one of you understood and agreed. I accept that. Each of you accepted the constitutional principle that is one of the cornerstones of our freedom. I'll say it again. The defendant is not required to present evidence or prove anything. And you must remember that concept with every issue that you discuss when you're back there in the jury room. You can get caught up in emotional rhetoric. You can get caught up in conflicting positions amongst you. But no matter what it is, the defendant is not required to present evidence or prove anything. Said another way that you must carry with you throughout all the discussion is that the burden of proving every required element in this lawsuit rests with my colleagues from the state attorney's office. And they don't shy away from it. They've accepted that. That's their responsibility. Never forget, no matter what the issue is, they have all of the burden, and there is none over here. Because that is what separates our constitutional government and freedom from so many others in the world. It is your duty to absolutely ensure that those rules are respected and honored through every stage of your discussions. For tell you that every element of the offenses is required to be proven beyond and to the exclusion of every reasonable doubt. Every reasonable doubt. And if the state of Florida fails in that burden of proof as to any element of the offenses, then you are required, like it or not, emotional or not, it is your solemn sworn duty. You are required to find the defendant not guilty. And that goes to every single element of each charge in this case. Only if it can be said in your conscience, in your intellectual honesty, that the state has proven the elements beyond a reasonable doubt, may you consider finding the defendant guilty. So, with every issue that is raised, burden of proof, no burden, reasonable doubt. That'll help you get through it. The court is going to tell you that it is your province to weigh the evidence, not the sparring between the lawyers, and not the stacks of 366 pieces of something, and boards, and whatever else. You, jurors, are the ones who weigh the evidence and decide what evidence is reliable, what evidence you are skeptical about, what evidence you don't trust. It's out of the lawyer's hands. This is for you to decide. And the court is going to give you some guidance. I mean, we don't just look at somebody and say, well, I don't like the looks, but that guy's too old, or he can't hear, but whatever the issues are. You look to some rules to guide you on the evidence, such as, did the witness seem to have an opportunity to see and know things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Oh my, we've seen a lot of issues about that from that witness stand in the last 6 weeks, perhaps. Did the witness have some interest in how the case should be decided? You know, like being able to make some money or something like that. Did the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? That's, you heard the term from time to time, objections and arguments and stuff about impeachment. And that's what we call it when you catch somebody changing their story that they said sometime before under oath in a deposition. You have the right to believe or disbelieve all or any part of the evidence of any testimony of any witness. 100% of the people that sit in that chair, you have a right to believe all or none. That's what a jury is about. Otherwise, we use a computer with all these little things, machines going out. I don't know. Maybe I'll live long enough to see we won't even have humans in juries. We'll have some kind of machine inside. But for now, you get to weigh and judge the credibility of every single witness. The court's going to give you an instruction about expert witnesses. Remember all the people we had talked about, go through this and that. The judge, you declare him an expert, and the judge will tell you, ladies and gentlemen, so-and-so is an expert of this or expert of that. You can consider that. However, you're also going to be told that, like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. So just because they may have met the criteria or threshold to be anointed by Judge Perry as an expert doesn't mean you got to buy it. You may or you may not. That's part of being a jury. Now, thinking back to your oath, your discussions with Judge Perry in Clearwater, we're now going to talk about the elephant in the room. And I know what it is, and you know what it is. My client, Casey Marie Anthony, with the advice of counsel, made her decision to not testify in this case. I didn't reach my age and try cases this long and not know that's still on your mind. But you swore an oath as jurors to rise above bias and prejudice and media impact and so on. The judge will tell you as follows. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as admission of guilt or be influenced in any way by her decision. Again, you must not view this as admission of guilt or be influenced in any way by her decision. A promise you made, and a promise that must be kept if we're lighting candles for our constitutional rights and freedom. No juror should ever be concerned that the defendant did or did not take a witness stand to give testimony in this case. Burden of proof, no burden, beyond a reasonable doubt, and don't dare think that you can consider the fact that she did not testify. As fundamental a right as we have, born in the Constitution, the history of our country since we've had the Constitution. Because these are in some order, I'm going to discuss a subject that you will have to consider. Counts, you didn't hear a whole lot about, but counts 4, 5, 6, and 7. When you see the indictment, you may remember from order talking about it and the reading of the indictment. Alleged that Casey Marie Anthony made false statements to Yuri Melich. Now, you know who Yuri Melich is. You've seen him on the witness stand a dozen times. She made some false statements to him in different times and places. And the court is going to tell you that the instruction of the law is you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, what it says, whether, when the defendant made a statement, she had been threatened in order to get her to make it, and whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. I'll call your attention to some of the evidence on this. You may remember a recording made where she was questioned by 3 detectives in a small room that was described as about a 6x8 room. I think they even put pictures in to show you this tiny little room. And you remember, if you will, hearing those detectives yelling at her 2, 3 at a time, like some TV show, not allowing her to answer, berating, arguing. So you may also remember that in the initial part of it, interesting enough, there was a dispute among the law enforcement officers. You had a sergeant say when she was not handcuffed, she wasn't arrested. And then young Miss Evelyn comes in and says, yeah, she was handcuffed, I did it. And put her in the cage of Sergeant Acevedo's car. And the prosecution then retorted by asking, but she was free to go, right? Okay, so the bottom line is when you consider those things, consider those counts, consider whether or not the law has been met If she voluntarily made those statements, if she wasn't under pressure, coercion, duress, not being threatened, not in a small room with 3 detectives, and she made a statement you say was false, we'll find her guilty of it. But the law says if she was not freely and voluntarily making those statements, you should disregard them. And if the statements are gone, so are all the counts. The initial charges, or the main charges in this case, of course, are first-degree murder, which requires the government to prove some things that are obvious. Are we arguing that this unfortunate child is not dead? Of course not. It's a tragedy. It's never been an issue in this case. So, but it's on there. You may wonder why did they do that? Kaylee Marie Anthony is dead. Well, okay, yes, the death was caused by the criminal act of Casey Marie Anthony. Now, caused by her. Well, what act? What act? You will also hear, and you will read the instructions as charged in the indictment, that this was done by a premeditated killing, and or alternatively, you will be able to consider whether or not there was a felony murder underlying that, and have fun reading the instructions on that. We're trying to make them as clear as we can, and the bottom line is there's 2 theories. The main thing is what act. The judge will describe and take the time, and you'll get into what does premeditation mean. I'm not going to belabor it. You'll also be given instruction on dealing with the offense of felony murder at the first degree, and that is, once again, that Kaylee Marie Anthony is dead, and the death occurred as a consequence of, and while Casey Marie Anthony was engaged in the commission of aggravated child abuse. We've been here, I'm not sure what day of the actual trial this is. The only thing I'm real clear about it is Sunday afternoon. Where, what, how, when, why is the evidence of aggravated child abuse? All of the witnesses that took stand didn't know anything about Casey Marie Anthony. Confirmed that she was a loving, doting, devoted mother. She was a young girl. She's only 22. My shoes were that old. The child was well fed, well nourished, well taken care of, bright, had no evidence whatsoever of any prior trauma of any kind, no torquing of joints, no twisting of bones, no closed fractures, nothing. Or, the law says, that the death occurred as a consequence of, and while Casey Marie Anthony was attempting to commit aggravated child abuse. And that Casey Marie Anthony was the person who actually killed Kaylee Marie Anthony. All the emotion, all the suspicion in the world doesn't prove it. Burden of proof, no burden, beyond and to the exclusion of every reasonable doubt. You will get an instruction hoping to help you understand what is meant by aggravated child abuse. One of the parts of that that's been added to it is a definition of willfully, not unintentionally or not accidentally, but willfully causing child abuse on Kaylee. I may not indeed have been able to hear everything. You may have noticed, we both have on our tables, as does the judge, a special computer where she sends me what's being said. So when I can't hear it in the acoustics of the room, I'm sitting there trying to read it. And I never heard nor read, in this case, any evidence of child abuse of any kind. I'm not going to further belabor all of those instructions because you'll have them to read, but I'm not done. It's not that easy. The instruction is going to tell you that you may find a reasonable doubt based on the evidence or the lack of evidence. Now, Mr. Baez went through a lot of things with you about what is or is not evidence. And forgive me if I repeat some of those, but I had made a list of issues that I thought were not proven in this case. You have absolute right, of course, to disagree with me, or say, yeah, that's right, and to think of some others on your own, which I know you will. So I'm going to run through a list just real quickly just to give you an idea what we're talking about on lack of evidence. This is a criminal case, those charges. No fingerprints on the duct tape anywhere, or on the bags, or anything that were searched and seized by warrant from the home. Interestingly enough, we learned that the infamous gas can with the duct tape, no duct tape, had been wiped clean. No prints. Toxicology tests. Dr. Goldberger, part of the forensic team doing the autopsy studies for Dr. Garavaglia, was charged with the duty of seeking to find chemical evidence of chloroform and several other drugs or poisons. Zero. Found zero. Mr. Baez did talk about there being no DNA. 2011. The case occurred in 2008. It's not new. The only profile of DNA evidence, as you heard a little while ago, excluded, meaning that not the defendant. DNA evidence, as you heard, if you remember how much fun it was to listen to is to try to say that this DNA evidence matches you, or not you, not you, a person. It's a statistical probability. If there are these markers on these alleles as was shown to you, the more there are, the higher the probability. And the general rule, I think they testify to, if I'm wrong with that, forgive me, that when there are those 13 markers, then the probability of that person, subject that gave that DNA, not being the one matching to that, it's like 1 in 14 quadrillion. That's 15 zeros. But if the DNA has one, just one marker that the subject does not have, that means it's excluded. Cannot be. And the FBI confirmed that the profile they got from that tape excluded Casey Marie Anthony and the child. There was no evidence of decomposition found at the recovery scene. The entomologists talked about what must have decomposed somewhere else. It wasn't here. No bugs, whatever. No other evidence of it. Mr. Myers pointed out to you there were no bugs on the trunk, only in the trash. The issue of chloroform was brought up from the beginning. What a media baby this was. And I must remind you about this evidence. Dr. Michael Sigmund is the one who extracted 2 bags, Tedlar bags of air from the trunk of the car at the same time, in the same way, at the same place. He took one to his lab and sent one to Dr. Vass's lab. Dr. Sigmund's lab says major compound was gasoline, and that there was some small trace of chloroform, which he also said is everywhere. Everywhere. And opposing side said, oh no, we had this shockingly high level. Don't know how much, but it was shockingly high. And Mr. Bias said, Dr. Rickenbach said, no, very, very low. Search warrants at the house 3 times. You know, in your common sense experience, you know that the police don't call up and say, by the way, we'll be there at 6:45, the search warrant be ready. Search warrants are issued constitutionally through a legal process and orders by judges, and the law enforcement officers go, surprise. And they searched the Anthony residence. And they searched it all, as you recall, seeing pictures. They searched everything. They found no chloroform, no bottles of ingredients, no papers related to it, nothing. So then the issue, one says, what does all this chloroform mean? Was it, at some point in the case, is it chloroform used to poison this child and to knock her out and kill her, or was it chloroform that was ultimately alleged to be found from the decomposition suspicions from the trunk of the car? Not both. And there's no evidence of what it was, so, but it sounded sexy for the media. The heart-shaped sticker deal, Mr. Bias. Laboratory analyst at the FBI says she saw an image of a part of a heart shape on the corner of duct tape, the language I recall. But when she went to take a picture of it, poof, it was gone. Poof, it was gone. And then, of course, they brought in as evidence some thick item attached to a piece of cardboard, which when it was presented to you, I don't know what number it is, but it was separate. That had been found across from the school in the distance from this child. Mr. Bias talked about numerous other things, the searches comparing shoes and shovels and so forth. Let's talk about some other things. Unusual in a murder case or any criminal case. Not even a hint of a claim that there was any form of admission of wrongdoing attributable to this defendant or any confession. No witness anywhere that she did anything to this child. None. 3 years of investigation and however much money. None. Why would she kill this child? There's no evidence of a motive to kill this child. Am I hearing him suggesting that she wanted to party, but she did that anyway? That babysitter. The boyfriends liked this child. Everybody had a good relationship. Why in the world, with a mother that you see in the video, why in the world, with a mother that's been so devoted to this child, trying to protect her and take care of her, wake up one day and say, well, I think I'll kill her? You learned about trace evidence. You learned about all the scientific stuff. But we didn't learn about was anything to link any wrongdoing, as example, to the inside of the car. The steering wheel cover, the car seat, anywhere inside at all. Yet we're told that, you know, somebody did like that, like DNA or skin cells or move this chloroform or whatever is alleged to use as a weapon somewhere. None. I suspect that you, individually, collectively, can make a much longer list than I did, saying here quickly, of the things that there's no evidence of. I don't know what the odor was or what there wasn't, but I was certainly intrigued to learn that at least 7 law enforcement officers on the hunt did not smell any decomposition or strong odors in that automobile. I remember Mr. Simon Birch, I suspect in Australia and New Zealand, didn't find out, tow truck guy, said he had a history of 6 or 7 or 8 prior experiences of decomposing humans from suicide or otherwise in cars that he had repossessed. But in this one, now, well, there may have been a little odor, he says, but with that experience and that consciousness and talking to Mr. Anthony about his missing daughter and grandchild, neither he nor George called the cops. Instead, he takes the trash out of the trunk and says, this is your source of smell, flips it over the fence to the dumpster. All of these things start mounting up reasonable doubt. this business about this tape as a murder weapon on the guess of probabilities. Could be. How many times did you hear somebody say could be, might be, maybe? In today's opening statement by Mr. Ashton, he said on several occasions, in all likelihood, a characterization that he made himself about something. In all likelihood. Well, in all likelihood doesn't quite make it. Let's talk about what burden of proof really requires, how it means, how you can think about it. You may have other definitions. Can you see? Sir, now, all of it. If you have if you go and you listen to the rest of the arguments and the evidence and you talk about things, you just discuss it. Oh, sorry. Can you all see it? Okay. You may have an absolutely abiding belief now or tomorrow or whenever that is not guilty. That's easy. Not guilty. Done. You may decide it's highly unlikely that she's guilty. Okay, good. All these mean not guilty. You may decide that less than likely, unlikely, possibly not, may not be, perhaps. All these you be thinking, I'm not sure, but maybe she's not guilty, possibly not, maybe not be, perhaps she's guilty. Also means perhaps not. Suspected. You might suspect that she's guilty. That's not proven guilt beyond a reasonable doubt. Possibly guilty. Possibly guilty. In all likelihood. Possibly guilty. Probably guilty. Moving up the scale. You have probably guilty. Guilty of what? Probably guilty of something, but probably guilty of what? Still not. Guilt likely. You may say, why? I'm confused. I'm befuddled. This is a bad deal. All these sort of things go together. Guilt is likely. That's not beyond a reasonable doubt. Or I got a strong belief in guilt. No, no, and no. Unless the state has proven to you beyond and to the exclusion of reasonable doubt, then whatever these other, if these are your evaluation thought processes, or others that may be in your own mind similar to that, there's only one answer. It's not guilty. It's not guilty because the state hasn't proven guilt. Now, there are a few things in the world that are absolutely subject to clear proof in our life experiences. Very few. People can talk about 100% this, 100% that, like Dr. Keith. The only thing I know that people are going to do, what 100% are going to do, is die. Anything else is 100%. We used to say taxes, but we know better than that now. A lot of people are not doing that. That's why we have a system that says the state has to prove beyond reasonable doubt. Everything. And if they fail to do that, then no matter what you may think in this continuum, strong belief, guilt likely, probably going on down the line, your obligation is to wait a minute, they haven't proven beyond a reasonable doubt. If they don't prove beyond a reasonable doubt, not guilty. This is not a trick. One of the things I was just also thinking about, going back to that list of evidence, this bothered me because I don't know the answer. I don't know the answers to a lot of things here. You don't either, I'm sure. Mr. Bias was talking about Mr. Kron. Why, another question for you, why would an uninvolved citizen, after calling the police about finding the skull, in a situation that is really just hundreds of feet around the corner down the road from the Anthony residence where all cameras are and so forth, nationwide lookout, y'all remember that? Said so during jury selection. Why in the world would a man sit silent for 4 months? I do not know the answer to that. I do not know how it is that he testified that he took his meter reader stick and put it in the right orbital socket of that skull and lifted it, yet the claim is that it was found embedded in the leaves and muck. Or was there, in fact, some repositioning, some posing of something to make a case? Dr. Schultz said there was no tape on the nose. Dr. Garavolia said there was some tape in the vicinity of the mouth. She concluded that the manner of death was a homicide on totally circumstantial evidence because she said so emotionally no child should have tape on her face. Well, there's no evidence that she did. Remember all the stuff, all the DNA, all the no. And Dr. Warren, who did the superimposition photo stuff, said it could have. So we have, in all likelihood, we have a could have, we have in the vicinity, may have. This is not, it could have, may have, so forth. This is a charge of murder in the first degree and serious other charges of aggravated manslaughter, aggravated child abuse. We all know, you accept it, and I close with this. You have a duty. I have been doing this for many years. I'm an idealist. I believe firmly in the integrity of our courts and in the jury system. Ladies and gentlemen, the reality is the court is no better than each of you sitting before me on this jury. The court is only as sound as its jury, and the jury is only as sound as the men and women who make it up. I am confident that you will review without passion the evidence you have heard, come to a decision, and restore Casey Marie Anthony to her freedom. Go do your duty. I will not claim origination for that. Some of you watch so many movies, ask from Atticus Finch to Kill a Mockingbird. I do not get the chance to get up again and talk to you. So I ask you to do this. Pay the same respectful, intelligent attention to my colleagues, whichever gets up next. Realizing that we got to sit over there, I have to sit over there and squirm because I can't get up. Can't get up and say no, but. So I ask you to consider this. Any and every time an issue is raised that piques your curiosity and you haven't been satisfied that the evidence proves it beyond a reasonable doubt, ask yourself, well, what would Mr. Mason argue about that or say in response to that? And you do it. And then you do your duty. You light your candles for the Constitution and you do your duty and you find Casey Marie Anthony not guilty because they have not proven her guilt. Thank you very much.
Good morning and happy 4th of July. Ms. Drainberg and I are going to both speak to you at this rebuttal portion of our argument. We're going to discuss different topics. I want to begin by discussing the science in the case. The defense counsel issued a very appropriate and aggressive attack upon the science, but I want to take a more measured and complex approach. Science can't be understood by simplistic concepts or easy phrases. The best way to understand the science in this case is to look at it and first look at what the scientists agree on and then what they don't agree on. And basically, the way it works is it's up to you to decide with an expert, as with any other witness, what part of his testimony you believe or don't believe. And in a dispute between experts, it's up to you to decide which one you believe. And you may reject both. You may find one more credible than the other because of experience or because of just that what they said makes sense. So it's totally up to you to decide what you believe from what the experts have told you. But I think it might be helpful to start out kind of isolating these areas sort of by subject matter. The first one I'd like to start talking about is the experts you heard on the subjects of forensic anthropology and forensic pathology. Those are sort of related fields. Those are the medical examiners and the forensic pathologists, the people that look at the remains themselves and what they told you. You essentially heard in this case from Dr. Jen Garavaglia, who is the chief medical examiner of the District 9 Medical Examiner's Office here in Orange and Osceola County. Dr. Utz, Dr. Utz was the gentleman who first took custody of the remains, who removed the duct tape and talked about that. You heard from Dr. Schultz, who is the forensic anthropologist, works out here at the University of Central Florida and is a contract consultant for the medical examiner's office here. You heard from Dr. Michael Warren, who is the director of the Pound Human Identification Laboratory at the University of Florida. And you also heard from Dr. Werner Spitz, who is the defense's expert called on that subject. Now, what do all of them agree on? Well, all of them agree that, number one, there is nothing in the bones that tells us anything. They all agree. There is no traumatic injury to the bones, there's no breaks, there's no fractures, there's no injuries, there's no nothing. Just looking at the bones, they all agree that there's nothing to tell us how Caylee Anthony died. Everyone agrees to that. The other thing they all agree about that is significant in this case is that because of the way the human body decomposes, there are two parts of the head that should not be together. That is the mandible and the skull. Dr. Spitz even said, remember he talked about when you picked up the skull, the mandible would stay on the ground. They're not connected. Once they decompose, there's nothing to keep them together. And what they all also agree about in this case is that when Caylee Anthony's body was found, the skull and the mandible were still in what they refer to as anatomical position. In other words, it was in the same position it would have been had the flesh and tendon been holding it. Where they disagree is on why that was the case. Dr. Utz, Dr. Garavaglia, Dr. Schultz, and Dr. Warren all told you that the only thing that could have kept that mandible in anatomical position is the tape. Remember, Dr. Warren told you, and he's, I would submit to you based on what you've heard, the most experienced of the four in forensic anthropology and skulls. He's told you that the only other time he has ever seen a skeletonized, fully skeletonized body with the mandible and the skull in anatomical position is in Sarajevo, in a skull of a person that was duct taped. So they have told you that in their opinion, which again, you may accept or you may reject, that that tape had to have been on that skull before she decomposed. Dr. Spitz presented you with an alternative, and I discussed that alternative with him at length. His alternative was that someone had come along at some later point for some unknown reason and reached down and picked up the skull off the ground, then picked up the mandible, took them someplace, put them back together, and duct taped them to hold them in place, and then returned them to the scene. You heard the cross-examination of Dr. Spitz about that scenario, and it is up to you to judge whether that scenario is reasonable or makes any sense at all. When I pointed out to Dr. Spitz that his scenario of the skull being returned was inconsistent with the, first of all, the deterioration of the duct tape, and second of all, most importantly, remember I asked him about, well, the person would not just have to put the skull back, they would have had to have draped pieces of hair over the skull. And remember what his response to that was? His response to that was to accuse the medical examiner personnel of doing it. And then when I showed him the photograph of the skull at the scene, undisturbed, with the hair in exactly the same place, he accused the sheriff's personnel of doing it. It is up to you to decide which of those two expert opinions you find more credible. And I submit to you, based on the evidence that you heard, that Dr. Spitz's version of events is incredible and non-credible. And I'll get to later in my remarks that it actually is also inconsistent with the very theory that the defense has been presenting to you in the other parts of their argument. We'll get to that in a little bit later. The other area that they disagreed on was the appropriateness and necessity of sawing open Kaylee's skull. Dr. Spitz told you that, in direct, that it was a violation of protocol for Dr. Garavaglia not to have sawed open Kaylee's skull, and that it was, in his word, sloppy. On cross-examination, however, when challenged, even with his own book, to demonstrate where that protocol was set down, he was unable to do so. When asked if there was any protocol he was aware of dealing with skeletal remains that required such an act, he admitted there wasn't. In response to that, we called Dr. Michael Warren back again, the director of the Human Identification Laboratory, to tell you that, in fact, it is not protocol. In fact, it is contraindicated to open a skull unnecessarily. Because there may be times when there may be some particular artifact that cannot be otherwise appreciated, but generally, no, skulls are not open. It is not sloppy to fail to do so. In fact, it is dangerous to open the skull, particularly in a child, because when you do that, the skull breaks, as Dr. Spitz did. Remember, I asked Dr. Spitz, you broke the skull, didn't you? And he was like, I don't remember that. And I showed him the photograph where the skull is fractured, and he didn't seem to remember. And I would submit to you that based upon what you have heard in this case, that Dr. Spitz's claim that the autopsy was done improperly is not credible. The other issue that they disagree on is this issue of the supposed, and this was sort of my shorthand term, but brain dust or brain residue. He referred to it as like dust in the skull. He says that there was this residue in the skull that he could tell by looking at it was remnants of the decomposition of Kaylee's brain. And because of the position that he could tell that the skull was on its side. He acknowledged that he took a sample of it, that he doesn't know if it's been tested or not. So we brought in Dr. Bruce Goldberger from the University of Florida, who washed the inside of the skull, tested it, and told you that there is no decomposition product inside that skull. So he did the test that Dr. Spitz said he didn't do, so he couldn't do because he didn't have a laboratory. And we now know that it's not what Dr. Spitz thought it was. So Dr. Spitz's whole theory of that proving that the skull was on its side has now been disproven. You'll also recall in cross-examination, I pointed out to Dr. Spitz that the arrangement of the hair mass was not consistent with his theory of how the skull decomposed. That, in fact, remember we talked about how if the skull was on its side, the hair mass is going to fall to the side, it's not going to fall evenly, blah, blah, blah. And you can look at those photographs, you'll have them all back in the jury room, you can look at them, and you'll see. I also asked Dr. Spitz an interesting question that counsel somewhat criticized me for asking. He acknowledged that in determining the manner of death, it is absolutely essential for a forensic pathologist to know about the events leading up to the death or disappearance of the victim. It's common sense. He said, yes, you have to know that. You have to know as much as you can about that. So I asked Dr. Spitz, well, what did you know? What information were you given? What research did you do? He said, well, I went to the house. Well, what do you remember from the house? Just that there was a pool. That's all he remembered. Well, what did you know about the events, leading up to her disappearance, etc.? Well, there was something about a nanny. That's all he knew. I would submit to you that his fund of information about this case is not sufficient to make his opinion credible in this case. That, in fact, the evidence in this case shows that the medical legal investigation of this case was thorough and complete, and that the testimony of Dr. Garavaglia and Dr. Utz and Dr. Schultz and Dr. Warren is credible and is worthy of your belief. Now, let's talk next about the entomological evidence. It wasn't a big feature of the case. It wasn't huge, but counsel referred to it, so let's talk about it. You heard from two entomologists. One was Dr. Neil Haskell, been practicing in this field, has been a leader in this field for, I think he said, 30 years, practicing forensic entomology. He told you two opinions, essentially. One about the car and one about the scene. You heard from Dr. Timothy Huntington, who has been practicing in his field since he received his PhD in 2008. A very bright young man, and I don't mean to denigrate his education or his sincerity. But the fact of the matter is you have to decide who you find more believable, someone who has been practicing the field for 25 or 30 years or someone who's been practicing the field for 3. But again, there are things they agree on. They agree on this very important fact, that the evidence at the scene where Kaylee's body was found indicates that the body initially decomposed in some other location from which the early colonizing flies were restricted. That's what Dr. Haskell told you. Dr. Huntington said he agreed that wherever Kaylee's body was for the first few days of decomposition, those early flies could not get to her. And then she was taken and dumped there in that field, in the woods, in that swampy area that you heard described by so many people. They both agree that that occurred sometime in June or July 2008, based on the entomological evidence. In that they agree. So what Dr. Haskell said about the scene, Dr. Huntington agrees with. Where they diverge is in the single issue of whether the trunk would have excluded the early colonizing flies. That's the only place that they disagree. Dr. Haskell, with his 25 years of experience in the field, has told you that in his opinion, the trunk is a source that could have excluded the early colonizing flies. Dr. Huntington, who candidly admits that he has never in his career dealt with a dead body in a trunk in a real world situation. But based upon some experiments, applying conditions completely different than in this case. Remember, that's the pigs in the blanket comment that we made. That based upon that experiment, and that experiment alone, he renders the opinion that the trunk would not have excluded the early colonizers. Again, it is up to you to decide which expert is more credible, or which you believe, or to believe neither. It is completely up to you. But the important thing is on what they agree. That body decomposed someplace else, that it was somehow, either by being wrapped or being stored, was in a situation where the early flies could not get to it, and that from June or July through December, it sat there in the woods. On that they agree. All right, let's go to the area next of the chloroform. Mr. Bias had a nice big poster about that, had all the experts or people that talked about chloroform. What is important to understand in evaluating the various people who testified about chloroform is to understand, first, what they were testing, and second, what their perspective was. Now, remember, Mr. Bias made a good deal of comment on the adjectives used by Dr. Voss and Dr. Weiss versus the adjectives used by Dr. Rickenbach. But one thing you have to understand in assessing those adjectives is their perspective. Dr. Voss and Dr. Weiss are used to looking at environmental air samples. Remember, Dr. Weiss told you that he's looked at environmental air samples from all kinds of different, fuel, car exhaust, environmental conditions, industrial, all different areas. And he's told you that based upon that experience, that he felt that the amount of chloroform he was seeing in the sample from the trunk was high, was surprising, because of what his experience is. Dr. Voss's experience is similar. What he's looking at is samples from dead bodies, and he's seen many of them. He told you that based upon what he has seen in decomposing bodies, and he has occasionally seen chloroform in those cases, in very small amounts, but compared to that, what he saw was shockingly high. But taking away the adjectives, the important thing is more to say, what did they actually find? Dr. Weiss and Dr. Voss told you that the chloroform they found in the trunk air sample in the can was somewhere in the low parts per million range. And Dr. Weiss gave you an excellent explanation of the idea of quantification. He said quantification would not have meant anything in this case, because even if you quantify the amount of chloroform being given off by the carpet, it doesn't mean anything in terms of the amount of chloroform that was there a month before, because chloroform is volatile. It evaporates. So it wouldn't mean anything. But he does say, and Dr. Voss says, that based upon the qualitative analysis and the comparison between the amount of chloroform and the limits of his machine and the controls, that it was somewhere in the low parts per million range. Dr. Rickenbach from the FBI tested a similar sample out of a can, but also tested the actual spare tire cover in this box. Now remember, he received it in this box, not sealed, not canned, not in plastic, in air-permeable cardboard. And what was interesting that Dr. Rickenbach told you is that he actually found chloroform, detectable chloroform, even in that. Remember, he told you he was surprised. He couldn't believe he found it, because chloroform is a volatile, and this is not sealed. So he said the fact that he found anything on that was pretty amazing. But remember, what he told you was that he found a much greater amount of chloroform in the sealed can. Remember, I think I had him put some numbers on a board, and it was in terms of percentages of the control. The control was 100 parts per million. In this item, I think he's put it at 0.08% of the control. In the can, it was 5% of the control. And again, he has said, and we will tell you, that is not a quantification. It is not a precise quantification. It's not intended to be a precise quantification. But what's interesting about it is that the rough estimate puts it in the low parts per million, the same thing that Dr. Voss found. Now, to Dr. Rickenbach, who is used to looking at chloroform in its liquid form, that wasn't a lot. But he told you, this is the first time I've ever found chloroform in any kind of solid object. Every time I've looked for chloroform, it's been in the liquid form in adulterated liquids of some sort. The case was being investigated. But even he said that he found detectable amounts of chloroform coming from the carpet in Casey Anthony's car. Nothing he'd ever seen before. And that's the significant thing about these witnesses, is they all told you the same thing. This is the first time we've seen this. Actual detectable amounts of chloroform coming from a carpet. And remember what they told you, Dr. Rickenbach agreed. The amount of chloroform in these items is far less than the amount of chloroform that would have been in that trunk a month before, because chloroform is volatile. It evaporates. It fills the space until fresh air comes in. Remember, this car was aired out by the Anthony family for hours on the 15th going into the 16th. So the chloroform that would have been there before it was opened up, when it was at the tow yard, was far greater than anything these people found. And ladies and gentlemen, I would submit to you that there has been absolutely no evidence to explain where it came from or why. Dr. Sigmund, who was the gentleman from UCF that did his initial testing of the sample, he told you that he tested the trunk 4 days after that item was removed. 4 days, it had been gone for 4 days. And yet even 4 days later, he was able to detect, even with his equipment, which he said is not as good as what Dr. Voss uses, it doesn't capture as much. Even he was able to find detectable amounts of chloroform in the trunk of that car, which shouldn't have been there. There shouldn't have been any chloroform in the trunk of that car, but it was there. Dr. Sigmund also told you something that was very interesting. He told you that while chloroform can be created by incidental contact between chlorine bleach and organic materials, that doesn't happen in a vacuum. That when that does happen, other compounds are created. And those compounds have not been found in this case. All that's been found is chloroform. No chlorine. Remember, I asked Dr. Furt, there's no bleach stains on that spare tire cover, are there? No, there's not. There's no, the issue was brought out that some cleaning products have small amounts of chloroform in them. And I asked Dr. Furton, were any of the other constituent components of cleaning products found? No, they weren't. All that was found in examination of that carpet and that spare tire cover were the components of decomposition and chloroform. In that, all the experts agree, including those called by the defense. Let's talk about now another subject as far as the air examination, which is the odor of decomposition, the expert testimony. The defense's primary attack upon Dr. Voss is that he has developed a device which is designed for use by law enforcement and the military. And that if by some miracle that device were to be purchased by someone in the private sector, why they would want to, don't guess, that Dr. Voss would split with the other inventors 15% of whatever minimal royalty that Oak Ridge National Laboratory might get. That's the impeachment. That's the criticism. You saw Dr. Voss testify in this case, and you have to judge his credibility. I submit to you that Dr. Voss is an unapologetic geek. He loves what he does. I mean, when have you ever seen a scientist on the stand in a criminal case say, and this is the cool part, Dr. Voss is an unapologetic science geek. He loves the challenge of solving scientific questions, whether it be how do you detect a body by the odor of decomposition, or whether it's maybe divining actually does work. You know, counsel sneered at him because he has the scientific curiosity to wonder if something as bizarre as that might actually have a scientific basis. Maybe he's right, or maybe he's wrong. But to say that you should disbelieve him because he has that scientific curiosity, I would submit, is inappropriate. You know, judge him by what he said. Judge him by who he is and what his experience is, and judge him fairly. But getting back to that point, when you actually boil down what Dr. Voss said and what Dr. Furton said, they really don't disagree that much. They both agree that the science of human decomposition odor has not developed to the level that there is a signature set of compounds that show human decom. They both agree with that. They both agree that the chemical signature from this car is consistent with a decompositional event. Dr. Furton said, yes, I believe that those chemicals are from a decompositional event. So does Dr. Voss. Dr. Furton agrees that it's possibly human. And that's what Dr. Voss says. They don't really disagree that much on much of anything, other than the final conclusion. Because Dr. Voss told you that when you combine the science with his experience and what he smelled in that can, the odor that he has smelled for 30 years, I asked him, do you have an opinion based upon all of that as to whether that odor was from human decomposition? And his answer was, I can find no plausible other explanation. And I would submit to you that Dr. Furton's other explanation is not plausible. You know, counsel in direct wanted to just have Dr. Voss talk about the garbage from a photograph without talking about what was actually there. But I wanted Dr. Furton to actually look at the garbage, because I wanted you to see what was actually there. In his closing remarks, counsel made a claim that I would submit to you is completely unsupported by the evidence. He told you that these officers removed something from the garbage. That is absolutely unsupportable in the evidence in this case. There's no evidence of that. In fact, the evidence is completely to the contrary. The officers testified they removed nothing from that garbage bag, that there was no food there then, there is no food there now, and all the imagination in the world is not going to create it. The only thing in that bag of an organic nature, similar to food, was the small bit of remnant of cheese that I passed around for you to look at. And Dr. Furton admitted that that cheese in that bag could never create an odor that would still be detectable by Tim Huntington, the defense own expert, 2 years later. The myth of the garbage has been disproven. That smell was not from garbage. It was from kale. The defense presented, let's talk about DNA for a minute. The defense presented DNA non-evidence. The defense called a DNA expert from the FBI to testify that she tested for DNA on various items and there was none. And she told you that she didn't expect to find any. That DNA decomposes just like every other part of the body does. And that she had no expectation of finding DNA on the tape that had been out there on the body for 6 months. The defense called, Dr. Eichenberg, who really just testified, and remember, he is the witness who provided us with a report 2 days before he testified. The judge instructed you on that, and that you could determine that in judging his credibility. But all Dr. Eichenberg really said was, well, I think I might have been able to find something. I mean, that was the essence of his testimony. I think I might have been able to find something, but I might not. That's it. That's essentially what he said. But even he admitted that the two things that were absolutely the most destructive to DNA are moisture and heat. And that it was highly unlikely that any DNA could be found on the duct tape. I mean, think about it. If there's no DNA on the face to which the duct tape was attached, how can there be DNA on the duct tape? And they admitted that. That was non-evidence. It didn't mean anything. The defense called 10 other witnesses to basically talk about non-evidence that the witnesses themselves admitted was meaningless. It doesn't mean anything. The fact that there's not dirt on a shoe doesn't mean the shoe wasn't in place. We go on and on with that. It just doesn't mean anything. The last area of forensic evidence was the hair examination. The hair examination, you heard from Karen Lowe and Stephen Shaw. Stephen Shaw was recalled by the defense, and we went through that PowerPoint with you about his research. Those witnesses are not going to come up here and tell you more than the science will absolutely support. What they told you was that there is this artifact that has only been seen in hairs taken from decomposing bodies, that despite all of their efforts to recreate it from living human beings, they have been unable to do so. Since they don't know exactly what causes it, they're not going to tell you that it couldn't happen any other way, but just no other way they can think of. And that testimony, ladies and gentlemen, has not been refuted in this case. To say that there is no evidence to connect Casey Anthony to Kaylee's death ignores all of this evidence. I want to go to the next issue I want to discuss with you is the issue of reasonable doubt. It is up to you to decide whether a doubt which has been proposed by counsel are reasonable doubts or whether they are speculative, imaginary, fanciful, and absurd doubts. So I'm going to go through some of the reasonable doubts proposed by counsel and subject them to a little bit of examination. The first area I want to discuss with you is the duct tape. Counsel went to great lengths to connect, as we already had, the duct tape in this case to the Anthony home. On that, we agree. That duct tape on Kaylee Anthony's face came from the Anthony home. But so the argument then goes, well, George Anthony, having somehow discovered this drowning, which we'll talk to a few minutes ago, there's no evidence actually happened, for some reason decides to dispose of the evidence of this completely innocent accident. And for some reason that no one can even propose, decides to put duct tape on Kaylee's face. Now, getting past the fact that there's just no conceivable reason why anybody would put duct tape on the face of a dead child. I said it before, people don't make accidents look like murder. That's absurd. And nothing has been presented to you to make that any less absurd.
Sustained.
Motion to strike, Your Honor.
Motion to strike granted.
You have heard nothing in the evidence in this case to make that proposition any less absurd. Now,
Overruled.
but let us propose that we ignore all of that absurdity and say that George Anthony has.
Paragraph 6 of Your Honor's order.
Overruled at this point.
And let's suppose that George Anthony has, in fact, placed Kaylee's remains in the wooded area on June 16th of 2008 and placed duct tape over her mouth. The defense then asserts that on the 24th, for some reason, he deliberately notifies law enforcement about this gas can with the duct tape on it, implying that in some way he is attempting to implicate his daughter in something for reasons which are completely inexplicable and not mentioned anywhere in the evidence. But he creates this issue about this duct tape by reporting that it's stolen. He gets the can back. No photographs are taken by law enforcement back in June when it happens. It's just reported. There's no way of knowing from that report whether duct tape was on or not. It's just not mentioned. But somehow the defense wants you to believe that that was part of the plan. That was part of his insidious plan to somehow implicate his daughter in something for some reason. They then tell you that when Kaylee does turn up missing and the police are there searching, that George doesn't tell them about the gas can incident. If George is concocting a nefarious plan to implicate his daughter in this accident, then why doesn't he tell the police that first day? And counsel made great point of the fact that he didn't. But if counsel is correct, then he would have. He would have done it. Of course, why he would give the police a piece of evidence implicating himself as much as anybody else, again, sort of begs the issue. But anyway, so we go on. So the police take the item, which at the time they have no idea has anything to do with anything, photograph it, and they give it back to him. So at this point, George Anthony takes the can back and sticks it in the garage for 4 months and doesn't do anything with it. Doesn't try to connect it to the police. He just lets it sit there. And then in December, when the body is found, the police find the can with the duct tape in the garage. George doesn't point it out to them. They find it. Because remember, George isn't even there. They find it and they take it into evidence. So what does this nefarious criminal then do? He takes the very same roll of duct tape, which connects him to this death, and he uses it to display posters. Does any of this make sense? None of this makes sense. To assert that George Anthony's use of the tape on the posters for his missing granddaughter is patently absurd. It doesn't make any sense.
Paragraph 6. Motion to strike.
The reason that it doesn't make sense is because it's not. I submit based on the evidence true. George Anthony had absolutely no idea that that roll of Hinkle duct tape had anything to do with the death of his daughter, of his granddaughter. He had no idea because he wasn't involved, just as he told you. You know, counsel showed you the big poster with the pictures of Kaylee walking into the pool and said that this hypothesis has not been rebutted. Well, I respectfully disagree. Because, ladies and gentlemen, the two people that counsel asserts were present when that happened were George Anthony and Casey Anthony. And George Anthony testified on that witness stand the first day of this trial. It didn't happen. And as Ms. Burdick will point out to you when she speaks to you in a few moments, Ms. Anthony also was given the opportunity to adopt that and rejected it twice. That has been refuted by the evidence in this case. Counsel also asserted to you that this crime scene was, quote unquote, staged. And here's the interesting part. He tells you on the one hand that George Anthony is connected to the tape. Remember, he said in opening, follow the tape. But then on the other hand, he tells you that Roy Kronk is connected to the tape. Remember, Dr. Spitz told you that somebody came along later and took the skull and taped it. And in opening statement, the defense counsel told you that person was Roy Kronk. So they both got the tape, this rare kind of duct tape. Roy Kronk, who has no connection to the Anthony family other than reading their meter once, who's never been in their house, who's never been in their garage, who have no way of knowing what kind of duct tape they have. So which is it? Who put the duct tape there? Counsel has argued to you that the crime scene was staged. Could I have State's Exhibit 82 published to the jury, please? You'll recall this is the photograph of the scene out there on Suburban Drive as it was found on December the 11th of 2008, before anything was disturbed. This is in its pristine form. Looking at this scene, it is clear that the only thing that has staged this scene is Mother Nature herself. This scene is covered in leaf litter. There is a 2 to 3 inch pile of leaf litter surrounding the skull, as testified to. There are vines literally growing over everything in this scene. There are vines, you'll see in photographs, growing through everything in this scene. This scene is staged by Mother Nature and no one else. This skull has not been moved for 6 months. Pardon me, maybe a little bit less because the animals might have moved before it decomposed. Defense counsel told you in opening statement that Roy Kronk took the remains home and kept them. We present the testimony of Dr. John Schultz, forensic anthropologist who was in charge of the collection of the remains. And we went through great length with him to show you where the remains were found and in what groupings. The reason that was important was because the grouping of the various bones demonstrates how the body was disarticulated during decomposition. Remember, he talked about how there were certain areas where the ribs were found because the trunk would have been removed as a connected group of organs as it decomposed, that the vertebrae were found separately because that would decompose separately. The bones showed evidence of that the bones showed evidence of animal activity, that they'd been chewed on. We didn't tell you that just to offend you or to make you mad. We told you that because it is essential for you to understand that these bones were not scattered by Roy Kronk. They were scattered by animals and by acts of nature. Could I have 207, please, in evidence? Again, you can see from this photograph, a little bit closer up of where the skull is. This skull has not been moved for months. It is surrounded by the hair, which has fallen directly from the top of the head. You can see it all around, pretty much evenly distributed around the skull. This is where the skull has sat since the hair and the scalp decomposed and fell off. And it hasn't moved since, at least not much. Could I have the duct tape? The duct tape is partially covered by leaf litter along the sides. Remember, when you see the next photograph, you'll see this. The duct tape actually goes around the jaw and the skull. This has been here so long that the leaf litter has actually covered parts of the duct tape. Could I have 218, please? In this photograph, you can clearly see that the duct tape wraps around the mandible. It didn't just get washed there by water. It's there because that's where Casey Anthony put it. It's there. The jaw is in place because the tape is there. Could I have 220? You can see in this photograph where the tape has now been lifted away from the skull, from the mandible, excuse me, that there are strings from the tape that actually go under the mandible. It's not a coincidence. It's not an accident. It's not water. That's because the tape was placed over her mouth and her nose before she decomposed. You take it off there. The scene was not staged. It appears as it does because of the forces of nature. The forces of water, the forces of animal, and the forces of decomposition. And any suggestion to the contrary, I would submit to you, is conclusively refuted by the evidence in these photographs. All these photographs you will have in the jury room with you. They're in a notebook. They're separated by sort of subject matter, so you can go right to them, look at them, take as much time as you like to look at them. And when you've done that, you're going to see that this crime scene was not staged. It was not moved. That duct tape has been on Kaylee's face since the day that she died, just as the state's experts told you. The state did not call Roy Kronk in this case because Roy Kronk's testimony about what he did on December the 11th, 2008 is embellished. Roy likes to spin a good yarn. But what Roy said he did on December the 11th is impossible. We didn't put Roy Kronk on to tell you a story that the evidence indicates just isn't true. And I would also submit to you that Roy's claim that he just happened upon that scene for the second time is equally uncredible. That doesn't mean that he staged the scene, that he stole it, all that stuff. What it means is that Roy likes to spin a good yarn. I submit to you based on the evidence what occurred in this case is that Roy found the skull, as we know he did, back in August. He tried to report it 3 times, and he got blown off and said, to heck with it. I'm over this. Maybe it really wasn't. But then he starts communicating with his son. He starts telling his son, hey, I know where the skull is. And his son is impressed. He's trying to get this relationship back with his son. Wow, wouldn't it be great to impress my son? So he goes back to the scene, and it's still there. And Roy becomes a hero. And Roy tells a very, very dramatic story about lifting up a bag and the skull rolling out, and it's dramatic, and it's wonderful, and it's fun, but it isn't true. Roy found the skull all right, absolutely, but not the way he said. It's just impossible. But that doesn't make Roy Kronk a morally bankrupt individual who would take a little girl's skull home and play with it. The judge is going to give you some legal instructions, and I want to talk about a few of them, the most important ones. The judge is going to instruct you on the main charge here, which is murder in the first degree. There are 2 ways to commit murder in the first degree. One is called premeditated murder, and the other is called felony murder. Now, we get up here and we argue to you what scenario we believe the evidence supports. And in this case, we told you that we believe the evidence in this case supports the scenario that Casey Anthony chloroformed Kaylee so that she would not suffer, placed duct tape over her nose and mouth to end her life, and then disposed of her body. But you can come up with whatever scenario you want. I mean, it's up to you to put these facts together and decide in your own mind what you think happened. And that's important in this circumstance. There are 2 ways to commit murder in the first degree. The important thing is for you to know the following. During your deliberations, in order to find the defendant guilty of murder in the first degree, the state must convince you beyond a reasonable doubt of the defendant's guilt of either premeditated murder or felony murder.
Your Honor, I want to object to this statement of the law.
I'm reading directly from the evidence. Either premeditated murder or felony murder. While you must all agree that the state has proven first-degree murder beyond a reasonable doubt, you need not be unanimous in your opinion as to whether that finding is based on premeditated murder or felony murder. In other words, what that means is that as you each individually assess these facts, you don't have to necessarily agree on whether it's premeditation or felony murder. You can think it's both. Some can think it's one, some can think it's another. The important thing is that you all agree that it is first-degree murder in some form. Premeditated first-degree murder is a fairly simple concept. It just indicates the 3 elements are that Kaylee is dead, the death was caused by the criminal act of Casey Marie Anthony, and that there was a premeditated killing of Kaylee Marie Anthony. Killing is defined as killing is a killing after consciously deciding to do so, and there is a more full description the judge will give you. Our position is that the facts in this case show beyond a reasonable doubt that this was a premeditated murder of a young child. But we know that you can reconstruct these events in any way you want. So you also need to know what felony murder is. Felony murder has 3 elements. The first is the same, that is that Kaylee is dead. The second is the death occurred as a consequence of and while Casey Marie Anthony was engaged in the commission of aggravated child abuse. Or she died while Casey was attempting to commit aggravated child abuse, and that Casey is the person who killed Kaylee. Now, aggravated child abuse is defined by 2 elements. The first is that the defendant knowingly or willfully committed an act of child abuse upon Kaylee, and in so doing caused great bodily harm, permanent disability, or permanent disfigurement, and that Kaylee was under 18, which there's no question that she was. Child abuse is defined as the intentional infliction of physical or mental injury upon a child, or an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of another person to do that. The reason that we talk about this is you can postulate a number of different
Under Brooks.
a number of different hypotheses in this case. Some might say, well, maybe Casey put the duct tape on Kaylee to keep her quiet. Maybe she was being loud. Maybe she put it on to keep her quiet and put it on too tight, and Kaylee died by accident. I would submit not really consistent with what we have here, but someone could think that. The reason I bring this out is because if that is what you think happened, that is felony murder, as the court will define it for you. That's felony murder, because it is the intentional act that could reasonably be expected to result in physical or mental injury to the child. So if that's something that you're thinking about, just want you to know that's also first-degree murder.
The law, Your Honor.
Overruled.
Or if you choose to believe that she used the chloroform to sedate Kaylee so that she could spend time with her boyfriend, as bizarre as that seems, but let's say that she used the chloroform in the trunk of the car to sedate Kaylee so she could go have a good time with Tony on the 16th, and that Kaylee accidentally died. It's still first-degree murder because that act is aggravated child abuse, and if she dies in the consequence and the result, it's first-degree murder. So regardless of how you put these facts together, and again, I submit to you that the one that makes the most sense is if it's premeditated, because it is. But any way you slice it, any way you put it together, Casey Anthony is guilty of murder in the first degree in this case. I want to talk a little bit about George. You have seen hours of videotapes of conversations between George Anthony, sometimes with Cindy and Casey, and sometimes just with Casey. Those give you a window into this relationship between them, an unguarded, unvarnished window into the relationship between these three people. Is there anything in any of those conversations that shows George Anthony as anything other than a loving father and a loving grandfather who is out of his mind with worry over Kaylee and perplexed as to why his daughter won't tell them something? Throughout all of these conversations, he is supportive, he is helpful to Casey, he's loving to her. She even says to him on more than one occasion, when he expresses some guilt about not having been a better father, she says to him over and over again, "You were the best dad, you were a great dad, you were a great grandfather." There's nothing in any of those tapes that would suggest in any way that he's setting her up in some bizarre fashion. Most of her more frictional relationship is with her mother. Most of the arguments to the extent they occur are with her mother, not with her father. You know, George is, remember the thumb? George is the thumb, we're the five fingers and George is the thumb. It's almost a little silly in a way, but George is not this Machiavellian, self-interested monster that counsel has suggested. The last time George Anthony testified, Mr. Baez brought up the suicide. You recall that he asked Mr. Anthony, didn't you attempt to commit suicide? Mr. Anthony said that he did. Mr. Baez asked him, well, didn't you express some guilt in the suicide letter? That's, of course, before you actually would have had a chance to see it. Now, of course, Mr. Baez seems to be telling you that it wasn't really a suicide attempt. It was just a couple of beers and some blood pressure medication. That's not what George Anthony said. George Anthony said he took blood pressure medication and medication he was given for anxiety by a psychiatrist. He took everything he could find because on January 22nd of 2009, he wanted to die. He wanted to be with Kaylee. That's all he wanted. He was tired of all of it. He was tired of the questions. He was tired of not knowing. He just wanted to be with his granddaughter. And you cannot read this letter and not see that this man was in pain. You can even see the effects of the drugs and alcohol as his handwriting deteriorates through this letter. This is not some self-serving, deliberately created manifesto of innocence. This is the cry of a man who just doesn't understand the world anymore. He doesn't understand what happened to his granddaughter. He doesn't understand why his daughter won't tell him. He just doesn't understand, and he's just tired. Kaylee Marie, I miss her. I miss her. I want my family back. I sit here falling apart because I should have done more. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. What happened? Why could she not come to us, especially you? Why not Lee? Who was involved with this stuff for Kaylee? Before that, he says, I blame myself for her being gone. You know, for months, as a matter of fact, for a year or so, I brought up stuff only to be told not to be negative. To denigrate that pain by suggesting that that is an insincere, selfish, self-serving statement, I believe belies the facts. I'm going to sit down now, and Ms. Drain-Burdick will address some other areas in the case. I just want to end by thanking you for all of your sacrifices and all of your time, and to wish you well in the decision that you're about to make. Thank you.
Okay, ladies and gentlemen of the jury, we'll take a 15-minute one, special. Defense?
Yes, sir, we do.
Rebuttal?
Good morning, ladies and gentlemen. When Judge Perry took that break for 15 or 20 minutes, I kind of felt like that guy that gets called out onto the field to kick a last-minute field goal once his teammate has taken the ball down to the 1-yard line. And of course, I'm ready to go, and the other team calls timeout. So there are some advantages and disadvantages, I suppose, to being the last person to have a say on this subject. The advantage, of course, is the obvious one, that nobody gets to say anything after I sit down except for the judge on the law. The disadvantage, of course, is that you've been sitting here listening to attorneys tell you what they think the evidence shows for 5, 6, maybe even 7 hours. to this point. And I recognize that you all are ready to begin the job that you have been here doing for almost 2 months. On May 9th, we packed our bags and spent 2 weeks in Clearwater. You have made a greater sacrifice in packing your bags and spending weeks here. And as everyone else before me has indicated, I thank you as well. But I ask that you do indulge me for a few moments to get our final thoughts on the issues that have been presented in this case. I promise that I won't be dragging out evidence or posters or pyrotechnics. If anything, that's not my style. When I came up here in May and stood in front of you for probably a little over 2 hours and told you what the evidence in this case would show, I meant what I said. I didn't make promises to you that the state didn't keep. I meant what I said. And through the testimony of dozens of witnesses, hundreds of exhibits, the state of Florida in this case has proven every element of every charge in this indictment against Casey Marie Anthony. Mr. Baez, defense counsel, started his closing argument explaining what his biggest fear was in this case, and that it was that you would be making decisions based on emotion. I would never ask you to do that. Co-counsel has not asked you to do that. The judge will instruct you that you cannot do that. And although this case is certainly emotionally charged, we won't ask you to make decisions about the facts of this case based on anything but the testimony that you have heard from the witnesses and all of the exhibits that you will be able to consider once you begin the job of deliberating this case. Want to know what my biggest fear is? My biggest fear, and I do not, under any circumstances, mean this as an insult. My biggest fear is that common sense will be lost in all the rhetoric of the case. That you won't step back and take a look at the evidence as a whole. You gotta look at the big picture here. Co-counsel, in his opening argument to you yesterday, talked about rabbit holes. And after he sat down,
Sustain.
my fear is that you won't look at the big picture. We spent 2 weeks in Clearwater questioning all of you, looking for people who would still be able to see the forest for the trees.
Overrule at this point.
In his closing remarks, Mr. Baez used words like liar, perjurer, fraudulent. A trial in a criminal case is supposed to be a search for the truth. The truth is what is the cornerstone of the criminal justice process, both for those who are accused and those who are the victims of crime. It is lying that perverts that process. So during an argument where the most well-documented liar ever seen in a courtroom accuses everybody of perjury, of fraud, of lying, the irony is rich indeed.
Your Honor, violation of paragraph number 5 of this court's order, and move to strike.
Overrule.
As we have come to find out, accusing others of lying is classic Casey Anthony. When Casey Anthony wants to divert attention away from herself, she accuses others.
Overrule at this point.
As we have heard from the evidence, Ms. Anthony has spent years lying, has spent 31 days. Mr. Baez, in his argument to you, suggested those 31 days mean nothing. A lie told convincingly is still a lie. The defendant, through counsel, has accused Yuri Melich,
Overrule at this point.
Jason Forgy, Gerardo Beloisi, Dr. Voss, many of the witnesses that have come forward in this case of being liars. In his statement, he indicated that the Orange County Sheriff's Office is desperate, or was desperate in this case. And if there was anything that the individuals working for the Orange County Sheriff were, it was desperate to find a little girl. In July of 2008, whether or not she was alive or dead, the men and women of the Orange County Sheriff's Office labored for hours in an effort to find her. They were joined by the FBI, with law enforcement agencies all over the country, the Florida Department of Law Enforcement, Texas EquiSearch, citizens, people who had no other motive than to find Kaylee Marie Anthony. But it was a lie. It was all in vain. Even the defendant's parents and her brother were searching in vain. You know, false allegations of child abduction are nothing new. And invariably, as in this case, it turns out that the perpetrator is a family member. The allegation of a false abduction diverts resources away from the perpetrator, diverts attention away from the perpetrator,
Your Honor, improper argument.
buys the perpetrator more time. And you will remember, one of the things that Casey Anthony said to her mother when she picked her up from her boyfriend Tony's apartment was that she just wanted another day. She wanted more time. She was trying to buy time. When she told her brother about the kidnapping, she was trying to buy time. Time to concoct another lie, another story, and to divert attention away from herself. In his argument, counsel put up pictures of all of the law enforcement officers who were at the Anthony home that night, suggesting there was no smell in the car because they took no action. That first night, July 15th of 2008, the police did not think Kaylee Anthony was dead. At that point, they had no reason to believe Kaylee Anthony was dead. There was no reason to connect any smell in the car to Kaylee Anthony being dead. The defendant was telling them she was alive, that she was somewhere else. She was asking for their help in finding her. So much so that this episode that Mr. Mason talked about of Ms. Anthony being handcuffed was ended like that, because the members of the Orange County Sheriff's Office were there to help. They weren't there threatening her to give a statement. They were there to help. The next day at Universal Studios, there were 3 long-term detectives who were there to help. If you listen to Ms. Anthony's statement again, they say to her, you have 3 detectives here who want to help you, who will expend the resources to find your daughter. Why are you lying to us? These aren't involuntary statements, as would be suggested, that you should just throw out. These are statements suggestive of a consciousness of guilt on Ms. Anthony's part. She was buying time, like she had done with her parents, her brother, her friends. The 31 days are really meaningless. Did I hear that? Did I hear a version of that? Counsel suggested that the detailing of what Ms. Anthony was doing during these 31 days had more to do with the state trying to prove that she was a slut. Did I hear that? Nothing could be further from the truth. Initially, the Orange County Sheriff's Office, in an effort to help her, was trying to backtrack and find out where she was and what she had been doing, because she told them she was conducting her own investigation. Really? They were using her cell phone records to try to track down this Zenaida, to find Kaylee Marie Anthony, to help the defendant. But as they backtracked, as you found out, it had become and did become more and more apparent that the defendant was lying about everything. If you go back and look at her 4-page written statement, the only true statement on there is that Kaylee Marie Anthony was born on August 9th, 2005. That's it. Every other statement on that form is a lie. You've heard during this trial, and it's been suggested to you in closing by the defense, that everybody grieves differently. Well, that may certainly be true. Everybody grieves differently. Responses to grief are as varied as the day is long, but responses to guilt are oh so predictable. What do guilty people do? They lie. They avoid. They run. They mislead. Not just their family, but the police. They divert attention away from themselves, and they act like nothing is wrong. That's why you heard about what happened those 31 days. Not to try to convince you to hate Casey Anthony, but to show you that what she was doing during those 31 days was in no way indicative of grief, was in no way the response to someone whose child has died by accident. Counsel said, well, she could have hopped on a plane and left the jurisdiction. The classic signs of running away. Ms. Anthony did not have options. In those jail videotapes, you will hear, you did hear, and if you listen to them again, we'll hear her say this was a time of desperation for her. And her father was like, what? Desperation? What are you talking about, desperation? She had no option to go anywhere except away from her family. That's who she ran from, because those are the people who would be asking her all the questions. The friends are easy to placate. They're not really paying attention to her life. If she's telling them, my mom's crazy, or my parents are getting a divorce, or my dad had a heart attack.
Sustained.
She was running from her family during those days. The people who would want to know, more than just as a passing reference, where's Kaylee?
Objection. Court sustained my objection, and counsel's continuing on that argument.
Argument is changed. Continue.
The defendant's actions and responses during those 31 days answer for you the only real question left at this stage of the proceedings. And that is, who killed Kaylee Anthony? The question is no longer, where is Kaylee? You will remember in my opening statement, I asked over and over again, where is Kaylee Marie Anthony? We know where Kaylee Marie Anthony is.
Non-rebuttal.
Overruled.
The question is no longer, what happened to Kaylee Marie Anthony? We know what happened to Kaylee. The question is, who killed Kaylee? For the longest time, Kaylee was alive. Nobody killed Kaylee. Kaylee is alive. Until her remains are found. As I told you, as I warned you about in opening statement, as the facts and circumstances changed over the course of time, the defendant's lies changed. They got bigger. They got better. They involved more people. Mr. Baez, in his closing statement, would have you believe that there must be something wrong with Casey Anthony because she has, quote unquote, imaginary friends. Those weren't imaginary friends. Those were lies. Every one of them was a lie. Ask yourselves, a lie designed to do what? A lie designed for a specific purpose. To get Casey out of a jam. So for the longest time, Kaylee is alive. Until her remains are found. And then, of course, the lie can't be, Kaylee is with the nanny. She's alive. She's been kidnapped. I had nothing to do with it.
May we approach?
No.
The lie must change. I told you in opening statement that it would. So now the theory is that there was some sort of accident. Well, you know from the evidence in this case that Kaylee Anthony's death was no accident. First off, the Orange County Sheriff's Office proposed to Casey Anthony on July 16th of 2008, maybe your baby died by accident. Can you give that second, please?
I had to sit down with mothers who rolled over their babies accidentally. I've had to sit down with mothers whose kids have drowned in swimming pools. I've had to sit down with mothers who had boyfriends who beat their kids to death, who felt horrible about what happened, and I've had to go to them and help them try to explain to their families, okay? And then I've also had to deal with people who have done horrible, unspeakable things to children, and then lied about it, and lied about it, and lied about it, okay? And I'll bet you somewhere in there I probably dealt with somebody who maybe made a mistake, but continued to lie about it. Maybe they weren't such a bad person, but maybe the whole world didn't see it that way. Maybe their family didn't see it that way because they kept lying about it. And then when finally, and months down the road, or days down the road, when they finally decided to come forward, okay? People pass it. He told me that you lied to me for the last time. I don't listen to what you have to say. Don't talk anymore, okay?
In his closing statement to you, counsel suggested that the Orange County Sheriff's Office had murder on their minds, that they didn't want to consider that this was an accident. You heard right there. Was this an accident, basically? I've dealt with tons and tons and tons and tons of people. I've seen it all. Was this an accident? No, Kaylee is alive. The defendant's mother suggested the whole accident scenario involving the pool specifically on August 16th of 2008.
Someone just said that Kaylee was dead this morning, that she drowned in the pool. That's the newest story out there. Surprise, surprise.
So when Kaylee Anthony is found dead on December 11th of 2008, surprise, surprise, it's an accident. No person would ever make the accidental death of a child look like murder. The defendant's actions during those 31 days and her response to this are completely inconsistent with what people do 100% of the time. You heard Dr. Garavaglia say 100% of the time when a child is involved in an accident, somebody tries to save them. They want them to live. They call 911. They anguish over the death of a child, especially if you want to accept this testimony that Miss Anthony was an amazing mother. Who did you hear that from? How was that defined? Her friends? People who don't have kids, that have other lives, that have seen 2 seconds of interaction? The questions in support of, what did you think about Casey Anthony's relationship with her child, were things like, did Kaylee run to her mother? Of course she did. Every baby loves their mother. They have every reason to. Their love is unconditional. Of course she's going to run to her mother, just like she ran to her grandparents. Well, Casey provided food and shelter and clothes for Kaylee. That makes her a great mother. No, that makes her a mother. Maybe an adequate mother. But in reality, the food, the clothes, the shelter were provided by her grandparents. That's why Kaylee was healthy and happy and well-fed and well taken care of and nicely dressed. Look at her room. Look at their backyard. What amazing parent acts with complete indifference to the accidental death of their child? You heard from the defense-owned expert an example of an amazing parent, a woman whose child died, and she wanted to go to the child's gravesite because that child had never been in a storm in the dark alone. That's an amazing mother. A mother who tried to protect her child, even in death. If this truly was an accident in the pool, Kaylee Anthony would have been found floating in the pool, not floating in a swamp down the street. If this was an accident that George Anthony knew about, he told you, we wouldn't be here today. I wouldn't be here. They wouldn't be here. She wouldn't be here. You wouldn't be here.
Overruled.
If he was home, as they suggested, when there was an accident in the pool, he would have called 911. He would have tried CPR. He would never have scooped up his granddaughter and put her in a bag and threw her in the woods. Never. No paternal instinct. Did we watch the same jail videos? Mr. Ashton has covered this, but did we watch the same videos? Mr. Anthony said he would trade places with his daughter in a second.
Argued by Mr. Ashton.
Sustained.
This argument cannot be followed to any logical conclusion. The way these remains were disposed of shows complete indifference to the child. It speaks volumes about how the person who disposed of her really felt about her. Can we look at the picture of the playhouse, please? This is how George and Cindy Anthony felt about their granddaughter. They built her playhouse in the backyard. George Anthony landscaped it for her. Put a little mailbox out there for her with her name on it. Put a stone base. Put a stone base under that playhouse so that Kaylee wouldn't have to sit on the ground in case it was wet. So that Kaylee wouldn't have to sit on the ground where an insect could crawl on her. On those jail videos, you heard Mr. Anthony over and over again trying to get Casey to talk to law enforcement, to the sheriff's office, to the Federal Bureau of Investigation. If he was so diabolical that he was trying to cover up something, why would he want his co-conspirator to talk to the cops? That makes no sense. I'm trying to engage in a cover-up, but I want you to talk to the cops. Not only does the disposal of those remains speak volumes about how Casey Anthony felt about Kaylee, the phone call that she made to her parents the night that she was arrested, July 16th of 2008.
On rebuttal. It's the second closing argument.
Overruled.
Hello? Hello, this is a free call from Casey. an inmate from the Orange County Correctional Center. For a rate quote, press 7. To accept this free call, press 0. To obtain a customer, this call is subject to monitoring and recording. Thank you for using Global Tel Link.
Casey?
Mom.
Hey, sweetie.
Oh, I just saw your nice little cameo on TV.
Which one?
What do you mean, which one?
Which one? I did 4 different ones, and I don't know. I haven't seen them all. I've only seen 1 or 2 so far.
You don't know what my involvement is and stuff?
Casey.
Mom.
What?
No.
I don't know what your involvement is, sweetheart. You're not telling me where she's at.
Because I don't fucking know where she's at. Are you kidding me?
Casey, don't waste your call.
No.
Scream and holler at me.
Waste my call sitting in, the jail?
Whose fault
where
is
bunks are?
Whose fault is you're sitting in the jail? You're blaming me that you're sitting in the jail?
Not
Blame
my
yourself for
fault.
telling lies. You mean it's not your fault? What do you mean it's not your fault, sweetheart? If you'd have told them the truth and not lied about everything, they wouldn't.
Do me a favor, just tell me what Tony's number is. I don't want to talk to you right now. Forget it.
I don't have his number.
We'll get it from Lee because I know Lee's at the house. I saw Mallory's car was out front. It was just on the news. They were just live outside the house.
I know they were.
Well,
Well,
can you get Tony's number for me so I can call him?
Hey,
Hey, can you give me Tony's number?
I can do that. I don't know what real good it's going to do at this point.
Well, I'd like to talk to him anyway.
Okay.
Because I called to talk to my mother, and it's a fucking waste. Oh, by the way, I don't want any of you coming up here when I have my first hearing for bond and everything else. Like, don't even fucking waste your time coming up here.
You know, you're making it real tough for anybody to want to try to, even if issue with giving you somebody's phone number. You're not even letting me finish. Like, I really,
That's good.
you're asking me for Tony's phone number so you can call him, and then you immediately want to start pressing towards me and saying, don't even worry about coming up here for all this stuff and trying to cut us out.
I'm not trying to cut anybody out.
I'm not going around and around with you. You know, that's pretty pointless. I'm not going to go through, not going to put everybody else through the same stuff that you've been putting the police and everybody else through for the last 24 hours and the stuff you've been putting mom through for the last 4 or 5 weeks. I'm done with that. So you can tell me what's going on. Christina would love to talk to you because she thinks that you will tell her what's going on. Frankly, we're going to find out. Something, whatever's going on, is going to be found out. So why not do it now? Save
There's
yourself
nothing to find out. There's absolutely nothing to find out. Not even what I told the detective.
Well, you know, everything
I have
she's
no
telling
clue
them
where
is a
Kaylee.
lie.
If I knew where Kaylee was, do you think any of this would be happening? No.
Anyway, you only got a couple minutes for this, so I'm not going to let you completely waste it. Here's Christina. She can get this.
No, I want Tony's number. I'm not talking to anybody else.
hello.
Hi, I'm glad everybody's at my house. I'll have to call you later. I'll have to call somebody to get your number. Do me a favor, get my brother back because I need Tony's number.
Okay, is there anything I can do for you?
I'm sitting in jail. There's nothing anybody can do right now.
Well, I'm just trying to do.
Oh, I know you are, honey. I absolutely know that you are, and I appreciate everything that you're trying to do, but I'd like to call Tony. He's not at my house, is he?
No, it's just me and your parents and Lee.
Okay, well, can you do me a favor and get my brother back or get the number from him, please?
Does Tony have anything to do with Kaylee?
No. Nothing.
Okay, so why do you want to talk to Tony? You probably don't want to tell me, do you?
Huh?
You probably don't want to tell me, do you?
Wait, I didn't hear what you said.
I said, does Tony have anything to do with Kaylee?
No, Tony has nothing to do with Kaylee.
Oh, so why do you want to talk to him? You probably don't want to tell me.
Because he's my boyfriend, and I won't actually try to sit and talk to him because I didn't get a chance to talk to him earlier because I got arrested on a fucking whim today because they're blaming me for stuff that I never would do, that I didn't do.
Okay. Well, I'm on your side. You know that,
Oh,
right?
actually, I know that. I just want to talk to Tony and get a little bit of...
Casey, you have to tell me if you know anything about Kaylee.
Sweetheart,
If anything happens to Kaylee, Casey, I'll die. You understand? I'll die. If anything happens to that baby.
Oh my God, calling you guys? A waste. Huge waste. Honey, I love you. You know I would not let anything happen to my daughter. If I knew where she was, this wouldn't be going on.
So how come everybody's saying you're lying?
Because nobody's fucking listening to anything that I'm saying. The media completely misconstrued everything that I said. The fucking detectives told them fucking bullshit. They got all of their information from me, yet at the same time, they're twisting stuff. They've already said they're going to pin this on me if they don't find Kaylee. They've already said that.
Well,
they arrested me because they said that...
Yeah, because they said that the person that you dropped Kaylee with doesn't even exist.
Because, oh, look, they can't find her in the Florida database. She's not just from Florida. If they would actually listen to anything that I would have said to them, they would have had their leads. They maybe could have tracked her down. They haven't listened to a fucking thing that I've said.
Do you know that whoever has Kaylee, nobody's going to get away with this? Nobody.
I know nobody's going to get away with it, but at the same time, the only way they're going to find Kaylee is if they actually listen to what I'm saying, and I'm trying to help them, and they're not letting me help them.
So how can I help them find her? The best thing you can do, baby, listen.
They need to look up her information in a New York database, in a North Carolina database, other places that she's lived outside of Florida. That's what I told them even again today. I told them that 4 times today. I said up at the police station, up at the county police station.
But she's the one who has Kaylee, or she transferred Kaylee to somebody else? Because
honey, I haven't talked to her. I don't know. I haven't talked to her.
How can everybody saying that you're not upset, that you're not crying, that you show no caring of where Kaylee is?
I'm not sitting here fucking crying every 2 seconds because I have to stay composed to talk to detectives, to make other phone calls, to do other things. I can't sit here and be crying every 2 seconds like I want to. I can't.
Okay, Casey, don't yell at me. I'm on your side. I'm on your side. Trust me.
I know you're on my side. I'm not trying
Nobody
to
is saying anything bad about you. Your family is with you 100%.
No, they're not. It's bullshit because I just watched the fucking news and heard everything that my mom said. Nobody in my own family is on my side.
Yes, they are. Nobody has said.
They just want Kaylee back. That's all they're worried about right now, is getting Kaylee back. And you know what? That's all I care about right now.
Casey, your daughter, your flesh and blood, your baby girl.
Christina, please, put my brother back on the phone. I don't want to get into this with you right now. I love you, honey, and I'm glad that you're there. Thank you for your help. I will let you know if there's anything you can do.
You can't tell me anybody that can find Kaylee. Nobody.
No, because every number that I've tried, every number that I called is disconnected. Nothing. I can't get a hold of anybody.
But that girl was the last person to have her?
She was the last person to have her. That was the last time I saw Kaylee. Okay. He doesn't. Lee said he doesn't have Tony's phone number. Yes, he does. He has Tony's phone number in his phone. He needs to stop fucking lying. He just told me a second ago that he'd give me the number. So if I go and I get you Tony's number, are you gonna finish talking to me? I will call you tomorrow. I want to talk to him really quick now. I know we're actually trying to close night. I haven't slept in 4 days. I have not slept in 4 days. Listen, if you're gonna talk to anybody, you can talk to me, and you know that. I can talk to you, but at the same time, I know I can talk to Tony, and that's who I want to talk to right now. I haven't gotten a chance to talk to him since this morning.
When you use your common sense, you can listen and hear that there's nothing that's wrong with Casey Anthony that can't be explained using 2 words: pathological liar. She's not grieving the accidental death of her daughter. Her focus in that call was where it had been for that day and the 31 days preceding it, and that is with Tony Lazzaro. That's all she wanted to do when she called her parents, aside from cuss them out. I want Tony's number. You have learned during the course of this trial that Casey Anthony is the only person who had access to every single piece of evidence discussed by Mr. Ashton today and yesterday. The duct tape, the laundry bag, the blanket, the shorts, the car. There's no evidence that anyone other than Casey Anthony was driving around in that car that began to smell to the point where she is texting her friend, Amy Huizenga, "I think my dad has run over a dead animal." She texted that to Amy Huizenga about 15 minutes before her boyfriend, Tony, picked her up at the Amscot. So you would think if your car smells like there's a dead animal plastered to the frame of it, maybe you check the trunk. Maybe you see if there's a garbage bag or a trash bag in the trunk. That trash bag was placed there as a decoy. You heard testimony from Catherine Sanchez that that car was backed into that spot by the dumpster. Why the dumpster? Guess why the dumpster? Because in addition to the bag of trash, the dumpster was a decoy to keep people either away from the car or thinking that was the source of the odor. The Anthonys didn't have access to that car. George Anthony didn't know where that car was. Miss Anthony was on the way to the boyfriend that her parents didn't even know existed. How would they know where to find her car? She told her mother she was in Tampa or Jacksonville or somewhere. They didn't know where she was or where the car was. And finally, the shirt. Big trouble comes in small packages. Indeed. Cindy Anthony told you that shirt was not one that she was familiar with. She did the laundry. That shirt was not kept at the Anthony house on Hope Spring Drive. That shirt was kept in the car, in the diaper bag or a backpack, because we saw it on 2 different occasions at Ricardo Morales' apartment in January of 2008, and then again in March. Someone in that house killed Kaylee Anthony. They want you to believe it was George who was involved in a cover-up of an accident that did not happen. Even George Anthony didn't have access to all of these things. Only Casey Anthony did. No one else tried to cover up and lie and lie and lie and lie, and I can go on a dozen or more times. Where were George and Cindy? Let's throw Cindy into the mix too as a possible perpetrator, because Casey Anthony would have you believe that this is all her mother's fault anyway for leaving the ladder down. Let's twist the knife in my mom a little more. The cover-up is her dad's fault. Let's twist the knife in him too. What were George and Cindy Anthony doing in June and July of 2008? They're living at home. They're going to work. And they're missing their granddaughter. What's Casey Anthony doing? Where is Casey Anthony? Well, she's not where she normally is, at home. She's at Tony's, because that's who saw her. She tells her mom she's in Tampa or Jacksonville or wherever. She's not where she's supposed to be. And where's Kaylee? Kaylee's dead in the woods. At the end of this case, all you really have to do is ask yourself a simple question. Whose life was better without Kaylee? Was Cindy Anthony's life better?
I called her to go. The deputy said last night. I found out my granddaughter has been taken. She has been missing for a month. Her mother finally admitted that she's been missing. Okay, what is the one here now? Okay, what is the address that you're calling from? 4937 Hope Spring Drive. We're talking about a 3-year-old little girl. 4937 what? Hope Spring, HOPESPRING, Drive, Orlando. Oh, my daughter finally admitted that the babysitter stole her. I need to find her. Your daughter admitted that the baby is where? But the babysitter took her a month ago that my daughter's been looking for. I told you my daughter was missing for a month. I just found her today, but I can't find my granddaughter. She just admitted to me that she's been trying to find her herself. There's something wrong. I found my daughter's car today, and it smells like there's been a dead body in the car. Okay, what is the 3-year-old's name?
Was George Anthony's life better? Mr. Ashton went over what George Anthony's life was like as a result of losing his beloved granddaughter. Whose life was better? That's the only question you need to answer in considering why Kaylee Marie Anthony was left on the side of the road, dead. There's your answer.
All right. Well, we all know what happened with the verdict. So that is going to be it. That was the entire trial, the closing arguments in the Casey Anthony trial. So congratulations. We've made it through the trial. And I want to gather some thoughts, go over some notes before I put out my reaction to the trial and the lawyering, et cetera, et cetera, et cetera. So thank you all for joining us for the Casey Anthony trial. I just want to remind everybody that at 5 o'clock, we are having a very special guest join us here. This is going to be the same attorney, Gail Sullivan, who wrote the opinion piece in the Massachusetts Lawyers Weekly on Kelsey Fitzsimmons. This is going to be at 5 o'clock. Okay. If you want to watch the verdict, we can play the verdict. All right, we'll just watch the verdict.
In the Circuit Court for the 9th Judicial Circuit in and for Orange County, Florida, State of Florida versus Casey Marie Anthony, as to case number 2008 CF 15606-0. As to the charge of first-degree murder, verdict as to count 1, we the jury find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, on this 5th day of July, 2011, signed foreperson. As to the charge of aggravated child abuse, verdict as to count 2, we the jury find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of aggravated manslaughter of a child, verdict as to count 3, we the jury find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 4. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 5. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 6. We, the jury, find the defendant not guilty. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict is to count 7. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson.
Madam Clerk, you may poll the jury.
Yes. Juror number 1.
Okay, now you got the verdict. Okay, I thought everybody knew the verdict already, so we'll just play the verdict. All right. Okay, so just remember, in about 45 minutes, we are going to be having a very special guest on. We're going to be talking about Kelsey Fitzsimmons, and perhaps we'll get into some other Massachusetts cases that are going on now. I'd like to ask her opinion about some of those also. So it's going to be very interesting. I never actually was able to get a Massachusetts lawyer to come and speak. Now that we do, we'll see how much they're willing to say. You know, because they're practicing. This is a woman who's practicing currently. She's an active in Massachusetts, and we'll see what she's willing to say. We'll see how much I can get out of her. You know, of course, I don't want to make her uncomfortable or make her say anything that she doesn't want to say, but it should be a very interesting conversation. So join us right back here at 5 o'clock, 45 minutes for that discussion with Gail Sullivan, a Massachusetts lawyer, and we're gonna have a good time, I think. Thank you very much for Poetic, by the way. Poetic Justice for the $20 before. Thank you again to Rita Schluler. And now thank you again to A. Obsidian for that super sticker. Appreciate you all joining us here for the Casey Anthony trial. We will see what we have on store next right here at Brother Counsel Studios. So we got today, and then for the rest of the week, very short week, and then next week, we'll keep you all posted. All right? We will see you in about 45 minutes. Take care.